selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat bama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya.
Good morning, ladies and gentlemen. I really expect that you could sit in the prepared place because our second day of the 5th ICCIS will begin in several minutes. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. May peace be upon us all. Welcome back to the second day of our conference, the 5th Indonesian Constitutional Court International Symposium, in the second day. We are pleased to welcome you back here in this room, and we also welcome all online participants that have been participating through Zoom meeting. Today, we will have 4 fruitful sessions that will be led by 3 chairs from many backgrounds. And the first sessions of today will be led by a lecturer from Brawijaya University, Mrs. Diana Puspitawari, PhD. For your informations, she is a very productive researcher and lecturer with a lot of research and also journal publication that you can access. Without further ado, I will invite the Honorable Mrs. Diana Puspitawari, PhD, to lead the first session. Mrs. Diana Puspitawari, the time is yours.
Thank you, Mary. It was such a nice introduction. Good morning, distinguished speakers and participants, and I hope you have a really Okay, I hope you all have a nice rest last night, and welcome back to this distinguished forum. Today, as same as yesterday, we have 3 speakers and 2 respondents. For the speaker, we give 20 minutes for each speaker, and then 10 minutes for 2 respondents. So it will be 5 minutes for each respondent, and then we've got 10 minutes for question and answer. On the first speaker, we have Professor Christy Warren from William and Mary Law School, the United States of America. Welcome to Indonesia, Professor Warren. And she will discuss with us about comparative constitutional review. Since we began a bit late, so without further ado, I will give the floor to Professor Warren. Professor Warren, the floor is yours.
Thank you very much. I would like to thank the conference organizers once again for inviting me to Indonesia and to see familiar faces and meet so many new esteemed colleagues whose research and writing I have followed over the years. It's a real privilege to be here. Mostly I would like to thank those of you who are in the room for arriving at 8 o'clock this morning after a very festive and long dinner last night. I really appreciate your attendance. I know exactly how difficult it was to wake up this morning. So my talk is going to be a little bit different than the other ones that we've heard so far, and maybe some of the ones that are coming, because instead of being down in the weeds in terms of focusing on small constitutional issues in a very precise way, which is of course what we all do, I want to take a step back and maybe go through the trees of what constitutional review is for, what it does, and how we can avoid some of the pitfalls that all of you have so well elucidated so far in the conference. We are a group of scholars, but next door we have constitutional court judges from around the world, and they are very clear about problems that they have in interpretation and application in constitutions that are ambiguous or that have conflicting provisions or in countries that are going through transition. So my work in the field, in addition to teaching, is in conflict and post-conflict constitution building. And so we are involved in providing advice to drafters. We don't do the drafting because that is a local, national endeavor that should remain that way, but I'm a comparatist, and we provide comparative options to people who are going through constitution drafting processes, and that's what I want to talk about a little bit. So I think my approach is going to be a little more pragmatic than some of the other ones that we've heard so far, and it's not because I think that you are necessarily going to be working in conflict or post-conflict zones yourself. You may or may not be. You may be living in one yourself, but you also may be undergoing constitutional reform in your own country. And the way that constitutional reform takes place and the resources that are available, I think, is very important, because we, not only as academics and practitioners, we tend to think within the box. We tend to refer back to our own history, back to our own practices, back to our own models, and stay in our lane when we are undergoing reform without really considering what the other options might be. This, can be a political issue. It's a political issue in my own country, in the United States, the role of international law, whether it can even be considered. Of course, it cannot be implemented, but it is a political issue in our country, because we have people who believe that the original text of the Constitution should limit future interpretations and current interpretations. And we have a number, not so much anymore, but we used to have a group of internationalists on the Supreme Court who said, look, what we're doing when we write opinions and refer to international law is not trying to implement the law of other countries. I'm not talking about international law here, I'm talking about the law of other countries, in our constitutional interpretation, but we are judges and we're problem solving. We're trying to deal with current and emerging issues. Why shouldn't we look at the way that judges in other countries have dealt with exactly the same issue, just to see maybe they have a different approach and it might be useful for us to consider. So I just start out by saying that that comparative constitutional law can be a political issue too, but I'm not going to engage with that. I'm going to, again, be very pragmatic about what the potential different options are. So I'm not good with technology, so I'm really kind of hoping and praying this works. So what I'm going to do is give an overview of what the different issues are that are decided when a constitution is either being created or updated or reformed. And one of the first issues that we deal with is the authority of a constitutional court or an apex court of any kind, the Supreme Court, to engage in review. And as you can see, the example here from Indonesia is that the authority is given in the Constitution itself. And you may think to yourself, well, that's what we say a no-brainer. Of course, the authority of an apex court to review is probably contained in the foundational document itself, but that is not always the case. You can see here in the United States, those of you who have studied U.S. constitutional law, that issue of judicial review was not addressed in our Constitution. It wasn't until the seminal case of Marbury versus Madison in 1803 that the Supreme Court ruled that it has ultimate authority to interpret the Constitution. So the Supreme Court gave itself that authority. At the time, that was a little controversial, but that was because it was not covered in the document itself. In India, which I'll talk about in a few more minutes, there is a type, I don't mean to be instructing here because I know you all know this better than I do. This is just kind of an overview of the issues to consider during constitution drafting or reform. So there is a grant of jurisdiction through the Supreme Court Rules of India for suo motu jurisdiction, which allows the Supreme Court of India itself to reach down and seize jurisdiction of various issues that are arising in the country without necessarily a direct petition being filed. And the Supreme Court of India has used this a number of times, including during COVID, to address issues that it considers socially important. You can see here that between 1990, when this right arose or was created, through 2021, the Supreme Court of India exercised its suo motu jurisdiction in 46 cases. So let's just briefly glance at the different types of review, because any of these can be included in a constitution ab initio when it's being created, or the types of review can be amended if you are going through a process of constitutional amendment. So there is abstract review, right? And this is more common in Europe than it is in, I will say, common law jurisdictions. So this is an opinion that can come out of an apex court without reference to a specific case. So it is an opinion that is given. The Venice Commission is very good at this particular method of review. And there is concrete review. And of course, in the United States, this is a requirement. A case or an issue, a legal issue, cannot be decided by the Supreme Court without being appended to a concrete case that has made its way through the hierarchy of the court system, and there has to be actual harm. So these are options. You may have your own impressions about which ones are better than others, but these are all choices that different countries have made. And so concrete review, again, pertains in the United States and Japan. Then there is the difference between hard review and soft review. Hard review gives courts the final say on constitutional questions. When the Constitutional Court or an apex court, a Supreme Court, rules, its rule becomes the law, and the law is binding, and there is no further appeal on that. And then there is soft review, which attempts to strike a balance between the judicial and legislative branches, to reduce any potential for conflict. One of the themes of this conference, of course, is conflict in peace and justice. So under soft review, the legislature is granted the ability to override or set aside what a court has done. So under soft review, the apex court does not have ultimate power to rule. And then there is an emerging model that's coming out of the Taiwanese Constitutional Court where constitutional amendments have been proposed or enacted, and apex courts are given the ability, the power to rule that constitutional amendments are themselves unconstitutional. So you can, probably see that some of these models are more complicated and potentially politically conflicted than other models. And the option here is, again, I'm not going to make any recommendations at the end of any one of these issues, but these are options that are on the table that can be utilized depending on what is going on in your particular jurisdiction. All right, so then just briefly, different types of constitutional review. There's decentralized review, of course, in the United States. It's also common in Pakistan, probably in most common law courts. And then the current trend is towards centralized review through constitutional courts. And that's a little bit about what we've been talking about in this conference. There are 95 countries in the world that now utilize constitutional courts, and these are the apex courts, either by themselves, or in conjunction with Supreme Courts that rule on the constitutionality of different legal issues. All right, so again, different types of review. There's interlocutory referral for constitutional review. In other words, while a case is going on, a legal issue can be referred to an apex court for review to get an answer about the constitutionality of a particular ruling or a piece of legislation that's being applied, and the case stops until the apex court rules. This is a model that's used in Germany and Italy. In Singapore, the president may refer something to an issue to a tribunal consisting of a number of justices to gain a ruling on the constitutionality. In the United States, there's a very, very infrequently used rule, Rule 19 of the Supreme Court rules, which allows lower courts, federal courts, to refer a constitutional issue to the Supreme Court in the middle of a case as a certified question. This is very, very rare. I'm not aware of any instance that it's been used recently. It's been only used 4 times in 63 years since this rule was enacted. Advisory opinions. I'm sure all of you are familiar with the Venice Commission, excellent organization that upon request issues opinions, advisory opinions, without ruling on the validity or non-validity of a national law. But they do exactly what we're talking about in this lecture. They provide an array of options that are used in different jurisdictions around the world. And these are advisory opinions by an external body. Scope of review. So these are some of the scopes of review that pertain under different different constitutions around the world. Of course, judicial review, conflicts in the interpretations of constitutions and constitutional law, conflicts between and among state organs. Now, you'll notice that under this list here, the scope of review, that the procedure, the processes are not mentioned here because the way that conflicts are resolved between different state organs varies among jurisdictions. Of course, in France, you have the Conseil d'État. You may have separate bodies that only rule on conflicts between state organs. There may be an entirely separate tranche of courts that that differentiate between judicial review of ordinary people's cases and conflicts and those among government organs. Protection of individual rights, and we're talking a lot about that during this conference and the conference next door, because protection of individual rights is considered to be one of the most fundamental roles of a constitution, right? But it's not always the apex courts that immediately have jurisdiction over protection of rights. And if you only have one apex court, there could very well be conflicts or balancing acts that need to take place when the protection of individual rights come into conflict with protection of collective rights or security issues, for example. But nevertheless, it is one of the areas of scope of review. Military issues, of course, are part of the scope of review in Indonesia. They are not necessarily, except in very rare cases, within the scope of review in the United States. So this is really a jurisdictional grant that varies among different countries. And again, I understand in Indonesia, this is an issue. Legal conflicts. So conflicts among rulings and laws that come out of different courts. And of course, the apex courts very often, although not always, have supremacy clauses holding that the rulings that they give are supreme, the supreme law of the land. And they hopefully, I think one lesson we've heard from this conference here and the conference next door is that absent supremacy clauses, there can be great confusion and gaps for political manipulation. Because if there's not a specific grant of supremacy that comes out of an apex court, different factions can argue that those rulings are not supreme and they can be taken to another court. Political conflicts. Again, that is a power that is granted here in Indonesia. The Constitutional Court has the power to dissolve political parties. That would never happen in a lot of other countries. In fact, it is one of the limiting doctrines in the United States Supreme Court that if there is a political case or controversy or issue, the Supreme Court is supposed to decline to get involved. Post-conflict constitutions, peace and reconciliation. So this is really something I could spend my entire 20 minutes talking about, but I won't. But yeah, I know I only have 4 minutes. And I'm going to finish on time. I will say that in the field of post-conflict reconstruction, constitutions are considered to be seminally important. They are considered a bridge between conflict and a new vision of peace held by the people in a country. The idea is that broad consultation should take place and that the vision of the new constitution should be forward-looking and not backward-looking in order to embed peace in a country. Scope of review, states of emergency. We heard an excellent presentation yesterday from our colleague, the Chief Justice of the Constitutional Court from Turkey, about problems that emerge during the states of emergency and I've covered the Constitution of Indonesia. So I just want to talk a little bit, because I only have a few more minutes, about access to constitutional review. I understand that that is an issue also that's being debated here in Indonesia. There are some systems that are very open so that individual citizens, people, I'll just put it that way, have access directly to the apex courts to complain about violations of human rights or other issues. In the less open systems, you either have to wend your way up through the hierarchy of lower courts and ultimately end up in the apex court, or you have to go through another sort of exhaustion of domestic remedies. And just think about this issue from the perspective of either a poor person or someone who can't afford a lawyer or someone who is not familiar with the law. The systems that are more open are more accessible to ordinary people, and the systems that are less open are not. I'll just leave it at that. And then we have a variety of options here about access to review, Bosnia and Herzegovina. Disputes can only arrive in apex courts if they are referred to one of the leading politicians in the country, or not majority, but a significant vote by the parliamentary branch. We have the United States. Access to constitutional review is a legal issue determined by rules of standing. In India, direct access to the Supreme Court is available for issues involving fundamental rights. And the most open systems that you can see here are the ones that are most available to ordinary people. And I would argue that they are less subject to political manipulation. And these are the systems that are most protective, I think, of human rights and individual rights. So there is a device that is common that emanated from Spain and is very common in Latin America called the Recurso de Amparo. It protects the ability of individual citizens to go directly to the apex courts to complain about violations of individual rights except for illegal detention. And the reason for that is that habeas corpus is also available, separate from the recurso de amparo, and that is considered to be more protective and more effective in dealing with illegal detentions. Although we have 17 constitutions around the world, you can see that they are largely in the Spanish-speaking communities that use the device of amparo. So lastly, I have 20 seconds left. I'm just going to show you these resources that are available that will help you do a comparative constitutional study if you go through a reform process in your own country, or you are advising in another country and you want to know how to put together a comparative study so that you can make comparisons available to the people you are advising and avoid the stigma of being an international advisor who goes around advising on your own model. This is very good. And lastly, I think I just got the gong. There is a compilation of constitutional case law so that you can interpret a lot of these rules that is provided on the Venice Commission website. Thank you very much.
Thank you very much, Professor, and you got the gong. Okay, now we come to the time of respondents. We have two respondents here. First is Mr. Dr. Jance Arizona from Universitas Gadjah Mada and Mr. Helmi Kasim from Constitutional Court of Justice. So our first respondent will be Dr. Jance for 5 minutes. Thank you.
Okay, thank you for your fascinating presentation about comparative constitutional review. This topic is very important, and it also reminds me about a study by Tom Ginsburg and Mila Verstes in 2014, citing the study from Constitutional Project showing that 83% of the state constitution in the world currently have adopted constitutional review. So there is a tendency to create a single model of constitutional review for world constitution in the world, at least by including by constitutionalizing constitutional review in the constitution, and this practice can happen because of the practice of constitutional borrowing among states that further homogenize all state constitution in the world. And I think that WCCG is an important forum that enables states to learn from one state to another state to use similar model to their own jurisdiction. In fact, that we know that the use of constitutional review varies greatly in practice, despite the strong tendency toward a single model and limited models. In her presentation, Professor Warren used a number of models to distinguish between hard, soft, and also abstract and concrete review. The adoption of these models depend on the context of specific countries. And another book by Tom Ginsburg as well tried to distinguish three waves of constitutionalizing constitutional review. The first is of course, the U.S. model after the Marbury and Madison case. That is the first wave, and the second wave is especially after the post-fascism and post-colonialisms, following the German and Italian models, more centralized. And the third wave is occur after post-communism and post-authoritarianism, including Indonesia, following this model. But by understanding the difference between the three waves, we must understand that the adoption of the constitutional review model is inseparable from the very specific context and objective and also moments. So I have a few questions to discuss further from Professor Warren's presentation. The first is how do we put the social and political context related to the design of constitutional review that vary from country to country? And how do you see the difference in performance from different constitutional review models? Whether the performance is strongly influenced by design, political context, or actors, meaning justice in the constitutional court. And I get impression that the Professor Warren also emphasized about the fit of constitutional review with democracy and the rule of law. This is a very positive notion about the constitutional review and the constitutional court. But how if we discuss comparative constitutional review in the lens of abusive judicial review as discussed by Rosalind Dixon and Landau 2021 about abusive constitutional borrowing? This standing comes from the understanding that the constitutional court is not always a problem solver, but it can be also a problem maker. And the last point is the question that often arises in the contemporary discussion about the constitutional court is, why is the court fail to prevent authoritarian government from consolidating power and resources on the one hand, and the other hand repressing and narrowing the civic spheres and government oversight institution. In the last 3 decades, the inception of the constitutional court is as a packet from safeguarding the democracy and the rule of law. Then how the constitutional court respond to the growing strains of authoritarianism and democratic regression in many countries, either in the global north, in the global south. Maybe we can also learn from the experience of the US, Indonesia, India, maybe also Turkey and Hungary in this forum. Thank you.
Thank you. Thank you, Dr. Yance. So we will collect the response and the question first, and then you can reply. Okay, our next respondent is Mr. Helmi Kasim. The time is yours.
Well, thank you very much, Bu Diana, our chair. Professor Warren, it is an honor to be here with you. This is the second time that we have met after the last visit to the Constitutional Court, and to engage in this conversation with all distinguished speakers, respondents, and participants who attended this conference online. Also, Papal is here with us. 2 terms, Constitutional Court Justice. Thank you very much. Instead of giving response or comments, I would like to use this opportunity to ask more questions to Professor Warren. I would like to raise some issues which might be of practical matters and which might be of concern for us with the Constitutional Court. Professor Warren have presented various aspects of a constitutional review in comparison, types, access, scope, including standing. Based on these various issues, I wonder what makes a strong court, Professor Warren, especially emerging countries like Indonesia and in relation to emerging phenomena of right creeps in emerging constitutions. And also in concerning types of reviews, Indonesia appears to be implementing a hard review. But in some cases, which is rare actually, when the Constitutional Court annuls a specific provision in law, the Parliament reinstates the annulled provision when amending the law. As a result, the applicant refiled the application to the Constitutional Court, and the Constitutional Court annulled again the provision once more. So it appears there's some kind of power struggle between the legislature and the Constitutional Court in this case. But it is still within their scope of authority, actually, the Parliament with the power to make laws and the Constitutional Court with the power to review the law. So from comparative perspective, how would you see this phenomenon? The second one, judicial review at the Constitutional Court, especially in the Republic of Indonesia, does not only review a specific provision in the law, but also the process of lawmaking. This recent case that drew public attention when the Constitutional Court ruled the process of drafting Job Creation Act violated the Constitution, the 1945 Constitution. This is the first time that the court has annulled a law based on defect in the process of formation. And right now, some members of parliament started to question the authority of the Constitutional Court to review the process of lawmaking because they say the Constitution does not specifically mention this authority. And the third, the court has always been in demand for having clear standards of review that makes its decision more predictable in issues of the same nature. If we look at the approach applied by the US Supreme Court, for example, like strict scrutiny, immediate, intermediate scrutiny, rational basis, or proportionality, if we see the approach applied by European court, especially the German, how would you see all these issues from comparative perspectives? I think that's all. Thank you very much.
Okay, thank you. Now it comes, we can applause for this session. So now we open questions, okay. One for this side and one from this side. And for the chairs who are not in duty for this session, you are welcome to raise a question also. Okay, first of all, I will give a chance to Mr. Andi Omara.
Thank you very much, Mrs. Chairwoman. Your presentation is very enlightening. Thank you very much for that. And I have two short questions. You mentioned about types of judicial review in many ways. And I wonder, how do you think about the strong and weak basic structure review that actually also become developing in many jurisdictions? That would be one question. And then the second question is about the unconstitutional constitutional amendment. I think how then we can relate the authority of the court and the sovereignty of the people that make the constitutions. That's my two questions. Thank you.
Okay, we will collect it. And Professor, I cannot see the...
That is okay. De Villiers. Professor Warren, thank you very much for an excellent paper. Perhaps just a question, and if you want a comment, and if you want to respond, that's good. But I wonder if there's a trend that emerging and young democracies are more likely to rely on judicial review as a result of the failures of their state. So the court, in a certain sense, is seen as the basket to help save the nation. And this you can often see in areas where politicians are discredited because of whatever reasons, where there's a low legitimacy of institutions, or where there's a one-party dominant democracy where minorities feel the only way they can have their voice heard is by way of litigation. And I wonder if this is a good place for the court to be at, because the court, in a certain sense, it's a high-risk area, because one is constantly, although in the United States you might say the court doesn't deal with political issues, one wonders what abortion is if it's not a political issue. And so, but the court then finds itself typically in that maelstrom of politics, as the Supreme Court often finds itself in the US, South Africa, everywhere. And some of the examples I can use is how in regard to social and economic rights, the courts in South Africa and India have been active. Recently, the court in the Philippines handed down a decision where government was ordered to clean a certain beach, whereas that may not have been the priorities of government because of budgetary constraints and so on. So the court is used basically to set policy priorities for government. My experience is, that's the last thing I say, is having lived in South Africa and Australia, is that issues in Australia which are likely to be resolved politically are resolved legally in South Africa. And that leads to a completely different political dynamic. And I'm not sure there's an answer to these things, it's just an observation I make.
Okay, thank you. Maybe one more question. Yes.
I can follow up on this very well. Professor, thank you for your presentation. I'm just wondering about your impressions about the future of constitutionalism, because next door there are constitutional court judges, as you said, and we can see a trend of some kind of exchange on the international level. Since 2009, it is institutionalized already. Do you think ever some kind of a world constitutional court can emerge? Because after post-authoritarian changes, advisors from different established democracies appear, which is obvious. And what else could happen? I experienced this in my country, in Hungary. Do you think this can be institutionalized? We see some symptoms of the rule of law and other important principles emerging. Do you think that an institutional framework can ever be made behind to this? Thank you.
Okay. Is there any more question? One more question, maybe? Yes.
Thank you. So thank you very much, Professor Warren, for such an interesting paper. I really enjoyed your presentation as well. So considering your experience, which is so rich, I was wondering if you could talk to us about the challenges that you've seen in your practice on constitutional change and democracies and post-conflict societies. So what are the main challenges that you've experienced? Thank you.
Okay, I think that's because the time is stopped, so I think we have more. Yes. No, not 10 minutes, but maybe 8, yes, 5 or 6, yes. Yes.
Okay, 5 or 6 minutes. Those are all big questions. So
Sorry,
I'm going to talk really fast, and if we have interpreters, you're all in trouble.
I think you've got 10 now.
Oh, okay.
because
10
the
minutes
time
before the
just
gong.
stopped.
Okay.
Yes.
So yeah, these are all big questions, and I don't have answers to a lot of them because I'm struggling with a lot of the same questions that all of you all are too. So to begin, how do we take social and political context into account in constitutional reform and constitution drafting? And how do we know what models worked and why they worked? And I think, you know, the bottom line of my presentation and to answer really your question is every single constitutional experience or movement is context specific. You absolutely, you know, once you study one process, you've studied one process and you learn what worked and it didn't work, but you do not replicate it. You know, what I advocate in my work is building a toolbox. You have a number of options, you have a number of things that have been tried, experiences, options. That's why I think being a comparatist is really helpful. And you take them and make that information available to people that are going through drafting processes or reform processes and saying, what do you think is going to work in your context? I'm not an expert in your system, but this is what I've seen in other environments. So I think consultation and delegating leadership to local actors is absolutely key. It's the answer. What we are is international advisors, really, and nothing more. There's a question about issues being resolved politically in one jurisdiction, and they are resolved in the constitutional courts. And our colleagues spoke specifically about South Africa. I think South Africa is a really specific case study because the Constitutional Court, of course, was created at the end of apartheid and as an institution, a tool to help heal society. Whether or not that has taken place, you know better than I do as well. But in places, you know, like Australia, the United States, where things may be resolved politically, we don't have transformative constitutional courts or transformative constitutions. I would argue that even the Constitution of India is supposedly a transformative constitution designed to abolish, you know, some of the scheduled caste issues and those sort of things. So I think it really depends on what the context is and was when the Constitution and the Constitutional Court were set up, because some are deliberately meant to be transformative and some exist in the context of longstanding political processes. And I have not studied the Constitution of Australia, so other than the indigenous rights issues that are being litigated there. So that's as much as I can comment on that. Yes, constitutional courts can be problem makers and not only problem solvers. Absolutely correct. And I think that really depends a lot on the composition of the court, how clear the allocations of jurisdiction are, whether the appointment of justices is politicized, or whether it's a meritocracy, what the oversight mechanisms are, what the disciplinary processes are, whether those functions are taken on by other branches of government, for example, the executive or the legislative branch, or whether there is oversight within the judicial branch itself, which I would argue is a cleaner model, assuming that there are codes of ethics and other ways to deal with that. But ultimately, of course, you know better than I that the goal is to not politicize the apex court, right? And to the extent that it is politicized either through oversight, appointment, or disciplinary proceedings, you're going to end up with trouble. Okay, I think clear standards of review. Okay, I think the topic of judicial activism was raised without those words maybe being actually used. The rulemaking power of a court and the division of responsibility separating from the legislative branch. And I think, again, that has a lot to do with the jurisdictional allocation of power in the courts. I think I'm not going to comment on Indonesia or any specific court, but I think problems arise in various contexts when there are gaps, when there are ambiguities, because political processes will fill those gaps. Politicians will take advantage of any gaps and ambiguities. So clear definitions are required. The clearer and more concise and fewer lacunae that exist in not only the Constitution, but for example, in Indonesia, there's a statute of the Constitutional Court, right? And it determines who has standing and what the grants of jurisdiction are. So it's not necessarily just the Constitution itself. The courts serving as a bastion in failing states or authoritarian regimes, I have no answer. I don't know what to say about that. I mean, we all follow what's going on in Hungary. We all follow what's going on in various authoritarian regimes, and I don't have any wisdom to offer, with respect to that. I just am not expert on the constraints that the courts there face. I do follow the popular media, and I have colleagues who work in Eastern Europe and even specifically in Hungary, but that's not my field of expertise, and I don't want to wade into water that is not mine. And so finally, the challenges in post-conflict constitutional processes, there are a number of challenges because you're dealing with a fractured society. You're dealing with a society that is broken. And you are trying to resolve some of the root causes of conflict through the Constitution. And that's why consultative processes are so important, in my opinion. Even when you get information that you don't necessarily expect or want to hear, the process itself can be more healing sometimes than the content. Because if people are heard, a lot of times that's what they want. They have not been heard. They have not been recognized. They have not been given a voice. I mean, you see this in Timor-Leste. You see this in a lot of societies where there were uprisings because people were just tired of not being recognized, right? And there are constitutional processes that are deliberately introduced as peace-building strategies in order to embrace people's different opinions and make them a part of the process. And so again, a lot of times people are willing to relinquish the purity of the position that they really in their heart of hearts want, because as long as they have an opportunity to participate and they get something out of it. There are, in terms of challenges, there are a lot of spoilers, that have to be dealt with, and that's always a challenge. And depending on the specific context, There are challenges that can be low capacity, especially if people have risen up and they haven't been able to participate in their own governments before the revolution, and then suddenly they're in charge of their own governments. So there are a number of challenges, but again, the idea of post-conflict constitution, the difference between, I would say, constitutional amendments in a stable society, and constitutional amendments are easier in some jurisdictions than others. In the United States, it's extremely difficult to amend our Constitution, and so we end up having activism in our Supreme Court because somebody has to interpret cases that have arisen since the original text was written, right? And you may not always like the answer, but somebody has to do it. Now I just lost my train of thought, so I'm just going to stop there. Thank you.
Okay, thank you so much, Professor Warren. But what I can conclude that we cannot just generalize constitutional review models based on legal system only, but we have to see on the context and the society that we are dealing with. So thank you so much. I know that online participants may have, and offline participants may still have questions, but still, since we are limited by time, maybe further discussion can be done outside the forum. Okay, thank you for this session. Give applause to our speakers. Thank you so much, Professor Warren. So for our next speaker, I would like to invite Professor Roy Andrew Bertain and our respondents. Unfortunately, Dr. Michael Fagies cannot attend the forum this morning. So it left us Mr. Bisariadi for our respondents. So for this speaker, we only have one respondent. Thank you. Okay. Okay, thank you. Welcome, Professor Roy. Professor Roy here will discuss on the creating rights, terminating rights, and overcoming legal conflict. Professor Roy is from University of Aberdeen, Scotland. And we have one and only respondent for this speaker, Mr. Bisariadi from Constitutional Court. So, Professor Roy, the rule is the same. You have 20 minutes of presentation, and I think the respondent has more time because of only one respondent. Okay, Professor Roy, the time is yours.
Slideshow?
Slideshow-nya.
This might be a little challenging to read off of the screen. Y'all have that in focus?
Okay, focusnya. The focus of the slide.
While we try to enhance the focus, I will try to remember what I had on my slides, and we'll move forward from here. First, I'm kind of the odd duck out here. I'm really a mathematical scholar. Professor Isra yesterday was speaking. He wanted to speak in Bahasa, but people asked him to speak in English. I want to speak in math. I normally work with set theory and graph theory when I'm trying to work on law. And that's not as odd as it might first seem, but I will try to make my discussion as non-mathematical as possible. Because, as Keynes once said, the secret to good teaching is you do the math and then you hide it, and then you move on from there. What I'm going to present on today is part of a really key struggle in legal science right now. And there's a question, you may have heard of Kenneth Arrow. He had a Nobel Prize in economics. He talks about social choice theory and about ordinal rankings in society. Can we actually integrate democratically my preferences, your preferences, her preferences, and do it in a just and fair manner? And it's mathematically demonstrated that we cannot. There's a problem with that. And it is complex. It's set theory. But the question is, does that actually apply to law itself? Or does it just apply in a more economic sense of the phrase? And so what I'm going to discuss today is a subpart of where we're going with this idea and these concerns. Part of the thing I'm talking about today is anti-commons theory. I am sponsored by the Japanese government to be building out a new regulatory approach for COVID type pandemics using a lot of anti-commons theory. But what I'm going to be speaking on today is not sponsored by anybody. It's all in the free and clear, so hopefully nobody will feel awkward about that. Just wanted to get that out because it's important to say when you're sponsored or not. Oop. Apparently I need to play more video games. I'm not good with buttons. I was that most troublesome child. I neither liked sports nor video games. I was always the kid with the book. So buttons are still my enemy. So the topical focus of our conference is constitutional courts and conflict resolution. But as a math guy, I'm thinking fundamentally, what is conflict? And the first thought is when you go into court, you're going to claim that your client has rights, and they're being denied. The other person comes in, they've got rights, and they're being denied. And if you're the judge, you sit back and go, well, that person doesn't have any rights, dismissed. And you could do that to either side. And so if they're in there, then there's some probabilistic, these people probably have some reasonable claim to their rights, and these people probably have some reasonable claims to their rights. And so we have some probabilistic overlap of the rights, like Venn diagrams, as it were. We have two sets that claim to contain the same elements. I hope I haven't scared anybody with that sentence. But this is very key to what lawyers do, is we say people are claiming things and everybody is claiming what the other person's also claiming. And that's exclusionary, right? So there's three camps of thought on what to do with this. The first one that I want to talk about is anti-commons. Anti-commons became very popular about 20 years ago. Professor Michael Heller raised the concept of anti-commons. He did it with regards to Russian economic development, and then it spread to environmental law, IP law, to economic injustice across the United States because of the way inheritance laws and probate courts operated in African American communities versus the way it operated in white communities. Anti-commons became this phenomenal research tool. But there's something very fundamental to it. I want to talk about how it causes trouble for us in a sense of conflict resolution. Coase is also very famous, another Nobel Prize winner from economics. He had two big theories in life. The first one is the nature of the firm. Why do we have firms? Which, in doing this demonstration, he came up with the concept that the market is not free of cost. It's free to do what you want, but figuring out what to do takes time. You have to organize information, and that means you're losing opportunities as you sort it. That's what transaction costs are. It's not money. It's you're losing other opportunities as you sort out your life. And then Cover. Bob Cover was a law professor at Yale, a very famous civil rights attorney, a very profound Jewish scholar with regards to Jewish religious law, and the notion of how can we ensure that our legal systems, our constitutional systems, are in fact just. Is it just merely backed on violence? And, you know, always God has surprises for us. This morning I was dropped off, as several of us were, at another building. And that's why I was late. I want to apologize to everybody for being late. But over there, they're holding a different conference. It's a conference on military equipment and clothing. And everybody over there, I walked in and they were like photographing us. They must have thought we were NATO generals or something. But truly, we talk about conflicts. We talked yesterday about states and tremendous transitions, and often that does come with military and blood and violence. And law and judges often are the people who grant that violence authority. And Robert Cover was deeply profoundly disturbed and intrigued by that. And at its core, he discovered this new jurisprudence of jurispathic judges, judges that kill law, not the more traditional hard and Dworkin theory that judges are creative in creating law, but actually the major role here is to kill. So if I can get into anti-comments, Michael Heller, as you see on the bottom left there, made this a very popular idea, but it actually goes back centuries. Adam Smith included it in his book on economics. You may have heard of Adam Smith, so it's not new. Cournot, a very famous French economist and engineer, also wrote about it mathematically. He detailed it particularly in the metallic industry, making metals, where it's where they discovered it again. We wind up having a variety of other scholars who have brought out this concept in different fields. But here's the key to this concept, which is, first, it's not the commons. The commons, say we're in Bali, there's a lake, and several families live around the lake. And if you want to fish in the lake, how does it go? If you don't have to ask anyone permission, anyone can go fishing, then everybody fishes. And pretty soon there's no more fish left. We have the tragedy of the commons. Everybody's familiar with that. On the other hand, what if I have to get the permission from every member of each household before I go fishing? What if this is a special holy lake and you have to get all the permissions? What if any one person can say no, and then you cannot? This is an anti-commons. When many people hold exclusionary rights to not allow a process to go forward, then the likelihood of that process going forward becomes zero. And so, again, the social welfare of that lake approaches zero, the same as when everyone has permissions. But the difference is it's easy to see when everybody has gone fishing, but it can be very tricky for lawyers to discover when have we granted too many rights to block opportunities, to block access to law, to block access to justice. And where those exclusionary exercises are can be very pernicious to sort out. So this is the great concern, that we may have a tragedy of the anti-commons in legal events. Oh, I really shouldn't have clicked too fast. At the bottom, this is what Michael Heller brought forward, is that there's this tragedy that we may have choked the universe of opportunity. But actually, our research has revealed that that's not really quite the case. It's a governing system, and you can distribute as many rights as you would like. Perhaps you do want to protect a sacred forest, so you do want to hand out these exclusionary rights to ensure that only when the whole community is on board with the use. Or maybe we don't want something to be so unused, so we only allow a few people to hold these exercise rights. I find this to be very applicable, understanding it's almost like you can dial it in, how much control to distribute across society. So power can be held in a dictator's hand, or we can distribute it among many parties and get similar amounts of control. Oops, sorry. So if I can give you some quick examples. The first one, the ecosystem, I just ran through that one. What about constitutional law? We just heard a phenomenal presentation on comparative constitutional law. And one of the things that I'm very interested in is amendments. How we recognize the powers to change it, and how many people have the ability to enable or prevent the process of changing a constitution. Again, we can see exclusionary rights in operation. The United States government, for example, you need the upper house and the lower house to approve it. But then you also need 2/3 of the state legislatures, many of whom have an upper and a lower house, except for the couple of unicamerals. And you start counting up how many organs need to approve, and if any one of them doesn't, then it fails. And so you would say, as the United States got larger and there were more players involved, we should see fewer and fewer constitutional amendments being created. And indeed, we do see that. And so then the United States starts trying to figure out, how do we get over this anti-commons, this tragedy of amendments? And the United States Constitutional Court, our Supreme Court, starts being more active in its interpretation. If we want medical technology, and this is where I'm working on with Japan, IP rights. The whole essence of a patent is to block everybody else from using your patent. And patents often today require hundreds of other previous patents to integrate to enable the new technology. And one of the great problems we've had with COVID is facilitating all of those rights. Even more critical are trade secrets. Trade secrets are that most private of intellectual property, and the very revelation of it destroys your rights over it. So even sharing it, you lose everything. So how can we facilitate medical research when these exclusivenesses are in play? In all cases, we want to consider the impact of granting exclusionary rights to remember that such grants are always effectively grants of governance, and judges will want to keep a careful balance to ensure policy goals remain feasible. Judges are always granting rights or denying rights, and understanding how they interplay with each other can be very critical. I'm watching my time, and I know I'm running a little over already, but I do want to explain a little bit of Gao and Wang, their observation that government agents, whether they're in ministries or in parliamentary committees, a variety of different government actors, control process and procedures, approvals, that effectively operate as property rights or as exclusionary rights over access to legal movements. And so they developed the first model of how we might be able to spot and identify anti-commons in government settings and in legal institutional settings. Wellantano brought out further that constitutional design essentially establishes, mandates anti-commons in government and legal settings. And particularly the way that governments fracture power. If we have a unified dictator who holds all power in his singular grasp, no anti-common. But if we say we need 3 branches, well, now we have 3 parties. And if we have a federal system, we have a national and distributed coming down, and we have more parties with overlap. Maybe I want to build a new airport. How many elements of the government will have some form of exclusionary right to approve or withhold it? And again, by granting it from the legal side, I do a lot of work as an environmental lawyer. We always want to make sure things get done right, but just the exercise of distributing powers and assigning rights means, will we be able to achieve our policy under an anti-commons understanding? So we must remain aware that anti-commons can lurk and hide in many legal questions and conflicts, and should remain vigilant to identify them. Wow, this is getting a little challenging. I'm really trying to pull up from memory what I have up there. Ronald Coase is he had a Nobel Prize in economics for the identification of transaction costs, as I described them before. But he's also quite famous for establishing the mathematical model of tort law, of conflicts, that both parties are making claims, and that it is the symmetry of the claim that is actually what is operative in tort law. And he did this without using math on the publication. He went back to Old English case law and brought out a sequence of interesting tort incidents, mostly commercial torts. But it comes down to this concept of exclusionary rights again. How can the baker bake his bread if the doctor next door can't tolerate the fumes and smoke from the bakery interfering with the patients, and back and forth? This is the central conflict here, is understanding that both parties are bringing forward conflicts. Now, instead of thinking, okay, first thing we do is grab a judge, he said what we really want is people to settle it between themselves. We want to enable natural negotiation and resolution. And why doesn't it happen? So the Coase theorem, which you may have heard of, a lot of people insult it, but it's actually understood backwards by most people. He said, if there were no transaction costs to negotiations, then people would have negotiated it. But they don't, and this is where most people stop reading. It's up to judges to reallocate rights, to facilitate transaction costs so that the people can achieve their own conflict resolution without other political necessary steps, without violence, without coercion, without policemen. So that's his first issue. And getting into this, he's trying to discover how can we support negotiations, how can we support bargains, what roles in reallocating rights, and recognizing that often historical reasons and reasons that had no equity or perhaps even no logic to them allocated rights in society, and sometimes a basic reallocation can enable transformative change. But then he also goes on and notes that often there are simply too many parties, and there are simply too many issues and too many claims, and no negotiations will get it done, at least not in our lifetime. So he says that's where the role of the state, the role of the judges arises, to no longer just reallocate rights, but to go and reach the point where negotiations, if fully informed and if properly allowed time, where would they have arrived to? And he says that's how you instill justice into a complex scenario. And finally, and this is, I won't get into the math of this, but it's been fairly well built up as an argument. The goal really isn't to eliminate injury. Classical tort law was, if you injure me, I need to be brought back to full balance, full justice. But across society, that will actually have a much higher cost, a much greater impact on welfare to cure every victim. And so at some point, it is better to figure out what was the optimal injury and let it go. And that speaks to a lot of what was going on yesterday on transformative justice and amnesties and how do we get past terrible injuries that involve hundreds or thousands or perhaps millions of people and coordinating all of the legal rights. At some point, we have to say what's the best we can do and move forward. And so in case you ever felt conflicted as a judge, there are really good theoretical reasons for that, very nice mathematical reasons, and I'll help you with those footnotes if you want them. This is, if we could read this, are all nice quotes that substantiate all this with the pin sites for all the loose arguments I've made. So Coase holds that curing or preventing all injuries will actually reduce the enjoyment of rights, more than the cost of optimal injury levels, which would reduce the enjoyment of rights. So it's better to recognize some level of injury is necessary than curing everything. So judges should either enable negotiations by reallocating rights where it would work, or set decisions that achieve what negotiations should have achieved to reach the optimal level of injury across all of the parties. And that's social welfare maximizing. Bob Coase operated with no math at all. I'll just put that out there first and foremost. Bob, first and foremost, was a civil rights person. He was very much looking to figure out why were so many different parties in the United States not getting the rights that they would have assumed they should have gotten under their Constitution, and how can you transform the legal process so that people would have access to the rights that they should have had. And so just some key quotes here. It's remarkable that in myth and history, that the origin of and justification for a court is rarely understood in the need for law. There's never a shortage of law. Rather, it is understood to be the need to suppress law, to choose between two or more laws, to impose upon laws a hierarchy. It is the multiplicity of laws, the fecundity of the juris generative principle that creates the problem, to which the court and the states are the solution. Sorry, there was a little fugue moment there as the screen shifted. He's observing that historically, if you go back, and Bob covered it, a lot of legal history looking at jurisprudence as it emerged out of the Middle East, out of Samaria, out of Greece, out of Rome, and out of Egypt, as we experienced it in the Western culture, none of them had a narrative that there was no law, and therefore a lawgiver needed to be created, because each of these cultures had a king, and the king was giving out rules and fiats and decrees and discreta in abundance. Even Hammurabi, if you've never taken the time, Hammurabi kept extensive letters to all of his circuit judges, and we have those. Those have been luckily discovered, and we can read those. And the level of attention of, well, we had this holding in this other city, and now we've got a similar case over here, the same stuff we do today. And the judges were dealing with people had multiple claims, and which one takes priority? What are the hierarchies of the rules in Hammurabi's establishment? And so that's really where we are. It's not Dworkin's how to do a hard decision. Most judges basically have too much law, and the courtmen go, no, it's yours. Right? You get to win. You have two children. Mom, it's mine, it's mine, it's mine, it's mine, it's mine. And someone has to say, okay, it's your toy, and you get to watch TV. Now go do your thing. Return balance to the community by hierarching the law. Cover develops a very interesting jurisprudence. He puts it into two camps. One is paideia. We sit to have coffee, and we're reaching for the sugar. Someone has to get the sugar first. I yield, he yields. We create a rule. Who gets the sugar first? Two other people sit to have coffee. The rule is slightly different. We're all being lovely and polite, but we evolve slightly different rules. But to remain a social group, when I now have coffee with somebody else, we have to keep sorting out the rules. So there's always this organic bubbling up of rules. And that's marvelous. We provide structure and coordination, but because there wasn't an overarching architect, we have to have a separate camp of law called imperial law, which is to reintegrate everyone in the community to a similar set of rules so that we share a sense of justice, so that we hold together as a community, as a collective. Otherwise, we pull apart. Everybody's just pushing for their own camp, their own rules, their own special views. Many people might say that's a good model of what's going on in the US on some social level. Someone needs to pull it together.
Excuse
And
me,
Cover says,
the time.
time. I'm going to steal from my first respondent
I really
a few
feel
minutes.
bad, but yeah.
I'll steal from my first respondent. So he goes, how do we sort this historically? Every country, every culture, every tribe had a cultural narrative. And we cannot disconnect the positive legal instruments from our cultural narrative, from our religious narratives. And Cover just straight out says, I don't go with Bentham. It's not because the king says there's a rule, there's a rule. That positive nature of it, he doesn't buy into. It's because the people in the community will voice their support for the justice that's being enacted by the steps undertaken by the judge. If the judge sends a policeman into the street to restore rights, it's because the community agrees with that. That's where justice lies. I was recently watching a movie on the airplane coming here about these police who were some security agents who were going rogue in another country, and is justice about following the rules, or is justice about achieving justice? You know, the movie was called Raksha or something like that. The key issue really for Cover is justice is when the community agrees is justice, because it matches their sense of adat, it matches their sense of their faith, of their religion, and it matches who they are. And so that's key. And so law and the narrative, the cultural narrative, go hand in hand. And this is why Robert Cover is cited for all the law and literature cases. But he's really getting at, if you're a constitutional judge and you're trying to sort out, am I dealing with real justice here? How do you know? How do you connect it? Is it because you can order the police to enforce it? Or is it because the community welcomes your judgment and they themselves will be working to help you achieve it? So this is really the last slide. So when we come to anti-commons, we see that there's this very simple idea. When people have exclusionary rights, but they're claiming it over the same thing, it's going to result in frustration. And it's very easy for judges in assigning rights, in splitting up rights, to accidentally create these legal institutions of frustration, where we're deepening conflict instead of curing it. In this one case, we're curing it, but across the society, we may be deepening it. Coase says we need to enable negotiation where possible between the private parties, but when it is too complex, judges need to recognize there is an optimal level of injury and move on, because that's the greatest social welfare. And then Cover says that we are going to recognize that there are injuries, but when we try to come to discover what is justice, justice comes from a community-wide vision of justice. And judges' roles are to ensure that our rules are common enough that we stay on board together as a community, and that our community vision of justice remains unified. That's the role of the judge, to keep us all at the same table of justice. Now, that's not that the judge gets to declare that. The community is declaring what justice is. It's the judge's role to ensure that the community gets its dreams. So, in case you want to know where some of this comes from, I provide you with some handy citations. And thank you very much.
Thank you. So since we have really, this is a second gong actually, because because the first gong doesn't working. Okay, Mr. Bisharadi, make it quick. Thank you.
Thank you, Budiana. Good morning. Very welcome for you all. Still hoping that Michael Fagias will probably show up, so he get the lion's share of giving response times. But still, since Michael doesn't show up and you already steal his time, then I'm fine then. So, Pak Roy, I'm not in the positions, or I'm not in the capacity to give comment to a writing of a professor. I'm a student myself, so I'm gonna switch positions rather than giving comments or reviewing a writing from a professor. So I'm probably gonna ask questions, just like student asking questions to his professor. I have 3 questions actually. So I'm very lucky that I'm working on research on constitutional right interpretations, and I'm lucky enough to read your paper in advance. You introduced me to Robert Cover. So, to tell you the truth, you introduced me to him. I never met, never read his name before. And the idea of Robert Cover, it seems like when you read, there's a balancing. While in the process of my research, there's also a doctrine of balancing. In the US Supreme Court, there's a doctrine of balancing. On the other side of the continent, the balancing doctrines also being termed as proportionality. It's rooted in the German Constitutional Court called proportionality. There's also scholars, Robert Alexi mentions about proportionality, and also Aharon Barak said about proportionality. And I think Canadian Supreme Court used the term proportionality rather than balancing. My question probably, where does this Robert Cover idea about balancing on constitutional right, is it just the same? Since I also read that today considered as the age of balancing or the age of proportionality. Is it the same as the idea that trying to be developed by Robert Cover on balancing, especially on constitutional right? My second question, right? My second question in the notions of inflations of right. Inflations of right. There is a notion of inflations of right. Constitutions there is a growing tendency that constitutional drafters make a long list of enumerated rights in the constitutions, especially in Latin America. And also, there's a growing tendency in the court creating a new rights. In Mexico, smoking pot even considered as constitutional rights, according to the Supreme Court's judgment. In Germany, bird feeding pigeon in public spaces, also considered as constitutional rights in Germany. So there's a growing tendency about creating a new rights. But the idea of Robert Cover seems on the opposite side, meaning that if you can create rights, you also can terminate rights. For the court, it's hard to limit rights. It's very difficult to limit rights. But the idea of Robert Cover seems like you can also terminate rights. If you have a difficulty to limit rights, how can you terminate rights? Is that, can you give any enlightenment on that? My last questions, I read on your part of the paper mentions that Robert Cover also cited or mentions about Grundnorm, fundamental norms. Is it the same as Kelson's idea on Grundnorms? Because in Indonesia, we regard Pancasila, the 5 principles, as Grundnorms. And it also mentions as a formal that this is the source of the law, this is the highest. And then in many jurisdictions, it's not mentioned what is their Grundnorms. Even in America, I don't know what the Grundnorms in America. In Germany, there's discussions that the Grundnorms probably about human dignity as the fundamental constitutional norms on the basic law. But then it was not mentioned, not like, oh, I have to go on. But it's not the mentions difference between with Pancasila.
Okay.
So
Okay,
that's
thank
my
you.
3 questions,
Thank
Pak Roy.
you. Because Mr. Pisaradi does not respond but asking questions, and we have 3 questions already. Unfortunately, maybe if other participants want to ask you question, maybe after this.
Yes.
Yes.
I'd be glad
Okay.
to take them later.
Your
so
time.
to respond quickly,
3
so
questions.
first, proportionality. In most European courts, including the United States court, they really are going back to the proportion, the ratio, that you have 2 people in the court, you'll give some to this side, some to that side. Both sides of the argument have some element. The issue with cover is he's talking first about allowing Paideia law just to exist. It's just there in nature. It's not governed, it just manifests. And rules are just, legal rules, social rules are just coming up from below. And it's the imperial order that really kind of establishes positive law. And it can be by both legislative bodies, by judicial bodies. And he does speak primarily to the US Supreme Court, is his real target of his main famous article. In fact, it's even called Forward to the US Supreme Court. But his notion of balance is quite different. It's a question of artificially delimiting law and thus denying it some of its naturalness, denying it some of its truly belonging to the community, because everything slightly artificial eliminates. So if I have 3 or 4 different interpretations of how can a parent raise a child, and we have to have a national rule, each of these camps is going to have something denied, but it's not per se proportional. This camp gets some and that camp gets some. It's a limiting the power of law itself to make that decision. So it's kind of a Grundnormen to the proportionality that gets used later on, right? So it's a kind of a deeper level proportionality that Cover is looking at. Because Cover is very curious, when do I need to use the police and the military to enforce what I just said? When do I need to overcome community feelings? Because there were different elements in society. And particularly, he was discussing about education and religion in American schools. And that was the Supreme Court case he's responding to. And he's looking at, well, how can I tell the Amish how to raise their children, and Jewish people how to raise their children, and other people how to raise their children? How do we have a common rule? In that proportionality of the use of government power, that coercive element of law to establish and enforce positive law, that proportionality. So a similar notion, but on a different issue. The second one on inflation of rights. So my first reaction on that is, yes, I've heard quite a few old law professors talk about it as constitutions written by young people. You know, everybody wants everything. It's Christmas. Constitutions by Christmas, everything is under the Christmas tree, every right you want. We have anti-comments that are really right there. Every right that you claim is a denial of somebody else's rights. The right to smoke marijuana is the denial of somebody else's preference that the air will be free of marijuana. And so we do see these multiplicity of rights, but the fundamental notion that to establish a right, and this is Coe's, that to establish a right is to deny somebody else a right. There's no other way. If we give everybody all of the rights, then nobody will be able to operate at all, because everybody will be just as denied as the people who are granted. And that leads to conflict. And so we have the anti-commons view of that, we have the Coesian view of that, and Cover would say that's precisely the problem of Paideia law with no control, because there's so many rights being pursued that it may not really reflect the community at large. There's many little subgroups in society, each getting their special little rights, but those rights really don't reflect a community value. And then to use the national power to represent the whole community to enforce specific rights which are really not in harmony with other large portions of society. We might be ripping society. And that would be Cover's, I think, observation of kind of what I would call more hyper rights than rights inflation. When we have too many enumerated specified rights, the ability of the court to establish that this is justice with every case on all of those rights across the whole country, when many people may not feel those rights are very critical, that would be at risk. Yes. Yes.
Just one follow-up.
Yeah.
Can law be that sense of binary, one wrong, right, wrong?
Well, certainly, if I have to issue a decision, who will have the child, right? That child has to move, or who owns the property rights to those shares, right? There are certain points where you have to go binary. It goes this way, it goes that way. That's why they're in court. And so there are moments when you have to make that kind of a hard decision, right? They get the divorce granted or not granted. There isn't a blurry, you get a 2/3 divorce. During the weekday you're divorced, but on the weekends you go home together. Law often does require those binaries. It's something that a lot of lawyers don't like, but it is, I think, inherently part of what happens in conflict resolution. And maybe that's just people with conflicts and claim aren't more open-minded to sharing, because then they might have negotiated out without having a judge declare who has the priority of the right. And you were talking about, can courts deny rights or kill rights? Well, the best example I can think of is the United States deciding that people don't have a right anymore to own people, the ending of slavery. It was a right very well established in the law for centuries, and then very clearly eliminated as a right. In the United States, it took a war plus other things to get it all done. Other countries, in Britain, it was done in a different way. But that's a very strong right that was held and exercised and then eliminated. So there are tons of rights that have existed and then are canceled. Even the right of the government. The government has powers, but in some way they're operating in the mathematical space of rights. The government claims that it can enforce a public view or a public policy on social behavior, and the public disagrees with it. It might be the ability to say something against the government. It might be the ability to show your hair. It might be the ability to smoke marijuana in public. And to kill the government's rights is often what courts do. And so, you have to be careful with vocabulary. We often get caught up with, is it a power, is it a right, da-da-da-da. But the legal theory really doesn't separate that. And so definitely we can kill. If you could remind me just for a second your third question. Oh, the Grundnormen. And so first, Kelson's notion of Grundnormen is there in his theory because he's trying to find something before positive law. What grounds the positive law? And so the Grundnormen idea of Kelson is not completely different from Cover's idea of Paideia law. But the Grundnormen then moved towards the Constitution and then following down that pyramid. Whereas Cover sees Paideia law as the bottom and then conflict really coming up over the rules. And then when judges can't handle it, it needs to move into a larger political sphere like a legislature. And we move from something that's just between two parties or several parties into a larger body, a politic, to be solved. And so the Constitution is another thing that's been solved by the people. It doesn't really descend from a king. And maybe for some European countries, there was a king who approved a constitution that comes down. But for most countries around the world, you got rid of the king first, you fought a war, you had independence, and then you say, you got people from different parts of the country that come together, what constitution do we want? And so the Kelson model doesn't really fit. If you're from a country like mine that fought everything, it was a total mess, and we got people together and they had meetings, and they debated, and we still disagreed when we got done, right? So the Kelson model of a God, Grundnormen, things down.
Maybe you can elaborate more.
Oh, yes. So coming to a thing. So the difference between the ideas of where Grundnormen lay is very different between Cover and Kelson. Kelson says Grundnormen set up a pyramid. Cover says that conflict enables the discussions and negotiations where we agree from an imperial perspective to create structure to limit the chaos. We are the chaos defeaters. And this is where we cycle back into Coase, who says that when there are negotiations that are too complex, too many parties, too many issues, the state sets up as a super firm to entrepreneur the solution. Thank you.
Okay, I think we really ran out of time because we have one other speaker. Okay, I guess we should give applause to our speaker. Thank you, Professor Roy.
Thank you so much.
And our next speaker, I would like to invite Muhammad Nova Al-Ghafani, PhD, for our last but not least speakers. from University of Ibnu Khaldun Bogor, Indonesia. He will discuss about the strengths and limitation of the Constitutional Court's 6 basic principles as a normative guidance in resolving water conflicts. So basically, Mr. Mova will discuss about the water conflict. And we have 2 respondents for this speaker. That is Mr. Max Steur, PhD. I hope I spell it right. And Ms. Titis Anindiati from Constitutional Court. And I really, unfortunately, the committee has warned me a lot about the time. We know that we start late, but we have to meet the time schedule as in the rundown. So I would like you to, well, you have 20 minutes, but I would appreciate it if you can deliver it less for 20 minutes. Okay, thank you. Mr. Mova, the floor is yours.
Thank you. Very good morning, everyone. Can I have my slides, please? Okay, can we zoom in? Yeah, so while waiting for the slides to be zoomed in, thank you very much. I'm going to talk about the Constitutional Court's 6 basic principles. So this is Indonesia, and what we see here in the red is severe water stress, including the island of Bali, where we are now. During drought season, we have a severe water stress. So red are severe water stress, which occurs during dry season. And below there, as we can see, the Indonesian water productivity is very low. So on the circle below. And you can see again there that the island of Java only have 5.9% of water, but we have 56.5% of water. So almost all of the islands of Java is in the red, which means severe, or in the yellow, which means high water stress. And these are some of the examples of water conflict which I collected. As I said, this is only an example. There are some conflicts almost everywhere, in Borneo also, but I have not mapped them, and also in Papua, including in Bali. There are 3 at least which I look at in the news of conflicts. So we used to have a water law, but then the water law was judicially reviewed, I think, several times, and the water law was finally invalidated by the court. And so the court states that in terms of water commercialization, we will have to pay attention to these 6 basic principles, something to deal with state control, fulfillment of human rights, environmental conservation, and then state control again. And then the 5th, that the priority has to be given to state-owned enterprises or region-owned enterprise. And finally, if water is still available, the government may grant permits to private enterprise to commercialize water based on strict requirement. Number 5 is interesting. I think number 5 comes up because of resource nationalism and state capitalism, which is a tendency of Indonesia. So the court tends to interpret state control through state-owned enterprises. It seems to be the trend in natural resources disputes. So I would like to talk about the strengths now. The first is that the strengths is it reinforces the duty to protect and respect in terms of the human right to water. It reinforces the duty to fulfill. It highlights the importance of environmental conservation. And then it states the manifestation of control by the state through state-owned enterprise. So these are the strengths. Other than human rights to water and environmental protection, it offers guidance and allocation. So how should we allocate water when there is a stress? Which one are the priorities? And so the House of Representatives then implement the 6 basic principles here into the allocation framework. What we have here on the top is the minimal daily basic needs, but interestingly, we can see there that state-owned enterprise is under rank number 8, and water utilization for the private sector, individual enterprises, is under principle 6. So this means actually that small, medium enterprises or individuals who are in small, medium enterprises or they have something commercializing water, they sit on the bottom rung of the allocation ladder. And people's farming, which is actually very, very water intensive for rice field irrigation, sits on number 4. So these are the manifestation of the constitutional 6 basic principle. But we don't have explicit environmental flow in the allocation framework. So the wording is only taken into account. So now I would like to talk about the limitation. The first is that I think the 6 basic principle is not sufficiently broad. So it is supposed to be basic, but I don't think it's basic enough in order to settle water dispute. The 6 basic principle only deals with allocation. So allocation is when we have too little water. But water dispute can occur not only because water is too little, but also when water is too dirty or when water is too much, which is flood, as you can see. So we have pollution, for example, which I don't think the 6 basic principle can handle. And also we have questions of our water services. Is concession or divestiture or private sector participation allowed or not? Is it not really clear from the 6 basic principles? So these are the limitations. And also the court says that this is the principle for the commercialization of water. But it doesn't say that this is the principle for the governance of water. I think this is also limiting because it presupposes that non-commercial water use is okay, but actually no. Non-commercial water use, even if they are used by farmers through boreholes and groundwater, it can destroy the environment. And this is very important and probably could be related to the earlier presentation from Professor Partain. The 6 basic principle neglects efficiency. So if we look, for example, in the integrated water resources management, we have 3 values. The first is equity, second is environmental sustainability, and the third is efficiency. And we can see that there are different kinds of water footprint there. For growing beef, for example, it requires a lot of water. So it is much more efficient to grow, for example, to use water for the production of bottled water because it requires very less, 1.5 is the water footprint, than for growing meat, for example, or for other kind of uses. But this is no longer possible if we interpret the 6 basic principle in a textual way. So, thank you. There are these are the example in which conflicts over water quantity occurs and the principle is not applicable. For example, what if there is a conflict between farmers and farmers? The principle is not applicable because it doesn't say anything what happens, who should get the rights to water. If there are conflicts between smallholder farmers and industry, the principle is applicable, then the smallholder farmers should be prioritized first. But it is dubious if there is a conflict between rice field and aquaculture. So for example, there is a conflict between rice and aquaculture visited by one of the minister. It's dubious how it should be applied. If there is a conflict between a smallholder versus drinking water. Now this is happening actually in Bali, in which we have a subak, and subak is a UNESCO heritage culture, and much of the water has been taken by the drinking water utilities or the industry. So the water that we are using for taking a bath is probably coming from this traditional irrigation system called the subak. So according to the 6 basic principle, drinking water should be prioritized because it's a part of human rights. But it's actually tricky because drinking water utilities also supply hotels or apartments or convention centers such as this, which is actually commercial. So the principle is applicable, but it doesn't provide the solution. The 4, if we have a water quality conflicts, for example, between hydropowers and floating net cages, this occurs in dam, for example, the principle is also not applicable. I mean, who should win? We don't know how the rights should be allocated. Also, when we have aquaculture versus rice farmers, it is dubious. Also, when we have conflict between aquaculture versus tourism, it is not obvious who should win. Also, we have special conflicts with water implications. So, for example, somebody cut down the forest and then it reduces the water flow. We cannot use this principle. And what happens if there is mining dewatering versus drinking water? It's not really applicable too. And we have here a customary water tenure in the Kahayan catchment. So they have this called manuba using poison. It's just part of culture. And they have lanting houses. This is located in the island of Borneo. So this is a kind of customary water tenure. And they have the handil and the beje, which is also a customary water tenure, but not necessarily customary law. And there often overlaps with palm oil plantations. And also, now we have a food estate project in the island of Borneo. So we cannot use this principle. I don't think the principles are applicable in these cases. So my conclusion is, first, the principles can only be used to guide some allocation conflict, but not water conflicts, but not the broader water conflicts, such as conflict arising out of privatization and concession. Secondly, the principle, by literal interpretation, covers only commercialization, but not water governance. And thirdly, the principle, although it incorporates equity and environmental sustainability as values, it neglects efficiency. And the fourth, which is, I think, could be quite dangerous, is that the principle may prohibit the reallocation of water to higher value uses. So as I said earlier, rice field takes a lot of water. Sometimes you have to opt. Are we going to choose rice field or hydropower or blackout? So if we choose the rice field, then we're going to have a blackout. But actually, hydropower has a lot of welfare maximization function, which is lower if it compares to a rice field. So my recommendation is as follows. The first, we have a literal and teleological interpretation. I think we should interpret the principle teleologically, which I suggest that the water should be exploited to the greatest benefit of the people's welfare, so welfare maximization. And also states that less than economically optimal, but nonetheless equal allocation of water would violate the Constitution. So what I'm saying is, if the allocation of water does not maximize welfare, it violates the Constitution, because the preamble of the Constitution said that the foundation of the state, why we establish the states, one of the purpose is to maximize people's welfare. So we use the teleological interpretation instead of the literal ones. And the second one, I think we could expand the scope of the principle from commercialization to governance. And finally, we should set up reallocation framework in the legislation. So the teleological interpretation, which enables efficiency as value guidance, the government should then set up a reallocation framework based on equity and environmental sustainability principles. So for example, we can build irrigation systems so that they can be more efficient for the farmers, or we can give the farmers water storages so that they can harvest rainwater, or we can have monetary compensation if we have that. But we cannot have it if we interpret the principles literally, so only restricting the private sector are very much at the below rank of the allocation ladder. So finally, this is my presentation, and I welcome very much your suggestions because I'm working a lot with the FIO, with the World Bank, and with the Ministry of Public Works, which is currently setting up the implementing regulations of the water law based on the 6 basic principles. Thank you very much.
Thank you so much. Thank you so much, Mr. Mofa. Our first respondent would be Mr. Max Stewart, PhD. The time is yours.
Thank you very much, Chair, and thank you for the presentation. I'm no expert on water law, nor on Indonesia or on Asia, so I approach this paper more as a generalist reader, but I'm very pleased that I was assigned as a respondent because I think that this is really an important contribution in demonstrating more broadly how constitutional courts are central institutions for addressing third-generation fundamental rights. In recent years, I'm hearing from other colleagues who are experts on the Global South that courts from the Global South have taken up a leading role in challenging the view that judiciaries overstep their competencies when adjudicating second and third generation rights. And I think Dr. Mofa's paper succeeds in demonstrating how questions of water allocation, quality, and managerial efficiency are a source of societal conflict and prompts questions on addressing them via judicial interpretation. The paper furthermore presents, I think, an internationally relevant example of the interaction between constitutional courts and legislatures, since as it explains, the legislature in Indonesia reacted to the decision of the Constitutional Court that had introduced the 6 principles for managing water conflicts. So with its ambition to provide advice to the court, it utilizes a standard interpretive method where specialists in a particular area of law, in this case water law, reach out to the judges, who usually embrace a need to keep a more general perspective in mind. So I think in this sense the paper is very helpful also for legal practice. So Dr. Mofa recommends to adopt a teleological reading of these 6 principles and subsequent legislation that would enable the principles to consider a wider set of water conflicts which are not covered by the currently prevailing interpretation. And I think the demonstration of this conclusion was very convincing. I wonder, however, whether the teleological reading does not set too high of a bar on the possibility to measure efficiency as contributing to the overall welfare of the population. So I wonder whether this resembles somehow a utilitarian reading of welfare, that by allocating some water to industry, taxation incomes may increase and this would benefit all. The question here would then be, however, that more income through taxation is no guarantee for welfare improvement on its own without robust democracy and accountability mechanisms for the exercise of state power. So I wonder, and this could be also a question, so how the Constitutional Court to effectively revise the emphasis on prohibition of commercialization that you convincingly demonstrated needs to embed its water conflict jurisprudence in a broader reading of requirements for entrepreneurship as well as exercise of state power in a democratic regime. And in the last couple of minutes, just 2 more questions to this fascinating analysis. So one, I think it would be interesting to hear more on the factors or motivations that might have driven the Indonesian court's decision on these 6 principles, as this could also offer an insight into whether and how the alternative proposal that Dr. Mofa suggests is a potentially feasible one to be embraced by the court in the future. And the second question pertains to this distinction between the inter and intrastate water conflicts that you highlight, and as discussed also yesterday in this conference, we are primarily discussing conflicts within the state, and I completely agree that it is important to focus on these types of conflicts. I wonder whether your recommendations actually for allowing commercialization of water supplies when this benefits the society as a whole could also be applicable to interstate water conflicts, or to what extent then interstate water conflicts require a different set of considerations to be accounted for in constitutional court decision-making should such a future case arise in Indonesia or elsewhere. So overall, I think this is a very promising work that I just look forward to see published in a very near future. Thank you very much.
Thank you very much. Thank you very much for first respondent. And our second respondent would be Ms. Titis Andiani from Constitutional Court. The time is yours.
Thank you. Firstly, I would like to appreciate Mr. Mufa's paper because it is mainly well written and brought up an interesting issue regarding the restriction on water tenure rights based on Constitutional Court Decision number 83 of 2013. However, I would like to know why or on what basis you feel the need to mention the limitation principles numerically as 6 basic principles, particularly on the title. Probably you could just mention basic principles without using the exact figures or the figure 6. You still could, of course, elaborate further in the analysis discussion that the limiting principle consists of 6 or 5 plus 1. You already mentioned in your paper that it is called 5 plus 1 because the limitation principle given by the Constitutional Court consists of 5. Then, if the 5 principles have been fulfilled, the following principle states that the government may grant a license to a private business to exercise control over water under certain conditions. But that is probably not necessary to put the number 6 in the title. In the introduction, Mr. Mufa very well described the facts in the field and how water scarcity became the forerunner of conflicts over water management rights in Indonesia. However, I was wondering why Mr. Mufa did not describe the actual background of the court's decision. In this case, the petition for judicial review that transpires the Constitutional Court Decision number 83 of 2013. In fact, the legal consideration in a Constitutional Court decision are statements or responses of the Constitutional Court to the constitutional issues raised in the case. Therefore, I think it is very relevant if the background part of the paper is elaborated again with the petition submitted by the petitioner, because without the petition, there would be no decision. Then, in the conclusion, Mr. Mufa provides an efficient solution on how the court needs to expand the interpretation of the 6 basic principles into water governance as a whole instead of only water commercialization, or even need to be given a theological interpretation to reach the prosperity of society. It makes me want to know more if the Constitutional Court has to do this in the future. Probably Mr. Mufa has analyzed or estimated which laws that have the potential to be used as an object of review that can be used by the court to respond in its decision with more suitable interpretation as recommended by Mr. Mufa. Then maybe as a suggestion, Mr. Mufa probably can explain the scope and limitation of the Constitutional Court's authority in deciding judicial review cases, because I think the courts can only create constitutional interpretation of an issue only if the issue is petitioned by the applicant in the case of judicial review. And the court itself cannot create cases or issues decision without petition. Okay, thank you.
Thank you so much. Now I open questions from participants, one from the my left side and one from the right side. From the left side, Professor Roy, and from the right side? Okay, Professor Roy. Yes.
All right, thank you so much. And I had a PhD student who recently also engaged with the water laws of Indonesia. And so I have a little bit of background, not your expertise, but I was stunned when my student got into the water laws of Indonesia. They're in so many different parts of Indonesia's regulatory world. Some of the agriculture, some of the water provisions, some of the water regulatory authority provisions, and they're all over the place. There's also some adat out there, traditional community rules. One thought I have as the kind of scholar I do is there's so many pieces and parts. How can one support a court to be tracking the whole of this very fractured and scattered water regulatory system to ensure that it is on constitutional principles and on human rights principles? And is there a way forward for Indonesia to maybe unify its water law systems, or is there a way for there to be, like in the United States, maybe a restatement of the water law? So it's not the actual law, but it holds it all together in one place so that the court can interact with it to better ensure constitutional harmony. because there's so much of a historical evolution of these mini water laws that we were just stunned, the complexity of it. And so that in essence is my question. Is there a way to make it easier for judges to ensure constitutional goals are achieved?
Okay, I think there's no more question, and you can respond on that, Mr. Mova. Thank you.
Thank you very much indeed for the comments. I think it's going to be very, very helpful for my article, but also for the applications in the upcoming legislation. I think first one is from Max. Does it set the bar too high? Yeah, I don't know. Could be, because through this article we are expecting two. The first is the Constitutional Court to reinterpret, and then the second question given by the second respondent. But also we are asking the government to do some theological interpretation, which I think they would be rather hesitant to do it, because they don't want to violate, so to speak, the literal interpretation given by the Constitutional Court. As the second question is, what are factors and motivation, and why the principle? Yeah, I think the two factors, I think, is a combination between state capitalism and resource nationalism. State capitalism here means that the state-owned enterprise is being regarded as an entity which should safeguard state control over the natural resources in Indonesia. This is the case in the oil and gas, this is the case in the electricity, and this is the case also in mining sector. So a lot of priorities are given to the state-owned enterprise. But water is a different kind, it's a different thing. I think it's really, really different. I mean, it's different from oil and gas. Someone can just bore a hole and then can get some water. So it's different principles should apply. Regarding the interstate water conflict, yeah, I think the interstate water conflict usually occurs in a federal state, like in the United States and Australia. I have no exact expertise on that, but I think the similar principle could actually should apply. We cannot lock, as Professor Roy said earlier, we cannot lock the parties, assign the rights, and exclude them from negotiating. We have to open it. So if it is more welfare enhancing, welfare maximizing for the industry to compensate the farmers, for example, that it should be allowed. The question on what basis do I mention the 6 basic principles? Yeah, it's because it's been highly regarded as 6 basic principles, but I would consider it again. Thank you very much. So I just say it's actually 5+1. So thank you very much for the suggestion. Also, thank you. I will try to describe the background of the case. And there was a question regarding how can we adopt this by the court. So which I think one of the way is we can try to ask another judicial review of the existing water law legislation, and try to persuade the court to reinterpret that, because the existing legislation encapsulated the court decision, and then it specifically says that the private sector should be at the bottom rung when if water is still available and it can go to them. So we can judicial review that article and then offer this, my paper probably as a solution to that. And lastly, commenting on Professor Roy, yeah, I think it's very difficult with water because we have forestry on one hand, we have agriculture, we have fishery, we have natural conservation and mining, and they are all related. So what we have in Indonesia for now is a framework law, actually. The water law is a framework law. I don't know how we can make it simpler, but probably the 3 principles offered by integrated water resources management of efficiency, equity, and environmental consideration can help. But in terms of consolidating them into one single legislation, I think it's going to be probably, if not difficult, then it's probably impossible, because simply water is just everywhere in plants, in our drinks and services, in the pipes, and yeah, so it's very complicated. Thank you.
Thank you so much. We have now come to the end of the second session, as we begin at 8:20 and we finish at 9:20. Now let us give applause to the speakers and respondents. Thank you so much. And further questions and discussion can be conducted after the lunch or after the session or outside the forum. I will give time to the Master of Ceremony, Mary. The time is yours again.
Thank you so much, chairs, distinguished speakers, respondents, and all participants who raised some questions. Ladies and gentlemen, we will go to the next sessions, the third sessions of today's conference. Today's the second day of the 5th ICCIS. Allow me to welcome the Honorable Dr. I. Gede Palguna to moderate the next sessions.
Okay, thank you very much, Mary. Sorry for the white dog. Thank you very much, Mary. It is an honor to me to chair the third session of the ICCS, and I would like to invite Professor Woo Young Ri from Korea, please. Hopefully you enjoy your stay here in Bali. Yeah, although maybe have already been a little bit crowded despite the COVID-19. And as usual, it would be given 20 minutes to Professor Wu to, am I right? Oh, Ri. Oh, yeah, sorry. To Professor Ri to present her papers. And because of the tight schedule, the time is yours.
All right. So I guess the PowerPoint slides will come up pretty soon. Okay. So. Hi.
Oh, I'm sorry. I would like to invite the two respondents, both of. I'm very sorry. Who is the respondent? Where's my schedule? I'm sorry, because.
And to save time, if you could upload my PowerPoint slides, that would be great.
The respondent of the session would be. Oh, Professor Bertus de Villiers, from Australia. We met yesterday in the South Coast. And, yeah, my old friend, Muhammad Mahrus Ali. He's already here. Yeah, thank you, Tuan. Please continue, Professor Ri.
All right. Thank you very much. Good morning. I am Woo Young Ri of Seoul National University School of Law, and in the remaining 15 minutes, approximately 15 minutes of time, this morning I would like to share the experience of the Korean Constitutional Court and it's operating this specific type of constitutional adjudication based on constitutional complaints. It might be a very limited experience of South Korea. However, I do hope and I do believe that What we'll be doing this morning, if we begin in a clean slate, and if we could just, try to design a system from the blank, a constitutional adjudication, a type of constitutional adjudication to allow type of direct application to the Constitutional Court for individual relief, then it will help all of us here to think about the intended legitimate goal of the constitutional adjudication itself. And particularly, I do hope that this experience of Korean Constitutional Court will serve as one out of many available references to and for the Indonesian Constitutional Court as well, and its contemplation to possibly introduce a constitutional complaint type constitutional adjudication in the future. As Korean Constitutional Court and Indonesian Constitutional Court have over a long time developed a very special type of friendship, which has helped both ways to develop our own respective systems of constitutional adjudication. And very nice meeting you here, all of you here in this room, and also all of you participating via Zoom. So this constitutional adjudication on constitutional complaint is a very specific type we have out of, let's see, sorry. This goes very, sorry. All right, 5 types or 5 jurisdictions we have since 1988. Constitutionality of statute, review of constitutionality of statute, impeachment and dissolution of political party, competence dispute, and then finally this constitutional complaint. Korean Constitutional Court has 5 different jurisdictions, and then I'm gonna go back to give you a very, very, very brief historical account for the development of constitution in South Korea. So as we begin, it is totally possible to have constitutional adjudication without an independent, separate institution of constitutional court as opposed to judicial court. Yet constitutional adjudication happens all the time, whether or not that specific jurisdiction does have a specific and separate independent institution of constitutional court. And also constitutional adjudication, even if a jurisdiction does have a constitutional adjudication system to be operated by a constitutional court, it is definitely possible to have, not have a type of direct application or constitutional complaint. And on this background, South Korea did have its very first democratic and republican form of government in 1948, and up until 1988, we have 9 times, that was the 9th revision of the Constitution. We had 2 military coups d'etat, the first one 1961, and the second one in 1979, and in both occasions, 2 of the military generals who led such military coups technically became civilians, and then they got elected through indirect election mechanism and then served a long while, 18 years and 7 years respectively. And then there came this nationwide democratization movement, civilian movement, and then martial laws, and then such civilian democratization movement had really became nationwide. And then incumbent president finally acknowledged to adopt this symbolically direct election for the presidential office. And then the ruling party and the opposition party agreed to have the constitutional revision. And that was the most recent and the last and 9th constitutional revision that established the current in 1988 constitution. The revision process came in 1987, and then the current constitution came into effect in February of 1988. So 4 main points, but our focus is on the constitutional adjudication, the introduction of constitutional adjudication. by the current constitution. I'm just going to give you a little bit of backgrounds to underscore the importance of constitutional complaint in South Korea. Democratization, and then democratization, what was most important for us for democratization in South Korea was how to normalize the relationship between the president and the legislature. And then, as you see here on the screen, now the president may not dissolve National Assembly, which is the national legislative branch of national legislature of South Korea, but it is subject by National Assembly general audit, annual audit, and then also special audit and whatnot. And the Constitution itself and the corresponding statute really control the president and the president's declaring state of emergency and whatnot. Okay, and then the protection of fundamental rights. The current constitution expanded the list per se for protection of fundamental rights and specifically introduced more of the new fundamental rights, particularly in social and labor rights, labor and social rights, and also right to minimum wage. Whatnot. And then the constitutional adjudication introduced by the current constitution to be operated by an independent, separate institution. So we used to have this tripartite, like legislative branch, executive branch, and judicial branch separation of power structure under the previous constitutions. And then now we have the Constitutional Court as an independent institution and as the fourth branch of the government. 5 jurisdictions like this, very like proactive and activist court, and then these, sorry, it's kind of hard to, all right. The first 4 are so-called institutional litigation, as we call it in South Korea. Constitutionality review is initiated by the judicial court. Impeachment process is to be initiated by a National Assembly, which is the national legislative branch. Dissolution of political party is to be initiated by the executive branch, and the competence dispute, of course, is initiated by respective governmental, like both national and local governmental institutions and branches and whatnot. So the only type of adjudication available to individual private parties to have direct access to Constitutional Court for redress is the constitutional complaint. There are 2 types. So first, the constitutionality review, the review of constitutionality of statute. In South Korea, we do have specifically ex post concrete review. We don't allow ex ante abstract review. So that means you have to have a life pending case at the judicial court, very typically and mostly civil or criminal, and then either the parties to those pending cases at the judicial court or the judicial court sua sponte on its own motion may file this case for Constitutional Court's review of the constitutionality of statute with the Constitutional Court. But when in those available routes, among those available routes, when not the court itself, but the parties, either party, originally filed a motion with the residing judicial courts to please file this review case with the Constitutional Court. That judicial court may say no, may dismiss, may deny, and only in that case, so the individual parties may go directly to the Constitutional Court for its review over the constitutionality of statute. And second route for constitutional complaint is this. I'm gonna skip all the way, but I'm gonna take some time for each slide so that you could. All right, so anyone who's constitutionally endowed, guaranteed rights have been infringed by the governmental action, then will have for her or his redress of rights, have direct access to the constitutional court. But that party should have, must exhaust all of other available mechanisms before that private individual may have access to the constitutional court. And very importantly, so that may be a reference point for Indonesian Constitutional Court or any other jurisdictions if contemplating to introduce such direct application or constitutional complaint system, is that what is most important, at least in my view, is how to establish the relationship between the Constitutional Court and the ordinary judicial court. So in South Korea, for this type of constitutional complaint, a private party may not file constitutional complaint for or to ask the Constitutional Court to review the judicial court's judgment. So that is specifically excluded, because when you say your fundamental rights being restricted or infringed by governmental actions, such governmental actions should normally include all types, right? Like legislative branch, executive branch, and judicial branch. So you could even file a constitutional complaint case for legislative inaction when the Constitution provides specific fundamental rights and there is no corresponding statute previously enacted by a National Assembly. Then a party may ask National Assembly to enact such statute to actually implement such constitutionally guaranteed right. And, for example, a good example of on the executive branch side is when the prosecution's office decides not to prosecute further, right? And the constitutional complaint is available. However, the Constitution itself, Korea's Constitution itself restricts that, by providing that constitutional complaint is available to individuals in accordance with specific statutory provisions. And then the responding statute called the Constitutional Court Act of the Republic of Korea specifically says judicial judgment. Judgment of the judicial court is specifically excluded. So that's a big thing. And particularly because constitutional complaint or constitutional adjudication based on constitutional complaint is available and therefore is filed by private individuals, what becomes very important is how to provide substantively the right to assistance of counsel, because the rest of the parties are all governmental institutions, and the only type of constitutional adjudication at Korea's Constitutional Court when there is a private party, individual party, it's the constitutional complaint adjudication. So we have a separate provision for representation by counsel, mandating representation by counsel, and by that token, of course, there is this court-provided attorney system, and as in the criminal cases in the judicial court. What I want to underscore here, I'm gonna go to, what can I do? It's gone. All right, thank you so much. I'm sorry. All right, it's such small, but the horizontal part, you see all 5 different jurisdictions, and if you go towards the right, there are 2 types of constitutional complaint cases. Korean Constitutional Court entertains approximately 1,200 cases per year. And then as you see, out of such, 1,200 or so cases entertained by Korean Constitutional Court per year, close to 1,000 cases are filed in the form of constitutional complaints. I was truly impressed by the number presented yesterday by the Turkey, constitutional court of like 20,000 cases in ordinary times in 2016 through 2018 pertaining to the attempted military coup, like 70,000 cases of direct application. But in the Korean case, still you clearly see the most number of constitutional adjudication cases are filed in the form of constitutional complaint. So you have to find a way to manage from the perspective of case management and operation of the court, the way how to handle such constitutional complaint cases because you will have increase in the docket size and whatnot. So in Korea, we operate preliminary screening for all constitutional complaint cases. So 3 justices out of 9, they form a panel for preliminary screening in all constitutional complaint cases, unlike other 4 types of cases, and to decide whether or not the constitutional court will hear such constitutional complaint case en banc as preliminary session. So very importantly, there are clearly merits and demerits even in the time for Korean Constitutional Court to decide, and in the time of transitional justice. After these military coups, there were criminal litigations at the criminal court for insurrection and then the murder during military coups and whatnot raised by private individuals. And then the ordinary prescription period way past, and the National Assembly enacted a special act. And the gist was the prescription was suspended, and the constitutionality of such special acts were also challenged in the form of constitutional complaint. And the Korean Constitutional Court held such National Assembly special acts to be constitutional and whatnot. So the Constitutional Court and the constitutional complaint adjudication, they have made a great contribution in further democratization and whatnot. But I want to also raise this point that, well, even if we don't have ex ante abstract review, the Korean community is almost polarized beyond diversification these days. And it also has to do with the general election as well. Because in South Korea, as long as you secure relatively more or most number of votes, then you are elected. So very typically 25% is good enough. So the representatives at the National Assembly, the lawmaking body, just care for, I mean, it's a generalization, care for 20 or 25% of the constituents. So there is no such big incentive, because we have this belief in deliberation process and the normative political processes to handle all these disputes and conflicts in the community by way of legislation. But you can't really, if you can't really rely upon such normal political process, then, and we already see this happening in South Korea. So in a very organized way, this constitutional complaint has been used as a tool to raise political objection, criticism, and opposition by contending political groups against specific legislation that was and should have been concluded through the legislative process. And this has been causing judicialization of politics, and then it might even exacerbate the already happening politicization of the judicial court and also the constitutional court. So let's see. So what we could do, right? So diversification of required qualifications for the justices and institutionalized routes to further invite and utilize expert opinions and the effort of civil society and also academia to review close the standard of review and whatnot. So the relationship between the Constitutional Court and the Judicial Court, and how to manage the increased docket size, and the judicial expert assistant, probably you will need more, how to manage these cases, whether to introduce preliminary screening process and whatnot, or whether to allow the preliminary review from the beginning. And also there are many issues, both at the normative level and the operational level, as to the retrospective force, especially that has to do with the criminal law provisions and whatnot. So let me stop here, and then I do hope that this, specific experience of South Korea's constitutional court's experience with the constitutional complaint adjudication will help us further think about, what we expect for or from the constitutional adjudication for the purpose of rights protection, and more for how the question of how to design and fine-tune the systems for this in our respective jurisdictions. Thank you so much.
Thank you. Thank you so much, Professor Ree, for the comprehensive elaboration of constitutional adjudication on constitutional complaint, which is still unique, especially for countries which is deeply rooted in civil law tradition, especially. Okay, now it's time for the respondent to have 5 minutes each. I would like to start from Professor Villiers first. Time is yours.
Chair, thank you very much, and thank you for the paper. I read it, and I recommend that people do read it. It's a fascinating overview. There are 5 issues that arise that I would like to identify, perhaps for discussion or comment. The first is the judges of the Constitutional Court are appointed on a limited term basis. And I was wondering if that affects the independence of the court. Is there constantly an uncertainty of being recalled or an uncertainty of not being reappointed? I serve on a court that has a 5-year term, and I know myself that by the time you get to year 4.5, you start wondering, well, who's going to pay the mortgage? What's going to happen? Now, there's no political interference in Australia, but the fact is there is that uncertainty that sits over your head if you serve as a judge. For example, you have to ban a political party that is recommended by government to ban, and you vote against government. Well, is that the end of your term? So I was wondering if one could speak about that. The second point is the Constitutional Court. The point is made that the Constitutional Court, as soon as a law or a part of an act is invalidated, the entire act is invalidated, and it starts with immediate effect. And that raises 2 questions. The one is whether there should be a sunset clause. We've heard in the past few days that sometimes courts would invalidate a specific clause, but that invalidation would only take place in a year or 2's time to enable the legislature to fix the problem. And the second is, if an act is invalidated immediately, there may be a vacuum. For example, in South Africa, the Marriage Act, a certain clause of the Marriage Act did not adequately recognize some form of customary relationships. And so the court notified Parliament that this is unconstitutional and gave Parliament 2 years to fix it. Had it not done that, South Africa would have been without a Marriage Act. So I was wondering if that is something one could comment on. The third point is the power of the Constitutional Court to ban political parties. And in a certain sense, that goes right against the grain of freedom of expression, and it puts the Constitutional Court in the middle of the political debate. And I was wondering if it's not advisable that the actions of people are banned rather than the party propagating. So in other words, it becomes a criminal matter rather than a political matter. My question was whether there's any guidance in the Constitution when a political party may be banned. Is it because of propagation of hate speech, violence, and so on? And I think we've seen, South Korea isn't the only country that bans political parties. In many countries, the Communist Party, for example, has been banned. But the question remains relevant, and that is, should one ban the party which in a certain sense expresses an idea, or should one rather prosecute those who act on the encouragement of a political party, and where does that leave the Constitutional Court, specifically in the context of freedom of expression and the terms that are not necessarily guaranteed? That was my fourth point, or the third point, I think. The third one, the fourth point deals with the rights of refugees, where refugees do not have certain rights. And of course, the world nowadays is a world of refugees. Millions of people are moving, whether it's into America, into Europe, into Southern Africa, into Australia, people are moving. And to what extent is it sustainable to say that refugees do not have certain civil rights? For example, the right to education. In South Africa, there's an estimated 10 million refugees, and does one say to all of them, well, your kids don't go to school, your kids can't go, you can't go to hospital, we'll just exclude you. In Europe, there's a big debate about the rights of old minorities as far as their cultures are concerned versus the rights of new minorities. Old minorities are entitled to promote their culture, to attend schools of language education in their mother tongue, while new minorities do not have those rights. And this, of course, has a high risk of layers of people in a society, which can lead to instability. I think ultimately those were perhaps not 5 questions, but 4 questions, but those are the ones I just want to make sure there might be, I might have missed one. No, so there were 4 questions, not 5. Thank you.
Well, thank you, Professor de Villiers. And now the other 5 minutes will be given to my friend, Muhammad Mahrusari. Time is yours.
Thank you, Mr. Chairman. Itiwa Gede Malguna. This is very comprehensive and elaborative paper relating to constitutional adjudication and constitutional complaint. And I'm very glad to give the comment, but I would like to, I prefer asking the questions rather than commenting the paper, because I think the paper is an enlightening paper and presentation. So this is some like a lesson learned for Indonesian Constitutional Court to implementing the constitutional complaint. I have 3 questions. First, about the constitutional reform and institutional reform. In your paper, you mentioned that constitutional reform and institutional reform in related to constitutional complaint, it's become the 2 inseparable and fundamental element in implementing constitutional complaint. And then my question is how to make it work together or simultaneously in a new democratic state. For example, like in Indonesia, how is it possible to implement Indonesia between constitutional reform and institutional reform? And the second question is about the judicialization of politics. We know that judicial power in Korea or in Indonesia is also, there is an executive power and legislative power. And my question is about judicial independency. Is there any intervention or any intervention power from legislative or executive power relating to the constitutional complaint? So how about the judicial politics in Indonesia and in Korea? So I would like to address how in Korea prevent the intervention from another branch of power. And the last question is about the constitutional interpretation. Related to the protections of private individual constitutional fundamental rights, I wonder how the judge interpretation relating to many cases in constitutional complaint in Korean Constitutional Court. So how the judge addressed the constitutional interpretations regarding the constitutional complaint in many cases. Thank you.
Well, thank you. You're so effective with your times. And so I would like to invite 2 or more questions from both sides. And if you don't mind, we collect the question first. And from Andi Omara and Mr. Andi Omara, and back Gofar, and who's here? I'm sorry, I can read.
Sabu.
Sabu. Okay. And the last one. Who's it? Oh, Professor N. Black. Okay. I think we should use our time effectively. Please, Mr. Andi Omara.
Thank you, Mr. Chairman. You mentioned about judicialization of politics and politicization of judiciary. And times pass, when we look at some jurisdictions, some have a very strong court in the beginning. But when times goes by, there is a dynamics in how courts getting stronger or getting weaker. And my question is how, for example, the court itself or the other actor can prevent the court from a very, what we call, intrusive other branch of government interventions. I don't know whether you have that experience in South Korea, perhaps?
Gofar?
Yeah, thank you, Pak Palguna. We meet again, Professor Ri. Let's continue our discuss last night while we were waiting Pak Jokowi. Thank you very much. This is actually a very simple question. My question is about the authority of Constitutional Court of Korea. So my question is, does the Korean Constitutional Court have the authority to conduct a judicial review on the Constitution? Yes, I mentioned the Constitution, not the law, because like Indonesia doesn't have the authority. But I'm so worried in the next event or something, one day we got problem about this, the one that Parliament making like amendment our constitution without no quorum probably, just in case, and nobody, no institution doesn't have this authority for challenge. This is my question. Thank you, Pak Palguna and Professor Ri.
Next, please.
Thank you for this really very comprehensive presentation. I just have a quick question. It's very clear that there is no ex ante abstract review in Korea, but have you ever considered introducing the ex post abstract form? Thank you.
And the last from Professor Black.
Thank you. My question relates to the relationship or the conflict between the Supreme Court and the Constitutional Court. We currently have a judge from the Supreme Court of Korea with us at the moment at UQ, and he has spoken of tensions between the two courts. So could you comment on that? Thank you.
1 minute. Really 1 minute, okay?
Prof. Ri, thank you for your presentation. I would like to elaborate the aspect of constitutional complaint in South Korea and Indonesia experience. Historically, our amendment of Constitutional Court Law 2003 is added the constitutional complaint, but somehow it was cancelled. And I think there is a debate whether our court shall adopt the constitutional complaint mechanism, even though not stated with our constitution. So I think my question is, what way the complaint mechanism shall be adopted? It can be, even though it's not our constitution. Can we adopt it in our constitutional court law? I think it's our question for you. Thank you.
It's quite a delicate question. Well, now time is yours, Professor Ri.
Okay, so I'm gonna try my best to, but many questions are interrelated, so I'll try my best to answer within the time limit. So thank you so much for the questions. There are 9 constitutional court justices in South Korea, and they are appointed like 3-3-3 format. So 3 are recommended by the president, 3 by the Chief Justice of the Supreme Court, and 3 by National Assembly. And then all of them had to go through the National Assembly appointment hearing, and then had to secure approval, National Assembly approval as well. So that opens a venue for all the political parties review and the perspective coming in. And as you say, the qualifications themselves are very limited, and there have been a lot of criticisms and challenges, especially compared with the qualifications required for the Constitutional Court justices on one hand, and then the qualifications required for the justices of the Supreme Court on the other, right? They are exactly the same currently. And of course, there have been legitimate criticisms and suggestions to open up at least further, relatively further for the Constitutional Court justiceships. And there we have both age limit and 6-year term limit. And the independence issue, so we, at least like in terms of institutional mechanism, by providing all of these, prescribing all of these, we have tried to secure independence, but there's no recall system to recall Constitutional Court justices. They might be impeached by, initiated by National Assembly, but there has been no such case. 2 impeachment cases were addressed to the then incumbent nation's president. One was approved, the other denied. And also, there was an impeachment case against a high-ranking judge in the ordinary judicial courts, but never against a Constitutional Court justice. But it is available, so that's the system design. As to the there are interrelated questions as to the tensions and the relationship between the Constitutional Court and the Judicial Court, and particularly the Supreme Court as the court of last resort within the judicial court system. Korea's Constitutional Court renders a decision of constitutionality, simple unconstitutionality. But unlike German statute, comparable German statute, there is no statutory provision allowing other forms or formats of decision-making for Korea's Constitutional Court. However, ever since 1988, Korea's Constitutional Court has been issuing decisions whose holding states such and such statutory provisions are not compatible with the Constitution, and we hereby provide typically 1 year or 6 months to revise the statute at issue and whatnot. And in that case, the judicial court's exception is just a recommended way of interpreting or constructing that statutory provision. However, that doesn't bind unless it is either simple constitutionality or unconstitutionality, and especially because the Korean Constitutional Court has sometimes issued decisions saying if such a statutory provision at issue is interpreted this way, then it is constitutional, then it is unconstitutional. And in that case, clearly, the Supreme Court, particularly the Judicial Court, has denied its binding force. And this is, well, at least in my view, it has to be resolved by National Assembly legislation by revising the relevant statute, particularly the Constitutional Court Act, and then the applicable or responding statute for the judiciary as well. And as to your second question, in this context, National Assembly of Korea can clearly revise all statutes, right? Like enact and revise all statutes. That means National Assembly can always step in to revise for the jurisdiction and in further detail of the Constitutional Court as well. The qualification, as to the qualification of the Constitutional Court justices, the jurisdiction of the Constitutional Court and whatnot. But as to your specific question, when there is the Constitutional Court's decision holding a specific statute to be constitutional or conditionally constitutional or incompatible with the Constitution, therefore recommending National Assembly to revise within a specific given time limit, then, well, I have been urging for our National Assembly for a long while with some other people in academia to revise the National Assembly Act so that, when such cases, such decisions are rendered by the Constitutional Court, it should come on the calendar for expedited process for legislation and whatnot. We do have an expedited process for legislation when parties, opposition and ruling parties agree, but that doesn't include those cases for the statutory required or recommended statutory revision recommended by the Constitutional Court on the ground of incompatibility of the Constitution with the Constitution. And I think that's the first step to be done. National Assembly statutory making or revision process to be revised to allow expedited process for statutory revision in such cases. At least it should be discussed and deliberated at National Assembly within a certain period of time, especially when the Constitutional Court sets a specific time limit recommended statutory revision. For political party dissolution, there are, one specific constitutional provision in South Korea's constitution, that is Article 8, but it is very abstract. If the object and the activities of a specific political party goes against the established, libertarian democratic order, right? But as you say, there is this increased and established freedom of expression law in Korea as well. So the Korean Constitutional Court there was one political party dissolution case, dissolved political party, but Constitutional Court rarely steps in but there is this, tension between South and North Korea. So unless there is this big national security issue, the Constitutional Court has refrained itself from intruding upon the political party tenets and whatnot. Refugees and immigration issues, they have become so important in South Korea as well. So far, these issues have been dealt with in the judicial system. And of course, as the first step, our National Assembly will have to enact a relevant statute for jurisdiction and also the standing for refugees and immigrants to provide redress, legal redress and whatnot. There is one general statute, as far as I know, for this purpose, but that is at a very abstract level and it does have to be revised. NGOs and citizen groups will have they have played a very important role at least in South Korea's case to invigorate and activate the civil society to actually go file constitutional complaint cases with the Constitutional Court, especially at the early period of the Constitutional Court. So that could be, although at a very abstract level, that will help. How to invite more of the expert opinions that will help the process of discussion among the justices to issue a case. As to the judicialization of politics, it's gonna be my last answer. As to the judicialization of politics, well, I mean, to a certain extent, we cannot really help it happening. Once again, it has such an intricate relationship with the general election, institutions and whatnot, freedom of expression level in the community and everything. But when the community is more and more diversified, we still have to rely further on the normal political processes and legislation processes and whatnot. But when it's happening, well, the judicial courts may, revise and fine-tune its own organization for more independence, right? By appointment system, how to position all individual judges and whatnot. Will they apply the promotions concept or not? And the term limits, sanction system, everything will come in. Judicialization of politics have been happening in South Korea, but we really will have to see. As to this one specific question as to ex post and abstract review, there have been active discussion on it, but once again, the criticism and the opposition goes, if the legislative minorities, if we do introduce this ex post abstract review, then the concern lies in the legislative minorities of abusing this process to challenge the constitutionality. So rather than, because they will lose further lose the incentive to actively use the legislative process, right, during the legislation. But still there is an ongoing debate. So we may see this in South Korea's constitutional adjudication system.
Okay.
All right,
Okay.
we'll have to stop.
I'm sorry because of the tight schedules. Maybe some questions are left unanswered. So I'm terribly sorry for this because we have another two speakers before end of the session. Thank you, Professor Ree and Professor De Villiers and my friend, Master Sali. Yeah. Yeah. Thank you. Mahrus. Makasih. And now I would like to invite Professor Anne Black from the University of Queensland, Australia, and as well as the two respondents, Professor Engin Yildirim. I'm sorry for maybe I miss. Am I right in pronunciate your name? And Dr. Abdul Ghaffar from the Constitutional Court of the Republic of Indonesia. Would you please? Yes, the same rules applied to Professor Black. You will be given how many? 20 minutes, right? 20 minutes for presentations, and then 10 minutes for respondents, 5 minutes each of the two respondents. Well, time is yours to Professor Anne Black.
Thank you. I'm delighted to be here to meet you people and to meet with old friends as well. Now, I have the joy of teaching a course on Asian legal systems to our future lawyers in Queensland. And one thing that always strikes me is how nations with constitutional courts in Asia, South Korea, Taiwan, and of course Indonesia, always seem to be right there at the forefront of human rights protections and at ensuring fair, accountable election procedures and creating trust in their judiciary. So their constitutions seem to be seen as there for the people protecting citizens through their access to constitutional or judicial review. Now, the country that I'm going to talk about is in stark contrast to this. So this is the country of Brunei, and hopefully my PowerPoints will come up at some stage soon. Excellent. So if you've spent any time at my university, the jacarandas are now in bloom, which are beautiful, but to students it means exams are imminent. So it has sort of mixed connotations. But Brunei, because it doesn't have a constitutional court or any form of judicial review, is right down the bottom of the list alongside North Korea and China when it comes to things such as religious freedoms, press freedoms, freedom of association. So coming from a comparative law perspective, that was my background to why I was intrigued by constitutional courts in Asia. Now, Brunei Darussalam is a neighbour of Indonesia. It borders Indonesia there and also Malaysia. It's a plural nation like most of Southeast Asia, both ethnically and religiously. The majority of its citizens are Muslims and Malays, but there's a significant Chinese and other race category, and also indigenous non-Malays who still remain animistic in many ways, and also some have adopted Christianity. So that's where Brunei is. Now, there are many positives about Brunei. It's the smallest nation in Asia, but don't worry, it has the largest palace in the world. It's Asia's only absolute monarchy, and Sultan Baqir, since the passing of Queen Elizabeth, is now the longest reigning monarch in the world, so some stability there. And he's very decorated as well. And he's the second wealthiest royal ruler. He was number one, so he slipped a little. He's wealthy, his family is wealthy, his palace is magnificent, but it has also benefited the citizens. They pay no income or sales tax. They have free, comprehensive health, education, high standard tertiary education, which has led to a very well-educated population. It's a welfare state. A large proportion of the population are in secure government employment, and they get preferential government loans, housing. And the Sultan has a habit of giving gifts every now and then. There'll suddenly be 1,000 Brunei dollars in everyone's bank account. It's interesting because it has a dual system of law and courts, so we have common law sitting aside Sharia courts. And controversially, perhaps, it's the first nation in East Asia to bring in Sharia criminal law, which met with a lot of mixed responses internationally. So it's always portrayed that he's a caring, a loved figure within the country. He's always together with his people. So everyone's happy, right? Well, it's hard to know in a country like Brunei, because just like if we asked the people in North Korea, they would say they love the Kim family and in fact sort of worship them. So you can't necessarily go about the degree to which a newspaper or the government says someone's loved as necessarily reflecting the situation. So what am I concerned about? This is an affluent country, people are well educated, they seem happy, they have a sultan that loves them. Why am I thinking about a constitutional court? Well, first of all, we've got the aggregation of all power alongside all wealth in the hands of one person, the sultan. This is only possible because Brunei, the abode of peace, has been for 60 years in a state of emergency. And I doubt whether the exercise of this emergency power can in any sense be considered constitutional if you look at the provisions in the Constitution. It's never been reviewed, the emergency powers, nor is it reviewable either by the courts nor can it be debated in the legislature. So there's no checks and balances at all on aggregation and a use or abuse of power. And there's no protections for human rights. So those are my concerns. So in my paper, I've argued that the constitutionality of Brunei's perpetual state of emergency for 60 years warrants judicial review, it warrants legislative approval, it warrants some form of accountability, and also the possibility of media scrutiny. So because of this state of emergency, the Sultan has been able to assume all power and all control over the legislature, over the judiciary. Within the executive, he's not only Prime Minister, but he's Minister for Finance, External Affairs, Defence. He's the head of Islam. He appoints the members of the Religious Council. He too can issue fatwas, not just the Mufti. He's also head of the military, the Supreme Commander, and has control over the media and the censorship laws in Brunei, which are extensive. So it comes from the emergency powers. So what does the Constitution actually say? In Section 23, it provides for emergency powers when public danger is imminent, whether by war or external aggression, for the Sultan to declare a state of emergency. It then goes on to say that it cannot be enforced for more than 2 years, and when it is enforced, the Sultan can make orders whatsoever he considers desirable in the public interest, criminal and civil. So the questions that raises, let me see. First one, does Brunei meet the constitutional preconditions for a valid state of emergency under Article 83? And is automatic renewal every 2 years without reference to any of these preconditions lawful? Does the emergency warrant the cessation of elections? Because elections are provided for in the Constitution, so there has not been an election in Brunei since 1962. And why is the one check that is in Section 83, which lays any emergency proclamation, is required to be laid, in front of the Legislative Council? Why is that meaningless in effect? So dealing with the first one, the legislative scrutiny aspect, first of all, from 1962 to 2004, there was no Legislative Council, so there was no body that you could lay it before. And since 2004, all members on that council, they're not elected, they're appointed, and they serve at the Sultan's pleasure. They can be suspended or removed. He doesn't have to give a reason. They'll lose their seats if they're disloyal or disaffected to the Sultan, his family, or the state ideology. And the only quote I've ever been able to get on this from the Sultan was in an interview from 1995 when he said, "When I see evidence of a genuine interest in politics on the part of the responsible majority of Bruneians, I will consider introducing elections." In the one election that Brunei did have, it had a turnout of over 90% of the people. The trouble was, it was a leftist party and an anti-monarchy party. So that might be the reasoning behind the lack of elections. On the state of emergency, he said, they're in keeping with tradition and values of Brunei for the country's peace and stability when we face future challenges. But the Grand Mufti has said that, I won't go back to what he said, but he's reiterated that this is a peaceful, happy nation with no conflicts at all. So the next question is, there is a Supreme Court. What role does it play? Can it check any of this? Well, first of all, the Constitution says that the remedy of judicial review is and shall not be available in Brunei, and that's mirrored in several other pieces of legislation. And in addition, the Sultan has taken non-reviewable, non-appealable powers to himself to direct other courts, including the Supreme Court, about hearing cases in camera, that is closed, to hold a court proceeding at a time and venues that he orders, to not publish any judgment that may adversely lower his position or dignity, and exempt any person required by a court or who's summoned to give evidence from doing so. So those are quite extraordinary powers. So what about constitutional interpretation in Brunei? Well, first of all, the Legislative Council doesn't have to give consent to it. The Sultan is the only one who can amend or revoke or change the Constitution in any way. So no debate, no referendum. He is required to consult his Privy Council, but he appoints everyone to his Privy Council, and the majority of them are his sons. So there was also, yes, amending the Constitution I've mentioned, okay. So why look at a constitutional court when we have already a Supreme Court, a superior court? One reason I think perhaps is that the failure of the Supreme Court, not its failure, but its inability to conduct judicial review or to review the Constitution, means that the court hasn't developed that concept or isn't regarded as a guarantor or protector of individual rights. It doesn't have that standing. It's a very efficient court. It's great for commercial and criminal cases, but it doesn't go further to the human rights protection. Also, the common law doesn't have abstract review, and perhaps in a country like Brunei, which is generally non-litigious, that a constitutional court with abstract review might resonate better. The third and most important one, I think, is that with changes happening in Brunei, the common law is no longer the main source of law in the country. The Sharia court now mirrors the common law court, including in criminal law, which is quite a confusing issue, which I won't go into, when you can be tried for murder in two possible courts and you're not sure which one it's going to be. Also, I've noticed that many Muslim nations which do have dual system of laws and also have monarchies or family rule do have constitutional courts. So that seems to be a model that resonates perhaps with dual courts. And also it'd be a way that the many reservations entered by Brunei on Sharia grounds for UN and international treaties could be checked as to their validity of the claims made. What are the prospects? Well, not very high. It's unlikely in the lifetime of the current Sultan. Obviously, the Sultan, the royal family and the elites benefit greatly from this continual state of emergency and from the form of autocratic paternalistic government. They've created a whole ideology that legitimises what they do, drawing on Islam and Brunei's Malay tradition, saying this is what we do in our country. And currently, actually, if it did happen, it would probably be another tool for the Sultan to control. He would appoint every member of the Constitutional Court and would make them subject to the same limitations that already exist with the Supreme Court. But circumstances change. Economically, geopolitically, oil and gas isn't quite as profitable now, perhaps, as it once was, and circumstances can change within royal families. And so the future might be different. This is the Crown Prince who's waiting in the wings. Time will tell. But I think the debate is one that's worth having, especially in this region, because too often Brunei, because of its smallness and because of its wealth, just flies under the radar for debate. So in conclusion, I want to thank all of you from the committee for this opportunity to be here with you today.
Well, thank you very much, Professor Black, for the effective time you given to present your quite comprehensive paper. Now, we have 5 minutes each, and we would like to start from Professor Engin Yildirim from the Constitutional Court of the Republic of Turkey. 5 minutes is yours.
Okay. Thank you. In the 60s, as we all know, radicals was saying that be realistic, ask the impossible, ask for the impossible. So I think we should be realistic when we think about whether a constitutional court may be established in the Sultanate of Brunei. The paper discusses whether a constitutional court may be set up in this country where an absolute monarch rules on the basis of a theocratic understanding of governance. The paper examines political, economic, and social conditions that may act against or facilitate a transition from an absolute monarchy to constitutional monarchy if an independent constitutional court was set up. Brunei has been governed under a state of emergency for more than 60 years, enabling the Sultan to sustain his power without any serious challenge. A constitutional court may first examine, as the paper argued, the legality of this state of emergency, this seemingly never-ending state of emergency in the country. Although there are some judicial or quasi-judicial bodies that may act against a check and balance force against the Sultan, they don't seem to be effective. So there is an urgent need for a constitutional court or for a peak court that would act against checking the power of absolute monarch. But in my personal opinion, as long as Sharia continues to be a source of law in Brunei, even if they set up a constitutional court, prospects for a rule of law, separation of powers, check and balances, and protection of human rights seem to me bleak. The paper suggests that there are Muslim nations whose one of the source of law is Sharia, religious law, and ruled by a monarch. Brunei can draw on their experiences, but it seems to me, with some exceptions, the experience of these countries don't seem to be very inspiring for a country to become modernized in terms of human rights and rule of law. And Brunei Constitution currently doesn't have any protections for human rights, as far as I know, with the exception of freedom of religion. But even in that right is only recognized for Muslims. And even within the Muslim community, if you have some heretical views or some dissenting views, some views separating from the dominant religious interpretations, you are unable to benefit from the freedom of religion secured by the Brunei Constitution. Brunei seems not to recognize human rights as a universal value. It reminds me that back in the early 90s, the debate about Asian values initiated by the Prime Minister of Singapore, as far as I can remember. So Brunei government or community or people or nation claims they have a different understanding of human rights based on community rather than individual rights. So there is a fundamental clash between the universal understanding of human rights based on individualism and what Brunei, in the majority people or the government, understands what human rights is. And this is not an easy conflict to be solved. It's one of the fundamental conflicts, and as long as they claim they have different rules, different ideas, different values, I wouldn't be very optimistic, even if an independent constitutional court is set up in Brunei to protect fundamental rights. That's last. And I would suggest and would discuss Ron Hill's, I hope I pronounced his surname correctly, hegemonic preservation thesis, according to which an anti-democratic elite establishes constitutional court or peak court if they feel that they are about to lose power, so that they seek to preserve their privilege against incoming new elites. So they establish constitutional courts, they write its rules, they appoint their members, so they create courts to have a kind of ally if things go wrong for them. This is my main suggestion to them.
Okay, thank you very much, Professor Yildirim. We give you another 1 minute because, yeah, we have 2.5 minutes left because of the effective presentation of Professor Black. Now, time is to my friend, Dr. Abdul Ghaffar from the Constitutional Court of the Republic of Indonesia. Please.
Thank you, Chairman Pak Palguna. Hello, good morning, everybody. It's an honor to me for attending here. And Professor N, I really enjoy your paper and your presentation. It's really enlightening, especially for me. And I have to say that actually I never studied about Brunei, even the country is on the same island with Indonesia, but I don't know, probably because this is also different legal system. So that's why I really thank you, Professor N. You already pushed me last night for reading the constitution, the Brunei constitution, just making me understand what it happened. And also I already read the Saudi Arabia constitution. I just want to compare because both of them are the same. The monarchy country is really different with Indonesia, a republic, and also presidential system. I have noted from your paper, Professor N, that Brunei Darussalam has had a state emergency since 1962, since the rebellion carried out by PRB. And because of the rebellion, Sultan Omar had risen and constitutional ground to declare the country in the state emergency that threatened the security and economy of Brunei. But unfortunately, you mentioned like that, the state emergency continued for 6 decades later, and the status was renewed again in 2021. With such a status, the Sultan Brunei hold the highest power. I mean that all of the branches of power holding by the Sultan. I have probably a question. Yeah, I don't have comment, Prof. And this is a really comprehensive paper. I just want to ask. First, in a country that implement an absolute monarchy system, will always give full power to one person. Like I mentioned before that already, read Saudi Arabia constitution also. And when I read the Brunei constitution, I also remember that no one chapter mentioned about the court in the Brunei Darussalam constitution. There, namely if the Sultan or King or other designation, this means that without the status as an emergency state, the Sultan of Brunei can still control all power. Yeah. As in Saudi Arabia, like I mentioned before, the king has unlimited power even though this country has a constitution. And the second thing, the second one, I totally agree with your opinion that constitutional court is very much needed by Brunei Darussalam, but is it possible to do this? This is my question. While institutions such as parliament have not been given independence by the Sultan. And the other one, the third one, why in your paper you don't discuss the success story of the countries in the modern era which were originally in the form absolutely monarchy and then become constitutional monarchy that put the king or sultan only as a symbol of the state, because as long as the situation in Brunei Darussalam is still as it is today, the hope of having a constitutional court will only be, I say that, like a dream. But probably I do mistake, I'm sorry. Fourth, the last one, Professor N, as far as I know, the Constitutional Court, which was established separately from the Supreme Court, is usually carried out by the countries that previously had authoritarian government, such as the former Soviet Union countries, and some another one is Latin America countries, and also including Indonesia after the end of the Suharto government. So, therefore, the desire to export the Constitutional Court to Brunei Darussalam is very likely to happen if the country succeeds in getting out of absolute monarchy system. However, if I'm wrong, really please correct me, Professor N. Learning from many countries, including Indonesia, the change in the new government regime will occur at least two factors, namely if there is a crisis, such as a financial crisis or a security crisis due to rebellion, or be very difficult to change the rebellion or attack from other countries, sorry. And as long as these two things don't happen, it will be very difficult to change the government system and course the legal system in Brunei Darussalam. Meanwhile, according to your paper, the people Brunei are prosperous. And thank you, the time is over also. Thank you, Pak Balkuna and Professor N, really sorry. Thank you.
Because the gong has hit your head.
Yeah, one more. Thank you.
Yeah, thank you. If you don't mind, Professor Black, I would like to collect two more questions from both sides of Professor Warren first, yes, and yes, you, Professor. Okay, three. Professor Cohen and Professor Saldi Isla, the last respondent. The last question from Professor Saldi Isla. Start with Professor Warren first.
So I don't mean to be controversial, but it sounds like everyone is pretty pessimistic about the possibility of setting up a constitutional court in Brunei, but it sounds like maybe for different reasons, and that's just what I want to ask about. So I'm wondering whether there is a predetermined content, substantive content that has to exist before it is possible to set up a constitutional court, because if I'm understanding correctly, the speaker has said that in the current situation, the structural prerequisites may not exist to set the court up. I wonder if there's a difference between creating just the institution itself, just the court, or whether the issue is setting up an effective court that will address the issues that we care about. And the reason that I'm asking is it sounds like Professor Yildirim is saying that, and I could be very wrong about this, so please correct me, that as long as there is Islamic criminal jurisdiction, that it's not possible to set up a constitutional court. And I just wonder if that's putting the cart before the horse, you know, that you could set it up, but you may not like what it does. And I wonder if there's a difference there.
Next, Professor Cohen.
Thank you very much. So I wanted to take the floor to thank you so much for this fascinating paper. It is so enriching in legal culture. I absolutely had very little knowledge of Brunei, so thank you for sharing this with us. I find it very interesting how we can look at this case study that has been this autocratic system for so long, where we're in a time at this point where we talk about emerging authoritarian regimes. And, I think about how this example might, roll on and have the domino effect on these emerging authoritarian regimes. So here's my comment and question to you, which kind of builds on the respondents and the question that we just heard from Professor Warren. I'm wondering, what are the odds, in your view, as you're the expert in this question, of creating the Constitutional Court, and that such court could actually have the effect that we're all discussing this morning in terms of constitutional review and moving forward in terms of the constitutional reality of the country. So thank you.
Okay. The last, Professor Saldi Isra from the Constitutional Court of the Republic of Indonesia.
Thank you, Pak Palguna, moderators. I followed the session from the back of the room, and I always follow. That is quite interesting topic, Professor Ant. If we looking from the historical background, Brunei come from Malaysia. Malaysia also from UK. There's two countries, there is no what we call the concept of judicial review. Then you propose that it's possible for the Brunei to build like constitutional court in Brunei. Can you explain us what the very specific things that you find so far that quite possible for Brunei to establish the constitutional court? First. The second one, is it possible to establish the constitutional court in the absolute monarchy like in Brunei? Then I do believe if there is the fundamental change, like what you saw in the last PowerPoint, for the next generations, is the picture of the prince. Is it the significant factor, or it is depend on the hand, the God? Thank you.
Okay, thank you. Yes, there is an interesting question, as well as intriguing. Is this possible to export a constitutional court, constitutional justice to a country where the Sultan is only accountable to God the Almighty? That's the point, I think, from Professor Sardi Isra, the last question. Now, it's 10 minutes is yours, Professor Black, please.
Thank you, everyone. I think it's important that I'm able to speak at a venue like this because the censorship and media laws in Brunei mean that academics and speakers from the country don't have the sort of freedoms that we do here. So it's wonderful that neighbouring countries like Indonesia and Malaysia have a very different legal and political culture. So thank you for your comments. You're the expert on emergency declarations, and I tend to agree with you that currently if one was appointed, it would be misused and it would be done to ensure that any abuses that have taken place thus far are not adjudicated by the court. So I do have I share that cynicism at the moment. And thank you, Dr. Abdul, too, for your question. And essentially all of you are saying the same thing, really, is this really possible? Is this just pie in the sky kind of thinking for there to be a constitutional court? Perhaps, I don't know, but I'm inspired by what's happened in other countries, because if I'd looked at Indonesia, say 40 years ago, I may have thought the same thing about authoritarianism here. And similarly, if I'd looked at North Korea and Taiwan. So circumstances change, and when there are ideas out there, perhaps when the time is right, this can happen. Now, it's not going to happen with an absolute monarchy. It's just impossible, isn't it? It has to be a move to a constitutional monarchy. And the question that I think it was Professor Warren raised about, or perhaps it was Professor Cohen, I'm not sure, how realistic is it that there could be a constitutional monarch, and in that transition period there could be something like a constitutional court? Does it just have to be a constitutional court? No. It could be the current Supreme Court if it could change. I just think its history now is so associated with economic outcomes. It's a very efficient court. It's good at protecting contractual rights, these sorts of things, corporations. It's retained its appeal to the Privy Council in the House of Lords for commercial matters. It's individual issues and freedom of religion, freedom of speech, freedom of association. I mean, why? You could not have a constitutional court, I don't think, until you had some kind of elections happening in Brunei. And the Constitution provides for elections, and the only reason why there aren't elections in this affluent, well-educated population has to be to retain royal families' power. There can be absolutely no other explanation for it and for the state of emergency. I think Dr. Abdul perhaps mentioned or someone else mentioned the Asian values and the communitarian versus individual rights. Is Asia so different? Maybe it is, but let the people decide. Let's have a vote on it. If those are if that's the sorts of restrictions that they want, if they want these censorship laws, if they agree with some of the sort of Asian approaches, then let this come through the elected representatives in a legislative council. Let's just not have it dictated to by everyone who's appointed by the Sultan. And I think, to end on the point about God the Almighty, the Sultan says everything he does, he's not doing for any other reason but to please God. But it's a very well-defined, crafted form of God. It's not the God of Islam that's wide-reaching, embracing, looks after rich and poor, people of all races, all schools of Islam. It's not that sort of God that you have in Brunei. It's one that tells you, you must pray or you'll be fined. You must do this or there will be certain consequences. So it's the state dictating your faith to you and the very kind of Islam that you can practice, which is as concerning as the restrictions on other religions. You can't be the sort of Muslim you choose to be in Brunei. You have to be the sort of Muslim that the Sultan tells you or the ruling elites tell you you must be. And that, I think, is problematic. Have I covered it? I think I've probably covered the main points that you've raised. Thank you.
We still have a few minutes to answer the question from Professor Sardi. I think whether Brunei, Malaysia, and UK has the same route, which is not familiar with the concept of judicial review.
No, that's not correct. Judicial review is embedded in the common law, and we have judicial review. We've got people from Australia, South Africa, Canada. Judicial review is part and parcel of the powers that come with a Supreme Court. So the Superior Court, part of their jurisdiction, will always encompass judicial review, and Brunei has claimed an exemption from that. So judicial review happens in Malaysia, in their highest court as well, at their apex court. So it's not an alien concept to the common law, but what they have in common is during the British residency period, that sort of authoritarian control resided with the resident, the British appointed resident, a bit like a governor. And so it was easy then to transfer that kind of power within Brunei, much against the wishes of Britain, but they acquiesced. The other sort of main thing, I think, is it's unfortunate that elections, I wouldn't be having this talk today if there had been elected representatives. If this had been the choice of the people of Brunei, then that would be a different question, but we'll never know. That's all.
Okay. Thank you, Professor Black, and the two respondents of the second part of the third session. And thank you. Go far, thank you. And yeah. Okay. Yeah, okay. Well, before we start with the third speaker, I would like to say welcome to Pak Daniel, the Constitutional Justice of the Republic of Indonesia. Welcome to the show. Okay. And now I would like to invite the third speaker of the session from the University of Jember, the eastern tip of Java, my friend, whether Mas Bayu or Rian Adivira Prabowo. Rian Adivira Prabowo, please. I would like to invite you to present your papers. And the two respondents, Professor Zabo from the Karoli Gaspar University of the Reformed Church in Hungary. The first would be the first respondent, and the second respondent is Intan Permata Putri from the Constitutional Court of the Republic of Indonesia. Where are you, Intan? Oh yeah, here. Intan Permata Putri. It is mean the, Intan Permata Putri, the girl who is like a diamond. Yes. Yeah. You have 20 minutes as the other speakers. Yeah. This is a young man from the eastern part of Java, from University of Jember. Time will be yours. Rian Adivira Prabowo, 20 minutes.
May I start?
Yeah. Please.
Okay, thank you. That introduction part is quite something. Okay, thank you, Pak Palguna, former Constitutional Court Justice, who is also chaired this session. And also I saw Pak Arjono over there, former Constitutional Court, and Justice Daniel Yusmik and Justice Saldi Isra. It's such an honor for me to be here. Distinguished speakers, committee, attendants, either online or offline of this conference. Good morning, selamat pagi. I'm delighted to be here. Yeah, that's my file. So, okay. Ladies and gentlemen, I'm Rian, and I'm here on the behalf of my team, consists of my dean, Prof. Bayu, Izin Prof, and also my colleague, Mas Nandu, over there. Izin ya, Mas. Yeah, and I just found out that sitting here can be so scary because I'm sit next to the someone like Pak Palguna, and this is my first experience. But anyway, show must go on. And challenge should be accepted.
Be careful, that's Queen song.
Sorry, what? Okay. Thank you, Pak Palguna. Yeah. Before getting started, I want to address that not far from here, still in this island, more or less an hour driving by car, there is a humble space, a garden, small garden, named Taman 65, 65 Garden. This garden was made to commemorate the bloody transition during the 60s from Sukarno to Orde Baru regime. And carved within this small garden is these words, forgive but never forget. And I was there once, and I think that those words, forgive but never forget, has some kind of message or ambience to the topic that we brought in this paper. Forgive but never forget. That's garden is in Bali. If you have time, probably you can visit there. The premise of this paper, of our paper, is actually quite simple. We just want to measure how far the Mahkamah Konstitusi or our constitutional court could play a role as conflict resolution body in post-authoritarian society in solving problems left out from our predecessor. As stated yesterday by Pak Andi Omara, we have violences committed during the Orde Baru regime, and long story short, the final resolution on how we should deal with the inherited wound from the past is still out of sight. So that's the sad part. And then let's, turn our machine on a bit, and because I just want to, to put it in context. In the late 90s, the demand to end the authoritarian regime was at peak, with human rights was one of the leitmotif for the social movement. And then the new era of reformasi began. Indonesia entered a new democratic era, installing democratic institutions. One of them is the Mahkamah of our Mahkamah Konstitusi, and also enacting human rights laws. And then the Mahkamah Konstitusi, to be more specific, in a quite short period of time, was able to answer the expectation, the public expectation, and also gaining a lot of reputation. It has gained emblems as the guardian of a constitution, the final interpreter of constitution, the guardian of human rights, and so on and so on. I cannot say the long list of the emblems. But then this question lingers in our mind, like how far the court could contribute to the complex and politically sensitive cases of our transitional justice problem. Like, can the court solve in a broader terms, in the our transitional justice, half-hearted transitional justice policies? Okay, that's the background. Yeah, transitional justice. So, before going further into what can the court do for for our transitional justice, I want to do a bit of detour for your information and also to, continue the yesterday's presentation by Pak Andi Omara. In our Indonesian context, we have two transitional justice mechanisms. The first one is the judicial mechanism through human rights court law, and then the second one is through the extrajudicial mechanism or non-judicial mechanism through reconciliation. Both laws are filed to the Mahkamah Konstitusi, to the Constitutional Court, and then the court has their decisions, and this is their decisions. Next, I hope it's not too small. This is what? This is an interesting decision because in our 1945 Constitution, we have Article 28I, paragraph 1, which stated that that someone should not be punished with a retroactive law. So that's the one article, and then the other article, Article 28J, paragraph 2, stated that any rights can be limited. On those two articles, Mahkamah, has kind of shifting interpretation, which one should come first. The court has shifted their interpretation and in which article should come first. The article, the non-dirigible rights within the Article 28I, paragraph 1, or the limiting rights of the 28J, paragraph 2. In the East Timor case, it was the era of Pak Palguna. I hope I'm not reading it. I hope I'm not mistaken. Anyway, this decision stated that it justified the retroactive laws in our human rights court law. So the court basically stated that yes, it is justified because the Article 28J, paragraph 2, is in a superior position compared to the Article 28I, paragraph 1. I mean, the limited rights the limitation of rights is more superior than the non-dirigible rights. That's the 2004 decision. Now, previously in 2003, in a Bali bombing case, because at the time the government enacting a Perpu, emergency decree, which punished the perpetrator of the Bali bombing with the retroactive laws. And the Mahkamah stated that, by quoting the experts, the statement of expert at that time, Professor Maria Farida, which later became justice in the next period, the court stated that it would mean slicing its own flesh. So in 2003, the court argued that the non-dirigible principle is in a higher position compared to the limitation of rights. So it means there is a changing interpretation on which came first, the limitation of rights or the... but the bottom line is this. I can understand why the court did this, because they want to defending the human rights court law to punish the perpetrator from the previous regime. So they did change the interpretation, but they did it in a good ways. I mean, in a good intention to protect to combating impunity. Okay, next. Okay, and then that's the judicial mechanism, and then the other one is through the non-judicial mechanism. I think this part is already presented by Pak Andi Omara yesterday. It's such a great help for our paper here, and save your time for lunch. okay, the court nullified the law in its entirety. So, and for until now we don't have new TRC laws, KKR laws.
I'm the only one. I'm the only
Yes.
dissenter.
Yes, I even remember what you said in the dissent, in your dissent opinion. You said that it's better to have flawless law rather than not having it at all in the last paragraph. Yeah, I really appreciate and I can understand your position as well. Yeah, but what you want to emphasize in this part is actually that even though the court nullified the entire law, it also providing guidelines as presented by Pak Andi Omara. He stated that the emergence of the state obligation to provide reparation and also to punish the perpetrator, and then in regards with amnesty, how the amnesty should be conducted. It should not be granted in respect for the gross violation of human rights. It can be granted in some part, but not to the in another part. And then the court even giving options through legal policies and also the political policies. Yeah, that's what also Pak Andi Omara said yesterday. And then this is the problem. Even though the court already made their stance on what's the reconciliation mean and also on how to combating the impunity, but the problem is this still. Those two decisions, it's still not being materialized yet. In Indonesia, we have slang for Mahkamah Konstitusi as the owner of the power of itu geni. Itu geni is spit of fire, yeah. Like everything that they say should be happen in reality. But in this specific case of transitional justice, I think it's still out of sight what kind of justice will the victims and also perpetrator receive, because the decisions granted by the court is not yet materialized in a real policies. So yeah, that's the bottom line. And this part is more. This part is more of a provocation rather than study, because a lot of scholars, a lot of intellectual pundit already say that Indonesia democracy is in a decline. One of the pundit is here with us, Pak Mas Herlambang, and also Thomas Power and others. But what we want to say is this: that if we want to prove otherwise, then the bridge should be made to translate the court decision into action. And in the recent development, and also already stated by Pak Andi Omara, during the president has delivered his speech on 16th of August, one day before the commemoration of our Independence Day in this year, and also enacting President Decree of 17, 2022. But the problem still the same. Will it be an effective measure? And also it's already 2 decades after the fall of the New Order regime, our previous authoritarian regime. And after this long 2 decades, a lot of victims and also perpetrators are already passing away. I mean, most of them are died already, and they died with their memories, not that their memory is not being part of this nation identity and so on and so on. So it means that this is a case of the half-hearted transitional justice in Indonesia. Where on the one hand we are installing a lot of democratic institutions, including Mahkamah Konstitusi, and even Mahkamah Konstitusi already granting their decisions. But on the other hand, the itu geni is not materialized. I'm so sorry for Pak Parguna and Pak Arjono. Okay, but okay, so to conclude, can the Constitutional Court be called as conflict resolution body? Yeah. The answer is twofold. On the one hand, the court already made their decisions, but on the other hand, the original conflict or the people in the fleet in the field they did not enjoy the justice that they should. The justice has not been delivered. Justice delayed, justice denied. Until when, we don't know. For last but not least, I want to to throw some kind of provocation, like, are we brave enough to forgiving without forgetting? That's my response to the president decree that stated by Pak Jokowi in 16th of August. Okay, that's all I think for me. Thank you for the opportunity, Pak Palguna.
Thank you very much. I feel like that the speaker would like reluctantly would like to say whether the court is part of the solution or part of the problem. But thank you for the great presentation. And now 5 minutes will be given to Professor Sabo from Hungary, the Karoli Gaspar University of the Reformed Church of Hungary.
Thank you, Chairman, and thank you very much for this very interesting paper, which I enjoyed reading, and I learned a lot from that. I don't know too much about post-conflict resolution. I studied into the Bosnia-Herzegovina case, so this is where I have some knowledge and experience. And the biggest value, or one of the biggest values of this paper, is the openness, how it openly shows the frustration of this whole issue, and this should be definitely kept. I have some concerns about the role of the courts as the writers, the authors. The court is not per se a conflict resolution body. Courts have to decide, as we heard from Professor Pertain this morning. They are sometimes reluctant to do that, and courts sometimes want that both parties are happy at the end of the day. But this is not their commitment. This is part of the salaries of the judges to find somebody guilty. And my concern is whether or not this is a task of the Constitutional Court. As I understood the Indonesian case, there is no constitutional complaint, which means that the individual cases, these kinds of reparations which are missing in Indonesia, should have been done by ordinary courts. For some reason, this was not the case, and the Constitutional Court can, of course, repeal the underlying legislation on a popular complaint. But sometimes it happens, sometimes it doesn't. And it is, I think, it shows a real braveness from the side of the authors to reveal this. And my question would be, what institutional solution can be recommended to overcome this stalemate? I mean, what kind of institutional change, the introduction of a new constitutional procedure, for example, or a new institution would help to come out of this situation. Sometimes it is a default reaction to establish a court. Like when there's a problem, the number one default advice, establish a committee. This is not necessarily the solution. It's not like more parliaments, more democracy, more courts, automatically more justice. So these were my thoughts, which arised while reading this excellent paper. There is some slight room remaining still to improve, but I wrote it down in my written comments, and I don't want to go into it now. Thank you so much.
Okay. Thank you, Professor Sabo. And the other 5 minutes would be for Intan Permata Putri from the Constitutional Court of at the Republic of Indonesia. Time is yours.
Thank you, sir. Okay. Congratulations for the presentation, but it will be ended. And I will deliver my questions. It will be short and gentle, I guess, so don't be worried, sir. And I read your paper, and I will straight to the point. You have some idea, and I highlight this point to remain. Constitutional Court has a rule as a conflict resolution institution. In your paper, it has 2 points. It has successfully defended the non-retroactive clause within the Act number 26 in 2000, and it also provides a legal foundation for the future reconciliation agenda through legal and political policy. And you also mentioned 3 decisions or cases which have constitutional issue for derogative nature for non-retroactive principle in implementation process. And the court decided that it is constitutional to protect civilians for severe violation of human rights. And for certain issue, these violences happen in Suharto era. And the characteristic of the decision of the Constitutional Court as a dispute settlement, it necessary guarantee that the winning cannot immediately receive the justice. And it's for the future cases, it's pattern, it's a solution for your paper. And the court has potential cases for conflict settlement in electoral dispute, and then judicial review for protection constitutional rights of civilian, of course. Constitutional Court also possess as a rule of enforce and protect of human rights. But it has some obstacles. It will about the political dimension, and it should be considered to be impartial, but in reason maybe, I found it in a paper, but you didn't comment in your presentation. It's about impartiality, and I will ask about your opinion. I thought you were here and know about the recent phenomenon about the switch of justice, our justice, and that how could Constitutional Court especially has to be impartial, because they do not have power to enforce it in itself. And I have several another questions. What's the different role of Constitutional Court as a protection constitution and conflict resolution institutions? And the last, what about the impartiality of the court? You know the issue. And I have another topic such as separation conflict, and then self-governing of new local territory, I mean, pemekaran. It has a seed of separation, I think, and that's all I have. Maybe as a team or as individual, you can respond to my questions. Thank you, sir.
I would like to stress the one before the last question, because we have a kind of a kind of indecent encroachment to the constitutional court by the legislative body. But it's not my duty to answer the question. It's the duty of the speakers. So I will left 5 minutes. Sorry, before we proceed with the discussion, I have given a sweet whisper from the committee that the session should not exceed 12:30. So I think 5 minutes for the speaker to respond both of the respondents. Now the 5 minutes is yours.
Sure. Thank you, Pak Kuna. Those are hard questions. If you ever see the Who Wants to Be a Millionaire, there should be a call of friend or what is it? Ask the audience or 50-50 or something. But this is a seminar, so I should answer the questions. The first one, thank you for the respondents, both of you. For the first question, what's the institutional solution for our half-hearted, transitional justice? The answer is quite simple, actually. The court already hinted the guidelines on how the future TRC should be formed. At least from our interpretation, there should be four of it. Like the first one is TRC with the subpoena law, like in South Africa, and then the second one is subpoena without TRC without the subpoena law, like what happened in Chile, and also political policies through general rehabilitation and general amnesty, and also the last one, because the court stated that among others in their decision, it means that there is also open another way to achieve reconciliation. Then it should be another temporary measures like the step that is now currently being taken by our president in the formation of the task force for the gross violation of human rights. I think that can be categorized as in the fourth option. That's the thing, and then that's a really interesting question, because it also relates with what Pak Andi Omara said yesterday about the unintentionally something about the unintended consequences. Yeah, but the same decision actually were also decided by the court in the decision in 2015. Mas Herlambang again also was an expert in that case about the human rights court law. The court has kind of not split decision, but on the one hand they say that the procedural law within the human rights court law is okay, but on the other hand the court also said that the legislative should fix the shortcoming between the Komnas HAM, our National Human Rights Commission, and with the General Prosecutor. So that's based from Pak Omara point of view. If we put it in that decision, that also unintended consequences, because the court can also decide with the conditionally constitutional as well. That's the from the first question, and then from Mbak Diamond, from Bu Intan, it's really hard, and it goes beyond our research to comment on what happened in between the legislative and also the constitutional court right now. But anyway, this afternoon there will be a very interesting paper by Max Stauer, if I'm not mistaken, by Max, about how the constitutional court could play a role in a declining democracy, in a hostile democratic environment. So I think perhaps we can do. Perhaps there are some hints in his presentation. So it's not my.
To be bridge in troubled water.
Yeah. Besides, there's also another works already committed by the Sebastian Pompe and also Lisa Hilping and others. I think we can gain some wisdom in that kind of works. That's about I think that's answer both of her question about either the independency of the court and also about about the conflicts between, the legislative and our court. Thank you, Pak Palguna.
Yeah, thank you. Old saying says that the most vicious terrorist is time. So it is about time to end the session. And thank you very much for all the speakers and respondents during the session. And I would like to apologize for all of my shortcomings. And see you next session. Maybe will be chaired by another person. But the last words I would like to say is, please don't mix up the speaker with Axl Rose from Guns N' Roses because of his hair. Thank you very much. Yes. Would you, from the committee, would give another kind of announcement first before? Oh yeah, I would like to. Now it's the end of the session. It is time to Mary to say something for us.
Yes, thank you so much, Dr. I. Gede Palguna, distinguished chair, distinguished speaker, respondents, and all participants. This is the end of our second session. What a very fruitful discussion, half-day discussion. It is now your break time. We have some announcement for you. The lunch will be available at Singaraja Hall, the second floor, the similar place as the place yesterday. And you are very expected to return to this meeting room at 1:30. So it's gonna be pretty brief lunch. I hope it's gonna be enough for all of you to take your lunch and pray and also take a break. We'll be starting again in the next 1 hour. Thank you so much for your kind attention and cooperation. See you in the third session. Wassalamualaikum warahmatullahi wabarakatuh. Okay, there is another announcement that we have to inform you for all speakers or chairs that want to reimburse your ticket. You can contact our committee, Selma Adana or Rosmalina, in the committee desk, in the corner of this meeting room behind our board. But if it's gonna decrease your lunch time, then it's gonna be better for you to reimburse later after the conference. I think it's gonna be more convenience for you to reimburse later. It's only 1 hour time. Boleh, silakan. Safe, aman. Terima kasih.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangin. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange.
The 5th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, Bali in 2019, and Bandung in 2021, the Constitutional Court of the Republic of Indonesia will hold the 5th Indonesian Constitutional Court International Symposium in Bali over October 5 to 7, 2022.
Here are speakers of the 5th Indonesian Constitutional Court International Symposium, ICCIS. Dr. Suhartoyo, SHMH, Constitutional Court of the Republic of Indonesia. Professor Dr. Saldi Isra, SHMPA, Constitutional Court of the Republic of Indonesia. Dr. Daniel Yusmik Pancastakifweh, SHMH, Constitutional Court of the Republic of Indonesia. Professor Engin Yildirim, Turkish Constitutional Court, Turkey. Professor Bertus de Villiers, State Administrative Tribunal and Curtin University Law School, Australia. Professor Christy S. Warren, Center for Comparative Legal Studies and Post-Conflict Peace Building, William and Mary Law School, USA. Professor Roy Andrew Pertain, University of Aberdeen, Scotland. Professor Woo Young Ri, Seoul National University School of Law, the Republic of Korea. Professor Bayu Dwi Anggono, Faculty of Law, University of Jember, Indonesia. Dr. Anne Black, T.C. Burns School of Law, University of Queensland, Australia. Dr. Michael Fahias, The Hague University of Applied Sciences, the Netherlands. Dr. Miriam Cohen, University of Montreal, Canada. Andi Omara, PhD, Gajah Mada University
from the
School of Law,
which is a
Yogyakarta,
journal of
Indonesia.
international repute.
Muhammad Mofa Al-Afghani, PhD, Ibnu Khaldun Bogor University, Indonesia. Max Taylor, PhD, OP Jindal Global University, Jindal Global Law School, India. Tholt Thabo, PhD, Karoli Gaspar University of the Reformed Church, Hungary. Dr. Yance Arizona, Gajah Mada University School of Law, Yogyakarta, Indonesia. Dr. Rosa Ristawati, Faculty of Law, Erlangga University, Indonesia. Dr. Radian Salman, Faculty of Law, Erlangga University, Surabaya, Indonesia. Sarah Michelle Vincent Wright, LLD, Faculty of Law of Université de Montréal, Canada. Umi Iliana, Independent Researcher, Advocate, Indonesia. Rian Adivira Prabowo, Faculty of Law, University of Jember, Indonesia. Nando Yusel Mardika, Faculty of Law, University of Jember, Indonesia.
Under a clear blue sky and a vast expanse of lush land spanning hundreds of miles. Clusters of beautiful islands from Sabang to Merauke. Natural wealth abounds. Illuminated by the sun's warm light from the eastern horizon and full moonlight when night falls. People of various religions and beliefs coexist. United hand in hand. diverse religions, beliefs, languages, customs, and cultures live in harmony. Tolerance, mutual cooperation, and respect reflect tradition and essence of life. Panchasila is constantly observed as the foundation of state life. As an ideology, Panchasila guides the nation to its goals. The values of nature. People and religion are upheld. And a lovely and peaceful symphony. On a land on which God bestowed his blessings. Indonesia.
Tes 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 tes. Tes tes tes. Tes 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 tes. Tes tes. Tes tes. Tes tes. Tes tes. Tes. Tes tes. Tes tes tes. tes.
Cik 1.
Cek 1 2 3 tes. Cek 1 2 3 tes. Tes.
Good afternoon, ladies and gentlemen. Welcome back to our fourth sessions of the 5th Indonesian Constitutional Court International Symposium, ICCIS. Distinguished chair, distinguished speakers, all respondents and online participants, we will start our next sessions. And again, we would like to invite Mrs. Diana Puspitawari, PhD, to again lead or moderate the next session. Mrs. Diana Puspitawari, PhD, the time is yours.
Okay, thank you, Mary. Hello, everyone. Hello again. This is actually Mariel's session. This morning, I was just replacing my chair colleague from Universitas Gadjah Mada. So this afternoon, we have like the same as what we done in these 2 days. We have 3 speakers. Each speaker we have 2 respondents, and that's question and answer for 10 minutes. So without further ado, I was just going to welcome Professor Miriam Cohen and Dr. Sarah Michelle Vincent White. Maybe Professor Cohen will be the speaker. Professor Cohen is for Université de Montréal, Canada. She's going to discuss and share with us on the conflict resolution in human rights cases, the evolving role of the Supreme Court of Canada. And we have 2 respondents. Please, Professor Christy S. Warren, could you come as a respondent 1? And our second respondent is Dr. Ivan Nur Rahman from Constitutional Court. Please, Dr. Irfan. And as you all can see that you have a time counter in front of you. So yeah, because of the schedule is changing, so we have to adjust on it. Okay, I would not going to talk too much, so I will give the time to Professor Miriam Cohen. This is the floor is yours. Thank you.
Thank you, Chair. Good afternoon, everyone. May I start by thanking the organizers of this marvelous symposium. It's been an honor and a pleasure to be here with you today. Thank you also so much to my fellow speakers, chairs and respondents for very insightful discussions. Thank you again to participants both in the room and online. I promise to do my best to keep you all awake after this wonderful lunch and to avoid at all costs the gong. So if I can have the presentation, I'll start. The topic of the presentation is a paper written with my co-author, Sarah Michelle Vincent White, and it concerns conflict resolution in human rights cases, the evolving role of the Supreme Court of Canada. So before delving into the topic of the presentation, allow me to first provide some background to the theme of the paper, how we came about discussing this paper with you today. Earlier this year and at the end of last year, myself, Professor Stefan Bolak from our university, and my co-author acted as counsel for an intervener before the Supreme Court of Canada in the case of the Queen and Bissonnette, which is also known, unfortunately, as the case of the mass shooting in the Quebec mosque. While the case itself concerned the constitutionality of parole eligibility periods, it was interesting for us as co-counsels to note and dwell upon the court's role in balancing societal interests and individual rights. Another preliminary remark is in order. So the paper that we submitted was a slightly adapted version for the purpose of this symposium. Because it's such an international diverse symposium, we thought it would be important to set the background of Canada's constitutional framework and the diverse fabric of human rights protection in a descriptive way. So in the interest of time, in my presentation today, I'll only dedicate a very short period to this contextual prelude that I just mentioned. So my presentation will focus primarily in the evolving role of the Supreme Court of Canada over the past decade by discussing changes in the court's composition and how its established jurisprudence has worked to protect human rights in some complex cases. And this is the outline of our paper. So our research question concerns the role, and this evolving role, as we call, of the Supreme Court of Canada in resolving conflicts between competing rights, as well as in maintaining the balance between individual and collective rights. And we use two case studies to illustrate that. Ultimately, we would like to suggest that lessons can be learned about the fundamental role and the methods used by the Supreme Court of Canada in protecting human rights in situations of conflict of multiple rights. So the Supreme Court of Canada has a dual role and a rather important place in guaranteeing human rights protection within Canadian society. While argued in a different context, constitutional scholar Richard Albert has posited recently that the Canadian Supreme Court is a contender as the most powerful Supreme Court in the world. He mentioned that in relation to constitutional amendments. We could argue that it's similarly the case in the protection of human rights enshrined by the Canadian Constitution. So concerning the constitutional framework, as the supreme law of Canada, the Constitution provides the fundamental rules and principles of a democratic government. It also reaffirms Canada's dual legal system. So Canada is bijural, having both the common law and the civil law system, and it's also bilingual. As many constitutional democracies, human rights in Canada are enshrined in the Canadian Constitution through the Canadian Charter of Rights and Freedoms. It's important to note that the rights and freedoms guaranteed by the Canadian Charter are not absolute, and they can be limited to protect other rights or national values, but only, and this is Article 1 that states, to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, end of quote. Many of the rights and freedoms now included in the Canadian Charter were before protected by other Canadian laws, federal laws, provincial laws, territorial laws. So this is what we call this multidimensional fabric of human rights protection. So it's not only protection provided by the Canadian Constitution and the Canadian Charter of Rights and Freedoms, but rather a protection that is provided through different laws in the country. So the necessity of a Supreme Court that can resolve human rights disputes and consolidate jurisprudence becomes very clear when we understand the multidimensional fabric of human rights protection. So having set the table, so to speak, I'll turn then to resolving conflicts between the competing rights and maintaining this balance between individual and collective rights. I'll illustrate this question with two key cases of the past decades. So the Supreme Court of Canada is often seen and also sees itself as the guardian of the Constitution for the protection of fundamental rights. However, all Canadian courts are considered arbiters of constitutional disputes, given the principle of constitutionalism enshrined in the Constitution Act of 1867. The court's dual mandate in constitutional and other matters, as well as its crucial role in resolving disputes, can be seen by its recent docket. So just allow me to give you some numbers. So over the last decade, and I here look at 2012 to 2021, 5,251 applications for leave to appeal and 199 notices of appeal as of right were filed at the court, and from which 4,433 were dismissed and 461 were granted. Regarding the outcomes of the appeals decided, 371 were dismissed and 303 were allowed. Of the allowed appeals, 407 were unanimous decisions, and 269 majority decisions. So this is an important point when I turn to the composition of the court and its impact in protection of fundamental rights. So the importance of the court's constitutional role is relatively recent. Guided by the court's jurisprudence, other courts have interpreted the rights and freedoms protected by the Charter in a liberal manner without reluctance, to strike down laws that violate the Charter guarantees. So the discourse that we've had already and the discussions that we've undertaken this morning about judicial review. Overall, a generous rather than legalistic interpretation has been adopted by applying the metaphor of the living tree, which allows the Canadian Charter to grow and develop over time to meet new social, political, and historical realities often unimagined by the framers, but within its natural limits. And I quote from scholarship. And to interpret the Canadian Charter, the Supreme Court has taken a stand on some of the most controversial social-political issues, which I don't have the time to get into the detail in my presentation, but we can think about issues on assisted death, for example, and the multi-murder case that I will discuss later. So I now turn to the question of the impact of the court's composition in the actual protection of conflicts relating to human rights and what lessons can be learned from the Canadian example. So in 2017, the longest-serving Chief Justice of the court, the Chief Justice McLaughlin, retired, and a new Chief Justice was appointed. In the past decade as well, there have been 7 judicial departures. So these transitions within the court, departures, appointments, have significantly altered its composition. Chief Justice McLaughlin arrived at a pivotal time in Canadian constitutional history. It was the newly adopted Canadian Charter, and the interpretation of the Charter had yet to be formulated and implemented in cases involving the resolution of conflicts between competing individual rights and or collective interests. Overall, the jurisprudence during her tenure was characterized, and there have been quite a number of scholarship talking about the legacy of Chief Justice McLaughlin. She has been referred to by scholars as consensus, accommodation, reconciliation, compromise, and balance, and an approach to deliver justice in a judicial problem-solving way. As for the Charter jurisprudence, her approach has taken the form of a harmonious balance between the individual interest asserted as protected by a right, the constitutional rights of other individuals and groups affected by that claim, and the needs of a society where these limits rights no more than is reasonable. Her leadership within the court and in a public opinion has helped to demystify the judicial function, improve public understanding of it, and to protect the judiciary from the attacks of claims of judicial activism, which we have already also had a chance to discuss. As to the new Chief Justice, his tenure has been short so far, but there have been more divided decisions since he took the leadership of the court as Chief Justice. So to illustrate the court's role in settling constitutional conflicts, we selected 2 recent cases which highlight the impact of the court's judicial transitions over the past 10 years to see what implications may have on interpreting the Canadian Charter and therefore on protecting fundamental rights. So you have a picture of the beautiful Supreme Court of Canada in Ottawa. And I'll discuss with you 2 different cases. The first one is Jordan and the Queen. It's a case from on appeal from the Court of Appeal of British Columbia, and it concerned an application under Section 11B of the Charter. And that section guarantees the right of accused persons to be tried within a reasonable time. It's a case with former Chief Justice McLaughlin from 2016. So while all 9 judges of the court agreed on the stay of proceedings, the analytical framework had split the judge's decision 5-4. According to the majority, a new analytical framework was needed to apply Section 11B of the Canadian Charter, and that required a presumptive sealing of time limits of an accused to be tried within a reasonable time. For the dissenting judges, the jurisprudence of the last 30 years should have been maintained, with the clarification of the legal framework to balance further the many factors relevant to the application of Section 11B without limiting it to these numerical ceilings. So here the question that divided the judges was not one of the final result, but rather whether a new analytical framework should be developed. So let me then turn to the second case, which is the one that I referred to in the beginning of my presentation. On appeal from the Court of Appeal of Quebec, the Supreme Court was asked to determine whether sentencing an offender to consecutive periods of parole ineligibility, and that's Section 745.51(1) of the Criminal Code, violated the accused person's protection against cruel and unusual treatment or punishment, which is guaranteed under Section 12 of the Charter of Rights and Freedoms. The conflict in this case was between a law which allowed the judges this possibility to limit the admissibility of a parole to an offender for the protection, one of the reasons being for the protection of the public, and access to parole consistent with human dignity, so access by the accused person. Because social norms are not fixed in time, the Supreme Court recalled that the nature of cruel and unusual punishment could evolve in accordance with the principle that our Constitution is a living tree capable of growth and expansion within its natural limits so as to meet the new social, political, and historical realities of the modern world. As such, by a unanimous decision, and one that I have to say as co-counsels for the intervener, we were quite surprised that it was a very fast decision to be delivered, the court declared unconstitutional Section 745.51 of the Criminal Code as it violated Section 12 of the Canadian Charter. And the decision was written by Chief Justice Richard Wagner. These 2 recent examples illustrate this complex role of the Supreme Court to guarantee the protection of human rights while resolving conflicts between individual rights and societal interests. So what are some conclusions that we can draw from this research? In a multicultural society guided by democratic principles, the rule of law, and the protection of human rights, a Supreme Court plays essentially a crucial role in the settlement of disputes, special constitutional disputes. In a system where fundamental rights, such as the right to life, liberty, equality, that are guaranteed by the Constitution, in our case by the Canadian Charter of Rights and Freedoms, the Canadian Supreme Court occupies a position of guarantor of constitutional norms as the final court of appeal. So the role of the court in performing its dual mandate has evolved throughout the years, and we submit that it will continue to evolve. We have suggested in our paper that changes in the composition of the court may be one of the factors that impact the outcome of decisions in human rights protection cases and established jurisprudence. Ultimately, I think the aim of our paper, and especially our presentation today in this international symposium, is to provide this overview of the Supreme Court of Canada's role in human rights conflict resolution, and hopefully that it could be a basis for comparative analysis with other countries and legal systems. So without further ado, let me thank you very much for your attention and your interest, and I look forward to your questions.
Thank you, Professor, for delivering us the evolving role of Supreme Court of Canada in guaranteeing human rights in situation of conflict between competing rights and interests. Now we come to the respondent. We have first respondent, Professor Christy Warren. The time is yours.
I'm going to try and avoid the gong this time. So I love this paper. This paper made me feel very hopeful, along with the case study from South Korea this morning. You know, we hear so much about problems, and I won't get into the details, but problems in constitutional court and jurisprudence and everything. And the fact that Richard Albert, whose opinion I value very highly, thinks that Canada may be on the road to be the most powerful Supreme Court in the world makes me feel even more hopeful. So a couple of things, I guess, questions and points that jumped out at me when I was reading through here. I just couldn't help but wonder something that I have wondered throughout this entire conference, which is there one better model? You know, is it better to have one apex court that is charged with all of these overlapping and sometimes competing but plenary responsibilities, one group of justices who are responsible for protection of human rights and, you know, serving as the final point of review in the appellate process, or is it better to separate out those functions into two different courts? And I really don't have an answer to that because, you know, we have one apex court in the United States. One thing that really jumped out at me was the caseloads. I paid attention, 5,251 applications filed and 199 as a matter of right. 461 were granted. You know, our Supreme Court, which really has the same kind of jurisdiction that the Canadian Supreme Court does, we have maybe 72 or 3 cases per year that are granted, and that's everything. That's you know, appeals, you could say protection of human rights, and I'm not sure that in our system, if you ask people what the function of the Supreme Court was, that they would even mention protection of fundamental human rights. So, so again, it's interesting to me, and I can't help but still have that question about whether there is you know, one model that's preferable in terms of the overarching goals of an apex court. I was also really intrigued by the idea that although maybe I shouldn't be because maybe it's not that unusual, that the direction of the court, or if you want to say the personality of the court, seems to change, and in Canada so have changed, you know, pretty dramatically, pretty concretely with the retirement of Justice McLaughlin, who was very famous worldwide as being, you know, an eminent jurist. And you know, again, in your case, that's, you know, a very good thing, but I also wonder whether that could be tweaked in other jurisdictions, in other circumstances, that with the replacement of justices on the bench, the Chief Justice and other justices, that the direction of the court changes so dramatically. And of course, that's something we're grappling with in the US right now. You know, and there's a lot of debate about whether that's good, whether that's right, whether the jurisprudence and stare decisis belong to the court, or whether it's permissible for, you know, best case scenario, the living tree document, worst case scenario, you know, alternative new visions that could be politically influenced, you know. And so again, I feel very optimistic based on your paper and your presentation, because I think some of these same changes in different circumstances could deliver more troublesome or problematic or controversial applications and results. I have a couple of questions. One is, as a comparatist, and this doesn't have anything to do with your paper, but I'm really intrigued by the idea of dual legal systems being applied in one Supreme Court. So I think I want to get a fellowship and come up and study how that works. And just one question that I would leave you, and then I'm going to leave you extra time unless the clock has stopped, which maybe it has, is, do you think there is one model, a unified apex court versus a division between a Supreme Court or having dual apex courts, a constitutional court and a Supreme Court for dealing with indigenous rights, which I know has been an issue up in Canada and in Australia, in the United States too, and I'm kind of interested in those issues, and so I don't know what your thoughts might be on that. But thank you again for your paper. I really enjoyed it. I learned a lot, and I walked away feeling the same way that I walked away from the South Korea example this morning. I thought, well, there are things still to be learned and gained from other models.
Okay, thank you, Professor. Next respondent, our next respondent is from Indonesian Constitutional Court, Dr. Irfan Nurrahman. The time is yours.
Thank you very much, Madam Dayana. Sorry, I call Madam Dayana to avoid our nervous.
It says 10, but actually 5.
Oh, yeah, okay. Okay. Thank you very much. First, I would appreciate to the comprehensive paper that discuss the protection of human rights in Canada very comprehensively. And I still wondering about for question, maybe can you share what that I wondering for it. First, mention in the paper, the Canadian human rights protection frameworks provide for multi-layer system, whereas rights are protected and within which there can be conflict among different actors and or competing rights. So how is the legal instrument mechanism to solve the conflict in protection of human rights between federal, provincial, and territorial law? And the second, how is the SGG maintain a balance between the individual human rights and the public interest at the same time? Is there a standard measure or instrument to determine which one is more important priorities? The third, human right in Canada is not absolute because it has limitation prescribed by law. So what is the limitation criteria of human rights in Canada, such as Indonesia in our constitution that stipulates at Article 28G that we have give a restriction to the human rights, respect for the rights and freedom of the others, and in order to comply with just demands in accordance with consideration from morality, religious values, security, and public order in a democracy society. And the last is, the paper emphasized that the composition of the judge is influence in making a decision. How significant its influence to fulfill the protection of human rights in Canada? If the paradigm of majority justice is judicial activism rather than judicial restraint, which is the better in protection of human rights in Canada? Thank you.
Thank you so much. Before you can respond, we open questions. One question from the right side and one question from the, one question from the left side, and yes. Your time, Professor, I cannot read your name, so.
De Villiers, thank you. Thank you, Chair. Thank you for the paper, Professor Cohen. One observation and one question. The first is the observation, perhaps an observation on the dual court system that was also raised by Professor Warren. It seems to me there must be a very convincing reason for a dual court system. Otherwise, one should have, I think, a single court system. And why I'm saying that, it seems to me there are two considerations. The one is when there's a question of legitimization, then the importance of a dual system becomes relevant. For example, in South Africa, one simply could not accept that the current court system was sufficiently legitimate and therefore a separate court had to be created. But if it's more just a functional decision, expanding the powers of a court, then I think one can deal with a single court system, and that's just my observation. But my question for you that I found interesting was that you say composition of the court should be changed to ensure more equitable outcomes. And I'm not sure if I'm entirely comfortable with it. Because ultimately one should have your top legal minds, I would have thought, on a court. And one shouldn't have a feeling, if you are the applicant, that my side is not sufficiently represented on the court, and so my chance of succeeding is weaker. I would be concerned of that. Jackie Dugard, you may be interested in the research, it's a professor in South Africa, and she published in the South African Journal of Human Rights. She took 20 years of decisions of the South African Constitutional Court, and she tried to analyze what influenced the outcome in the field of socio-economic decisions. And she looked at things such as the appointment of a judge, whether appointed before or after democracy, the gender of a judge, male, female, or otherwise the race of a judge, white or black. And she found that in all those categories, the outcomes were pretty consistent, interesting enough. The main factor that she found made a difference was whether judges sat on their own or whether they sat collectively with other judges. And so her hypothesis was that judges who sit together are likely to be more liberal-minded when it comes to socio-economic judgments in South Africa now than when they sit on their own, which was quite surprising, and that the other factors of race, gender, just didn't count. And I thought I should just share that.
Other question by Pa Ali.
Thank you, Mrs. Chair and Professor Cohen. The first question actually following the comment from Irfan and Professor Filler concerning the, I think it's like a thesis that the change of the judge will influence the decision. And actually, I think in Indonesia, it's also some research that's compared between one period of the constitutional court judge to the other period. And also in some issue, for example, in accordance with the law that's concerning the Islamic law, how the judge or the justice decide the case of the judicial review concerning the Islamic law. But just like Professor Filliard, we have the big question, what the dominant factor that makes the differences between one judge to the other judge. For example, for constitutional courts, maybe I have the assumption that the background of the constitutional justice will, as a dominant factor, to lead to different decision. For example, we can split it to become three, first from the academician, and then the second politician, and then the third is the carry judge that's proposed by the Supreme Court. It's, of course, will have a different approach to a certain case. But I think until now we do not have a clear result of the research that classify the justice. And maybe in Canada already research that's what's the dominant factor, whether the education, maybe the ideology, and the other. This is the first question. And then the second, I'm sorry if I misunderstand. You mentioned that the public opinion support to protect the judicial independence. How it's the public opinion might support the protect the judicial independence, because maybe in three years until now, a lot of attack toward judicial independence in Indonesia, but we, the civil society, try to defend the judicial independence, but the decision is on the parliament and the executive that creates the law. It's not have much influence to protect the judicial independence. Pal writes the very interesting article that our judicial independence is under attack by the clear air present danger right now. So it's maybe we can learn from the Canada. Thank you.
Okay, thank you. I think the questions, we do not call any more questions, so you can answer the question.
Thank you. Thank you very much for your comments and question and engagement with the paper. So all very interesting and important questions, and I'll try to address them in the order. So thank you very much, Professor Warren, for your comments. I'm very glad to hear that you enjoyed and felt optimistic after reading our paper. And I think the questions that you raise are questions that we have discussed and thought through a lot in terms of this multi-layered system and which system is better. Is it a dual system or a system that has one Supreme Court that has constitutional and as a final court of appeal? I happen to come from a different country than Canada, which has a dual system with the Constitutional Court, so I'm able to compare a little bit. And I have to say in Canada, it's a very specific and kind of unique system that allowed for having one court only, and it's historically connected to, you know, how the court came about and when it became the final constitutional court for constitutional matters, and when the Constitution was actually repatriated back into Canada. There's also something unique about Canada in terms of explaining the unique court and not a dual court system, which is the indigenous rights, but also the dual legal system of civil law and common law. So in the Canadian Supreme Court, we always have 3 judges that come from the civil law province, which is Quebec, and that speak French. And more recently, and I think I'm now delving into your second question, there has been a lot of debate about nominating a judge with an indigenous background, and how does that play out with the bilingualism that is normally expected or is a good thing to have if you're a judge of the Supreme Court, and you would have cases coming from both the civil law French province and the Anglophone English province. So very recently there has been a nomination of the first indigenous justice who also is bilingual, and I think that will probably come with a new era of the court's jurisprudence, because there has a lot of issues to be decided by the court, and there will come cases that relate to indigenous law and indigenous rights, and how Canadian law is applied to indigenous peoples, and having a justice of the Supreme Court that has this background knowledge of indigenous law, but also is an indigenous person, I think is a step in the right direction. You also mentioned sorry, I have the wrong paper. So having a dual or other system, I think my answer to that is it depends on each country, right? So how it's done in Canada is very particular to, like I said, the historical constitution of Canada, and also the way the Canadian society is, the federalism in terms of the sharing of the competence between provisional and federal powers. So I can't imagine in Canada having a dual system, and again, going back to the multi-layered protection of human rights, how would that work, having a constitutional court that only deals with the protection of human rights by the Charter of Rights and Freedoms and Constitution, and then having other courts that would deal with the protection of human rights in laws? It just doesn't seem to be a court going to, I guess also Professor de Villiers' comment, that a system that would work in Canada. Just also your comment about the retirement of Chief McLaughlin, and I think the goal of our paper was not so much to argue that, you know, as judges come and go, the protection might be more or less of fundamental rights in Canada, but rather this idea of having this Chief Justice that lasted so long and came at a very specific moment in history, and she was able to maintain this very unanimous, harmonious court. And now with this change in the court's composition, how will that impact? It shouldn't impact, and I'm now kind of skipping the order here, but going to your question, and I agree with you, Professor de Villiers, that it's worrisome if we think that changes in the composition could impact the protection of fundamental rights. But in the Canadian example, it's a very particular one because it's a very new Supreme Court with a very new Charter of Rights and Freedoms, and which had a very long and consensual Chief Justice. And now we just had this change now in Chief Justice and in other judicial appointments with the new Indigenous appointment of an Indigenous justice. So our question in our research is how will that impact the protection, but not to mean that it will be a lesser protection. We believe, as Richard Albert says, but in relation to constitutional amendments, that the Constitutional Court, the Supreme Court of Canada, is a strong one to protect fundamental rights. So I know that my time is running out, and I want to make sure to answer all questions. So how is the legal mechanism, thank you very much for your question, to solve conflicts between the federal, the provincial, territorial, and constitutional? So the way that these conflicts would come about depends on the competence of each law. So for example, we explain in our paper, while the Canadian Charter of Rights and Freedoms only applies to government action, so you can really do the judicial review of laws using the Canadian Charter of Rights and Freedoms, but federal laws, provincial laws will not apply in that same way. For example, the Quebec law that protects, so the Charter of Quebec that protects rights and freedoms, that applies in the public and private domain. So each law will have a different competence and jurisdiction of application. What is the idea of how do you limit rights? If we look at the Canadian Charter, Section 1 of the Canadian Charter provides, which is also common in other constitutional democracies and in international instruments, provides a clause for limitation. So essentially, if a law is challenged before the court on the basis of the Constitution, so we have to look at whether the law is contrary to the Constitution, if it violates the Constitution, and if this violation of a specific section, for example, of the Charter, is in accordance with a free and democratic society. And that we developed, there's a jurisprudential test, the Oakes test, that was completed by later case law that provides how we would look at this limitation and the application of Section 1. So in order to address the last question that I had from Professor Ali Safat, so judges, how do judges influence and decide cases? What is the dominant factor? And this is it's a fascinating question, and I'm very glad to get your suggestions, comments, and also suggestions of literature. Because judges are, after all, humans that come with their own background, and especially in the case of Canada, where you have, we say it's a dual system, but you have the civil law, you have the common law, and you have Indigenous legal traditions as well. So it's three systems operating with one constitution and one Canadian Charter of Rights and Freedoms. So when judges come with their background and their own legal system within the Canadian society, they will look at cases in light of that. But also the established case law of the Supreme Court is a solid one. So it's not, the court will not easily overturn decisions. And that's why we chose these two cases, because, for example, the Jordan decision that we discussed is one where the court went and against previous decisions, and that had consequences for a lot of the cases that came before it, but the court still went forward and decided to overturn previous jurisprudence in order to protect the rights of the accused person and the section of the Charter. I don't think I will have the time to address all of the questions. I want to keep within my 10 minutes, but I wanted to thank you very much. I don't know if, Sarah, you have something to add at this point, but we can continue the conversation afterwards. And again, I thank you very much for your interest and questions.
Thank you, Professor Miriam. For me, I have a chance to read your paper, and actually I have several questions, but I won't deliver it here. So let's once again applause to our first speakers. Thank you so much. It was very interesting. You know, your paper is flowing fluently, and it is very readable.
Oh, thank you
I
so
like
much.
it so much. Okay, thank you. Thank you. Yeah. Thank you. For our second speaker, let me invite Mr. Zol Sabu, PhD. I hope I spelled your name right. Zol Sabu, PhD. Mr. Zol Sabu is for Karoli Gaspar University of the Reformed Church from Hungary. He will discuss a paper entitled Theoretical Framework of the Judicial Control of Parliamentary Procedure. And our two respondents for this evening is Dr. Rosa Ristawati and Dr. Radian Salman. I don't know which one of you will come up. Is it Rosa? Okay, Dr. Rosa. And I would like to invite Ms. Oli Fiona Agustin for our second respondent. Okay, Dr. Zol Sabu, the time is yours.
Thank you very much. Dear colleagues, I brought my pet topic here to this conference, which is parliamentary procedures. I like parliaments very much. During my legal studies in Hungary, I had the job to be a guide in our Hungarian parliament, and I guided several groups around the building and explained not just about architecture, but also about the functions of the institution. And later on, I was lucky to get into the parliamentary administration. I worked 6 years in the Department of Legislative Drafting. And now I'm in academia. I'm a scholar, enjoying the freedom that I can think and speak openly about parliamentary procedure. And today, I will tell you a few things about the relations of parliament and the judiciary, specifically the control of parliamentary procedures by the judiciary. Let me begin with the statement that I'm still working on this framework. So what I will present here is an ongoing work. I will present you a possible framework how the parliamentary procedure can be reviewed by the judiciary, an external organ. But there are still holes and missing parts of this framework. I will tell you some things at the beginning about the importance and the legal nature of parliamentary procedure, and then I will focus on the possible forums, how procedural disputes can be resolved by the judiciary, and then a few categories of possible judicial control, activist, non-activist, and so on, and then draw some conclusions. So, you know, rules of procedures of parliament are in the heart of national sovereignty. There are so many fields of law which is being harmonized within the European Union, and there is a thing, this is parliament, which is really the domain for the domestic legislator, and nobody else has a say in it, we could think. But I will conclude saying that there can be some tendencies also here and this domain to harmonize things. But definitely, rules of procedure are things of domestic parliaments. They decided on them alone. But nevertheless, they are under control of the majority of the parliament. So the parliaments are not unanimous institutions, one of the three branches, but a parliament in itself is a partisan body very often and has a majority and a dissenting minority. These rules of procedure should be fair, even determined by the majority. It is not possible that minority is deprived by basic rights in participating in the parliamentary debate. These rules are on halfway between law and politics. These are legal rules of a political game, and politically driven interests result in creating parliamentary rules of procedure very often. I have to stress that fair procedures alone do not guarantee good decisions. There is no guarantee that a good set of rules of procedure will result in good statutes, good parliamentary decisions. But unfair procedures are more likely to result in unfair procedures and unfair outcomes. So this is a justification why these rules are important. There are basically three functions of parliamentary rules of procedure: to set the procedural order, to establish the internal organization of a parliament, and to provide for minority rights. Now, parliaments should work effectively, and their work cannot be upheld by opposition. Agendas need to be set, but on the other hand, members and parliamentary minorities should be also respected. A number of historical examples tell us how important is it to have fair procedures. It happened multiple times in the 1930s that the Nazi takeover in Germany and Austria was helped by making some procedural tricks in the parliament that time. And the sovereignty of parliament and the sovereignty of the constitution are two principles which might collide. On one hand, sovereignty of parliament as part of the national sovereignty, as I mentioned, stresses the independence of parliaments in creating these internal rules. However, on the other hand, the sovereignty of the constitution is another principle which looks at the whole picture and thinks that the rule of law is the guiding principle, and it is important to not to let parliament go alone, but an external control is important, and this is how the judiciary comes into the picture. The general constitutional rule on the independence of parliamentary procedure making is very general. You can see here the three most common examples: the Bill of Rights of England, the US Constitution, and the German Constitution, and numerous other constitutions also provide for independence, autonomy of the parliament to set the own procedural rules. And I don't want to go into the background and history of all these rules, but it's also a very interesting topic, how they were created and how they evolved. I just mentioned the three common types before going to this slide. The three most common forms of parliamentary rules. One of them is the statute. A simple statute of parliament can regulate internal procedure, which is made for an indefinite time period. So statutes are not adopted only for the parliamentary term, but for an indefinite time period, for eternity, if I might put it this way. And it's not possible to deviate from them, even with a parliamentary consensus, because a statute is a statute. The second is the internal norm of a parliament, for example, standing orders of a parliament, like in the United Kingdom, which can easily be changed. Deviation is possible, but they have only binding effect for the internal legal subjects. They cannot bind citizens. They cannot oblige citizens to do anything, to appear before committees of inquiry, for example. And there's a third category. Lawyers often tend to say that if they cannot categorize, cannot group categories, that it has its own category. So the third category, with only one element, is the sui generis, which is neither a statute nor an internal rule, but an autonomous decision. This is what, for example, the German practice shows. And the justiciability is different, because a statute is always subject of a normative control by the Constitutional Court. However, courts may not intervene in autonomous internal decisions of parliaments. And this is how I come to this slide, actually, the four possible scenarios set out by Stephen Gardbaum, showing the different terms of judicial activism in legislative control. He observed that at the very first stage, in the 19th century, the sovereignty of the parliament was unbroken, and this time there were no strong coalitions and government instead of the parliament. No instance of judicial control existed at this first stage, because fair procedures were not in danger. In the second scenario, the governing parties do not want to control parliament, but want to keep in office them at all costs. The party discipline, the dependence of parliament on the government and not vice versa, led to an emerging role of the courts, who had to look into keeping parliamentary rules. In the third model, there's an even higher rate of power concentration, in which a dominant party comes to power, and as a result, all political accountability ceases, and the relationship of responsibility of government-parliament relationship is blurred. Even more active rule is expected from the external control body, the judiciary. And the fourth, the worst scenario, is when the centralization tends to an abuse of power. The dominant party abuses its power, and the court also tends to exceed its authority. So special situations require special solutions, said Gardbaum, in observing the South African constitutional court's emerging activism, related also to procedural control in South Africa. And I created this matrix. It's not a very big invention. It just shows the four possibilities. There is either an external forum for resolving disputes of parliamentary procedure, or an internal forum within the walls of the parliament. For example, if the rules are not respected, if opposition is not provided enough time to speak, or the requested committees are not created, the question is, who do you turn to? You ask the speaker, or you have another forum elsewhere to go to. And another aspect is who you are. If your right is breached, are you an MP who has problems, or are you a citizen whose rights are injured by parliamentary action? So internal actors can seek internal remedy, external actors can seek external remedy, and this is possible for external persons also. Different parliamentary functions enjoy different political protection. Now, time is short and don't want to give examples and explain all four possibilities in details, but I would like to draw your attention to the importance of the first line, number 1 and number 2. The importance of the courts is crucial. My hypothesis is that it is important, especially in parliamentary governments, to empower the judiciary to resolve disputes of parliamentary procedure. Also for internal actors, for members or political groups, but the same goes for external citizens, for example. If citizens are denied access to parliament, there was a case in Germany when journalists were denied access to parliament, and they successfully claimed at the ordinary court of the German capital, which dissolved the decision of the speaker. Now, this would not be possible, I think, in Hungary and also in some other countries. And there was another case in Ireland, I think, this is the next slide. It shows the emerging judicial activism. In Ireland, the Kerins case, Kerins and McGuinness, Ms. Kerins was leader of a public company who was invited to be heard before the Public Accounts Committee of the Irish Parliament. And Mr. McGuinness was the chair of the committee. And this person, who was not an MP, was invited as a citizen, not a simple citizen, but a leader of a state institution, to answer questions, but she was so attacked by the committee, there was no preparation, and they asked very embarrassing questions also, that she had real pain and injury and depression, and she needed also medical health after the hearing. And she successfully sued the parliament that the hearing was not fair. And it was very surprising, but the Supreme Court of Ireland said that she is right. This is not the right way to deal with citizens, to harm them. They need to be treated in a fair way. And in this internal parliamentary domain, the Irish Supreme Court intervened and said that this was not fair. The Israeli Supreme Court struck down a law because an amendment was passed in the very last moment, not leaving any sufficient time for parliamentarians to discuss. So it says that it's against the Constitution. And let me jump now, after mentioning these two examples and leaving out the others. Those who are interested can read the paper. Let me underline one of the good examples I found, the German model of procedural review. The Constitutional Court receives applications from every unit empowered with constitutional rights. Whenever the Constitution mentions the qualified majority, 1/5 of MPs or 1/3 of MPs, this group who is denied rights can turn to the Constitutional Court in the so-called Organstreitverfahren, the constitutional dispute procedure, and very often it is successful, and the court successfully resolved these conflicts of the internal parliamentary procedure. There are two types of review procedures. Actually, the courts, let me jump to the below list. There are two types of review procedures, as I said: substantive review of procedural review, as all you know probably. The substantial review looks at the substance of a law. Procedural review looks at the procedure. Now, for a very long time, it was very rare that a court struck down a law just on procedural reasons, that the parliamentary procedure was wrong. It came very, very late. It came with the emerging activism of the courts worldwide. For a long time, it was a side argument. Let's call it semi-procedural review. When the substance is not constitutional, then sometimes the court looked at the procedure and said, oh, and by the way, also the procedure was wrong. The single procedural review came later. The Israeli case was one of them. The content of the law was all right, was not contrary to the Constitution, but the procedure, as I said, the last-minute amendments were against the Constitution. And the third point, that the procedural review goes beyond legislation. So far, I was only talking about lawmaking, because courts pay more attention if there's an outcome, if there's a law which will affect citizens' rights. But all the other parliamentary functions were a little bit left to the parliament. But in the last years, for example, in Austria 2014, the Constitutional Court now has the right to control also, for example, questions and inquiry committee establishment, which is not a lawmaking function. Ladies and gentlemen, I stop here. This was the most important part of my presentation. I just wanted to highlight different possibilities. Thank you for your attention.
Thank you so much for the presentation. Now, the time is for first respondent, Dr. Rosa, to give a response to Mr. Zult paper. The time is yours.
Thank you very much, Ibu Diana. Good afternoon, everyone. Good afternoon, Professor Saldi Isra and Pak Palguna. This is not an easy job for me, actually, because I read it, the paper again and again, and then I get the point. Dr. Zul Sabo, your paper on theoretical framework of the judicial control for parliamentary procedure is very insightful, interesting, and contextual in the relation to the court and the parliament. Especially right now in Indonesia, also we have an issue of the relation between the court and the parliament.
Wow. You have to tell me later.
Yes. First, indeed, that everyone here may agree that for centuries, parliamentary privilege has standing as a bar against judicial review over the internal affairs of the parliament. The literature about the parliamentary privilege always involving parliamentary rules, the rules of procedures as the heart of this privilege. So, Dr. Sabo, your finding from comparative perspective, for example, about the type of the legal nature of parliamentary procedures and the shifting, changing paradigm or perspective on the doctrine of the non-intervention in the legislative procedure, for example, are beneficial to examine the context in the issue of the parliament and the court relation. So at this point, allow me to bring your theoretical framework into the Indonesian constitutional law and practice. So in the Indonesian constitution, actually, there is an article stipulates some aspect of the procedural law concerning the parliament. At least after the amendment of the constitution, Indonesia has rules on the mechanism of impeachment. Other than that, for the lawmaking procedures, Indonesia constitution stipulate in Article 22A, which is like stipulates that further provision regarding the procedure for the enactment of the law shall be regulated by law. So it is by law. So as you mentioned on the type of legal nature, it is the statute of the parliament, right? In Indonesia is similar. The law number 70, 2014 on the parliament, if I may call it as parliament law. This law of parliament is one of the most frequent review by the court. So if I'm not mistaken, it is about like 10 times. The law itself delegates about at least 113 issue on the procedure, rules of procedures. So in the constitutional practice, the court indirectly review about the lawmaking process. So the decision of the court on the procedure on the lawmaking, which is by reviewing the job creation law or Cipta Kerja law, and there is one of the landmark decision on controlling the lawmaker. So here, the parliament, we have DPR or the House of Representatives, and the president is the lawmaker. In that case, the court actually did not intervene directly. The parliament, the rules of the procedure, the parliament procedures, but review on the constitutionality of the multi-subject method in the lawmaking. So, yeah, still the formal, but not into the procedural, the rule of procedural itself, and assessing the formal process of the lawmaking. This decision created a new standard for public participation in the lawmaking process, and indeed it has a significant impact to the parliamentary procedures on the issue of the lawmaking. So at the end of my note, if I may, Dr. Sabo, I think you may consider to find out the argument on changing, shifting on the paradigm of the non-intervention of judiciary to the political institution, or for example, maybe related to the problem of public distrust of the parliament or any other causes. So actually I have one issue. Lastly, I was wondering also about the degree of independency of the court, in particular relation between the court and the parliament. So if the parliamentary procedure on the particular issue is being reviewed by the court, for example, like here in Indonesia, 9 constitutional justices respectively, 3 from the parliament, 3 from the president, 3 from the Supreme Court. So then how do you look at it about the independence of the judicial for reviewing that rule of procedure? So I think here maybe it's kind of a threat against the judge's term office. So on the other issue, when it comes to the parliamentary procedure of the judge's nomination and appointment process in the parliament, for example, because it should be like ruled by the rule of the parliament, would that be the case that the court could use what is so-called judicial control, or it may be infringement or encroachment to the parliamentary internal procedure? Thank you so much.
Okay, thank you, Dr. Rosna. And now the time for, do you have to clap? No, I think we move to the second respondent, Dr. Olive.
Oh, Amin.
Amin.
Thank you so much, Dr. Diana. I honored to be a respondent, and especially to Dr. Sabo, if I'm not mistaken in pronunciation. I actually read your article intensively because I'm really interested with your topic. You have comprehensive argumentations in your article, and your paper explained the relationship between the Hungarian Parliament and the Constitutional Court, especially in the possibility of a legal forum from the possibility of recovering the procedural decision from the parliament. And I appreciate it, and I absolutely agree with your argue in your article that you said the tension between legislative autonomy and the judicial duty to enforce constitutional requirements are more common right now. And this tension are often resolved by the Constitutional Court. And you explain more if the parliament's sovereignty is not, if not limited, the Constitutional Court is suitable as act the House Rules Court in German types that you mentioned in your article. And once more, I agree with you that you said basic argument that said the different jurisdictions have different solution for resolving the, debates between constitutional bodies. And this reminds me, if I can quote from Dr. Max Stewart in article that published in International Journal of Human Rights, said that the conception of majority democracy challenged the role of an independent constitutional court as an institution that protects basic rights and the rules of law beyond the power of the majority. With the contradiction in the statement, if allowed, I would like to know more from Dr. Sosabo to share with us about how the authority of the Hungarian Constitutional Court related to the condition of legislative omission. I conclude my response with the hope of having more discussion with you about the relationship between Parliament in Hungarian and the Constitutional Court, especially regarding to unconstitutional legislative omission, because this is my dissertation talking about that, and the Hungarian is one of a country that I used to comparative study in my thesis. Thank you.
Thank you, Ms. Oli. And the rest will be open question for, yes, one from my right side and from the left side. Is there any questions? Okay, Mas Yance. Okay, yes.
Thank you so much, Ms. Chairperson and Dr. Zabo. It is really interesting question talking about the judicial review of legislative process, but there are some issues related with that you mentioned in your slide that you provide two types of the judicial review. The first one is the procedural judicial review, and the second one is a substantive judicial review. It is also mentioned in the article written by the Simon Bartov, one of the legal scholars who concerned in the semi-procedural judicial review. But there is an issue in between procedural judicial review and substantive judicial review, which is called semi-procedural judicial review. So when there is a case or an applicant filed the case, and there are two issues that, which the first one is the procedural judicial review, or material judicial review, and the second one is the substantive judicial review. And then they call it, or you call it, semi-procedural review. The question is that why you use semi-procedural judicial review terminology rather than using semi-substantive judicial review? So yeah, this is my first question. And then the second question is that, so you mentioned also the comparative case study from the African courts, constitutional court. There is also the interesting case, Doctors for Life versus the National Assembly in South Africa. And then it mentions that when there is no, or when lack of the public participations or standard or quorum in the parliament discussion during the lawmaking process, as well as a debate during the lawmaking process, is it also can be considered that the law can be said unconstitutional when there is no public participations? So that is my question. Thank you so much, Dr. Sabu.
Thank you. And The next question from Yanje.
Thank you, Mr. Zabo, for your fascinating presentation. This is also quite relevant in Indonesia as well because there are more cases related to procedural review come to the Constitutional Court recently in Indonesia. And my question is based on your experience in Hungary. Sometimes when the court trying to really control the procedure of lawmaking in the parliament, sometimes the parliament didn't happy with that. And sometimes they also would like to try to do counterattack by controlling the court. Maybe that is also the case in Hungary, because when the parliament changed the law on the constitutional court and then raised the number of the constitutional court justice as a way to control the court. So yeah, maybe we can also see this is a competition of lawmakers, because both the parliament and also the constitutional court, basically both of them are lawmaker as well. So maybe we can see this is part of the competition as well, when the court trying to control the procedure for parliament to create legislation, and then maybe the parliament also trying to control the court. And the controlled court maybe not will not work well to control the parliament again. So the question is how to see this relation between the court and the parliament when the court trying to control the parliament procedure to lawmaking, but sometimes the parliament also trying to control the court. That is also happening in Hungary, right?
Okay, thank you for the questions. Dr. Sabu, the time is yours.
Thank you very much for these questions, and thank you for the organizers for the whole event. I wanted to say that earlier. Thank you for the excellent organization and great hospitality. Now, I'm happy to hear that I'm also granted with a lot of cases which I will bring home concerning the Indonesian Constitutional Court's practice. I didn't know all about this, and this is fascinating. I hope I can read something, if you can recommend in English some literature or translation of those cases. That would be wonderful for me, because I'm comparing different jurisdictions in terms of how the judiciary is looking at the parliamentary rules, whether they are kept or not. Another issue is the judicial review of the rules themselves. That's another issue, but I will not tell about this because I would like to address the questions now. Very interesting discussion. Now, the multi-subject matter which you raised, that different unrelated items in a piece of legislation are packed together and pushed through parliament. Is that what is happening in Indonesia? I can imagine, because it happens in Hungary also, and very many countries. In the US equally, the tax law is stuffed with different unrelated issues. And this is what happened also in Israel. A very few countries keep the one-by-one principle in saying that one law can only be modified with one single other law. In many countries, different laws are being modified within one piece of legislation, and this is normal. The question whether or not is done in a fair way, whether or not related issues come together, because if something is not related to the main subject, that is a problem. When the government wants to smuggle something and hopes that it will not be noticed. In Hungary, we call these laws salad law, because it is put together from different things like a salad. And with a salad, there is nothing wrong. I like a salad very much. But when there is something unrelated in the salad which makes the salad wrong, that is a problem. So I cannot say more than this is a common case worldwide, and I'm interested to learn it in Indonesia. Now, the court's independence, how can the court be still independent when reviewing legislative procedure? I think this depends on the standing of the court in the constitutional system. There is no need to fear about this decision. Does it harm the independence of a judge who will decide for one of the two competing parties? It's simple the task of the judge to decide, and he's still independent if he selects one of the two parties on legal arguments. So I don't see a danger of judicial independence when we empower the courts to be judges in procedural questions of parliament. And the legislative omission in Hungary is a very interesting issue. The constitutional court of ours, although it was reformed 12 years ago, is still one of the strongest of the constitutional courts, because it can also declare that the legislator, the parliament, didn't breach the constitution by acting, but by omitting passing a legislation. And without any legislative action, if something is not done, which he says that this or that provision of the constitution requires legislation, for example, procedural or institutional framework, because constitutions are not for the details, then it can state the omissions. Now, the problem is that there is no follow-up of the omission decision. The Constitutional Court sets a deadline and defines the task of the legislator. But very often happens in Hungary that the legislator understands the task according to its own taste. And it even happens that it makes the required legislation, if at all, because some deadlines expired long ago. And there is no second round. The court will not state whether or not this was what it really thought of. So this is the problem of legislative omissions. The semi-procedural review, well, it's just a question of standpoint, whether semi-procedural, you can call it semi-contential, or what was it? Semi-substantial, exactly, semi-substantial. One of the scholars, Itai Bar Simantov from Israel, called it semi-procedural. The constitutions which allow this kind of review say that, or at least predict, when not say explicitly, that this kind of review is only possible if also the substantial review is carried out. And we can speak about a procedural review if alone the procedural reasons substantiate the annulment of a legislation. No participation still constitutional, asks one of our colleagues from Indonesia. Well, in Hungary, there were some cases, you are absolutely right, in which not the constitution, but statutes required public consultations of various institutions. These were not done, and this is why some representative of these NGOs who were not consulted with claimed at the Constitutional Court. Well, in this respect, the Constitutional Court didn't go against Parliament. They said, it's true that there was no consultation, but it's not a high breach of the procedural rules, because it cannot be derived directly from a constitutional principle of the rule of law, that it would need the annulment of the legislation. So it was a little bit softened. The Constitutional Court didn't go so far, but when inter-parliamentary legislation happens, the Constitutional Court is really very strict. And like in Israel, also in Hungary, a whole salad law, a whole omnibus law was completely struck down because of a last-minute amendment at the very end of the procedure, not leaving room for substantial debates on the floor. And lastly, what is the approach of the Hungarian parliament when it is controlled? Well, no parliament is happy if it is controlled. Nobody is happy, of course, if he or she is controlled. But this is about rule of law. This is about checks and balances. And maybe I didn't understand the question well, but there are, of course, tensions between state bodies in Hungary as elsewhere. But this is normal in a democracy. This is normal in the system of checks and balances, that the state organs mutually control each other for the benefit of democracy. Thank you very much.
Thank you very much. Thank you very much for the paper, Dr. Sabo, and thank you very much for respondent and participant who asked questions. So we will give applause once more for the speaker. I know that the discussion is very interesting actually, but we have limited time and we still have one session to go. Let me invite our third speaker for this session, Dr. Yance Arizona from Universitas Gadjah Mada, Indonesia. He will discuss about the Constitutional Court and the forest tenure conflict in Indonesia. Following with him is two respondents. I would like to invite Professor Roy Andrew Pertain, and secondly, Dr. Nalam Kurniawan is not here, but Miss Mary will be the respondent. Miss Mary, could you come? Okay. Okay, the committee told me that we really have strict on time, so Dr. Yance, time is yours.
Okay, thank you for the opportunity to present my paper. Can I have my slide in the screen? Okay, so I need to clarify first that basically that this article is not entirely new article. So in 2013, I wrote an article in Bahasa Indonesia to analyze 3 constitutional court decisions related to forestry law, and the current version is made in English, and with the help of the second authors and also research assistants. And I collected more constitutional court decisions. I'm updated this paper, including 12 constitutional court decisions, and it is also important to see the implementation of the court decisions usually because I would like to see some court decision that has been ruled by the Constitutional Court in 2013 and 2014, and now it's already 8 years. So during the 8 years, and then this article also include the problem and also the successful in the implementation of the court decisions. And so that is the difference between my previous article in Bahasa Indonesia. So this is the outline of the articles in the left side, and in the right side, I would like to put the argument at the beginning of the presentation. So the first argument is that the Constitutional Court positively contributed to facilitated forest tenure conflict resolutions. So we can see the positive effect of the Constitutional Court decisions. And the second argument that the effectiveness of the court ruling relies on the support of NGOs and local communities. So maybe many constitutional court decisions are good, but most of problem with the constitutional court decision is they are not implemented. So I think that that's why we need to see, need to scrutinize the role of different actors, especially related to the protection of the constitutional rights. So this is about the forest tenure conflict, and the beginning I would like to show you, this is the map of Indonesia, the map of the forest areas in Indonesia, mostly with the color green, yellow, purple. All of them are forest areas in Indonesia. Only the white one in the island, non-forest area. So according to the statistic that around 67% of Indonesia's land surface considered as forest areas. It is around 120 million hectares. So it's huge. So what is the problem with the forest area? So when the land is stated as a state forest area by the government, it means that the land is the state property. What does it mean, and what is the implication? So when the land is a state property, it has to be freed from individual and collective land rights. So no individual and collective land rights should be exist if the state already decided a particular land as the state area. Meaning that if people living there, so they're doing criminal action because they occupy the land without the government permission. And this is rise the problem because many people living in the within and also in the edge of the forest area, even 71% of village in Indonesia is located within the forest area and also in the border of the forest area. Around 32 million people depend on their livelihood from forest resources. And there are many land conflicts that have been recorded. For instance, Consortium for Agrarian Reform recorded more than 2,000 cases of land conflict, especially in forest area during 2015 to 2019. I'm considered forest conflict here as a forest tenure conflict, defined as a conflict of claims to obtain access and benefits from land and forest resources. It can be a horizontal conflict and also vertical conflict, and in this sense, I'm focusing on the vertical land conflict involving local communities against the state agencies and corporations. So what is the root of the land conflict in Indonesia? It's basically as a colonial, starting since the colonial period, especially during the 1865, during the Dutch colonial period. That is the first forestry regulation in Indonesia. So at the time, the colonial government trying to claim unoccupied land, basically, as a state forest area. They're doing through the state territorialization process. The beginning, they're trying to declare all land that no one can prove their ownerships is considered as the state land. So that is we know it is as doctrine of declaration or domeinverklaring in the Netherlands. And after that, after the government declared the unoccupied land as a state land, and then they create boundaries, and then after that they do exploitations and also give forest permit to companies. And this legislation sustained even Indonesian independence in 1945, meaning that during the formulation of the first forestry law in 1967, the lawmakers at the time translate the forestry regulation in the colonial period, and then they use it as core to develop forest empire, forest regulation in Indonesia. And the law number, and this law is revised by the law number 41, 1999. It's gradually recognized customary land rights in Indonesia, but not in full. And the problem with the forest legislation is I mentioned you about the colonial legacy. The first is about the scientific forestry. This is during the colonial period. This is imported from Germany. The knowledge about scientific forestry from Germany, which mentioned that only the state can manage forest properly, not the local community. Even they considered local communities as a threat to the forest sustainability. And the second is criminalization of customary practice. And yeah, as mentioned to you that these practices continue in the forestry regulation after Indonesian independence. And yeah, so there are court decision, constitutional court decision try to challenge forestry regulation. I mentioned to you that there were 12 constitutional court decisions, and yeah, this is the list of the court decision. But I would like to focus to 4 court decisions because those 4 court decisions quite relevant to our discussion today. The first is case number 45. This is about the establishment of forest area. Before that, the previous the up is the previous text of the definition of forest areas in Indonesia. Yeah, so the forest area is a certain area that is appointed and or determined by the government to maintain its existence as a permanent forest, meaning that when the government appoint a particular area on paper sometimes as a forest areas, meaning that that's automatically become forest area even without consultation by people or consent by people who living there. And so by the Constitutional Court mentioned that this is unconstitutional. So the establishment of forest area has to be followed the Article 15 of the forestry legislation, which is the appointment is the first step to the establishment of the forest area. After that, it has to be followed by delineation process, mapping, and at the end, the government has to create a decree to determine the forest area. So that is the one positive things to restrict arbitration, unitary decision by the government in the establishment of the forest area. So the second, the court case number 34, but I would like to skip this to save the time. The third case, this is one of the landmark decision in Indonesia. Maybe if you know from Australia, Bertus, this is like a Mabo case in Australia. So this is really important landmark decision in Indonesian Constitutional Court decision. This is related to the definition of customary forest. In the forestry legislation mentioned that a customary forests are state forests that are located within the territory of indigenous peoples or indigenous communities. So the Constitutional Court just deleted the word state. It's changed the meaning of customary forest. And the current definition of customary forest is customary forests are forests that are located within the territory of indigenous communities or indigenous peoples. So this is a landmark decision. After this decision, indigenous communities in Indonesia mentioned that our state forest, our customary forest is no longer part of state forest. So they're trying to claim to gain back their customary forest from the state, and they estimated that around 40 million hectares of customary forest has to be returned by the government to the indigenous communities. But the problem is that to be able to obtain their customary forest, the procedure is really complex. The first, that the particular community has to be recognized by the regional government through regional regulation, either created by the province or by the district governments. And after they obtain their legal status as indigenous communities, and then they're eligible to apply to get customary forest from the Ministry of Forestry. And the fourth decision is about the criminal provision in the forestry law. So there is this is usually used by the government to criminalize the local and indigenous communities, because they put the provision that everyone is prohibited from cutting down trees or harvesting or collecting forest product in the forest without having the rights or permission of the authorized officials. And then the Constitutional Court add in the right sides some exception, yeah, except for people who live for generation in the forest and they are not intended to use their forest resources for commercial purposes. So they put an exemption for people who already live in the area. So I would like to address about the implementation, yeah, of the court ruling. So after the court ruling about the establishment of the forest area, there is also increase. You can see in the right sides in the below. So the graphic showing that from 2014, the establishment of forest area is increased. It shows that the Constitutional Court decision also have an impact to advance the establishment of forest area in Indonesia. And also there are many operating regulation created by different ministries after the Constitutional Court decision, either from the Ministry of Internal Affairs, Ministry of Environment and Forestry. They created operating regulation, ministries regulation to enable to make a procedure for customary forest recognitions. And also in the Ministry of Forestry itself, there's also the creation of a new directorate to enhancing the social forestry and customary forest recognitions. And also the continued support from NGOs and indigenous communities organization is very crucial. I think that without the support of NGOs and indigenous communities organization, that the good court decision will not be implemented properly. And this one, some picture. This is only a few picture. There are many other pictures, maybe 100 of that. So this picture is basically to show you that how the court decisions really influence actual forest tenure conflict on the ground. Because in this picture, you can show that how local community put the signpost, and this signpost, they cite the Constitutional Court decision. Yeah? They told that right now, our customary forest is no longer a state forest, according to the Constitutional Court decision number 35, 2013. So there are many pictures, in many locations where the land conflict between local communities, indigenous people, and company and state agencies, they put this signpost. But the problem is that it's not easy to get the customary forest, because the first that local community has to be recognized by this government first as an indigenous community. After that, they can apply for to get customary forest recognition. So the last point that I would like to discuss, and also to get input from respondent and also other participants in this events, to see the contribution and the limitation of the court decision, in the context of forest tenure conflict. So the contribution, I found that the Constitutional Court restrict the arbitrary action by the government, which is the most important element in realizing the rule of law principles. So that is the one thing. The second thing is that the Constitutional Court play an important role as the protector of the constitutional rights by prioritizing individual and indigenous communities' rights in the process of establishing forest area. And the third, that the Constitutional Court provides support a new narrative for land struggle, especially for local and indigenous communities, as mentioned to you, that they put the signpost in the, so the Constitutional Court in the conflicted area, so they put, this Constitutional Court put a new narrative, and now they're trying to frame their conflict is related to their constitutional rights. So before, the conflict is about fulfilling about their livelihood, but now they're trying to argue that it is a violation of their customary constitutional rights. But there's also limitation. The limitation first, that the constitutional court decision apply for the future because it is prospective, and the constitutional court is general and public, so it is not automatically solve concrete cases, yeah, because it's also consequences of the abstract review. And the other thing that the court didn't address the complex procedure for legal recognition of indigenous communities in Indonesia. Even the court can provide a new argument, but it is in the implementation is still difficult for local community to solve their land conflict because the complex procedure is still there. So, and also that I saw that the implementation of the constitutional court ruling required institutional changes in the government, and also the involvement of the political processes to give meaning to the constitutional court decision, especially with the support of indigenous communities, local communities, and also NGOs. One point that I'm thinking it is also interesting to be discussed, because as I mentioned to you before, that the forestry regulation in Indonesia is a colonial legacy, and I think that the constitutional court will also play an important role in decolonization process, yeah, to trying to reduce the colonial legacy, yeah, embedded in our legislation, and then the constitutional court can also facilitate it to as a means to for the decolonization as well. So that is all of my presentation. I'm really expect to have feedback from all of you. Thank you.
Okay, thank you. Thank you for such nice presentation, Dr. Yance. Now our first respondent is Professor Roy Andrew Partain. You have 5 minutes. Thank you.
Greetings. Luckily, I'm not working with a slide, so hopefully this will go easier this time. First, I adored this paper. I enjoyed it. I read it several times emotionally. The forests of Indonesia are something I've actually been working on with other people. Imam Mulyana at UNPAD was a student of mine, and his dissertation was on forest law as well. And so I read the paper, seeing things that you did not mean to cover. Your focus is on the Constitutional Court, but it invokes so many key, wonderful issues in both colonial, decolonialism, property law. So many issues are engaged, and I thought you took on a cornucopia of topics and managed it well. So just as a very first impression, I thought it was very well written across the board. As you notice on your slides, you've listed a lot of statistics, a lot of data. You've gone to find all of the cases, and the cases that were accepted, the cases that weren't accepted. We saw nice tables and charts. I know in the Netherlands, Jonathan Klick from University of Pennsylvania has been around talking about legal empirical analysis. And we do have some cautions when we step into that mode. One of the problems is we have to make sure that we understand what the pool size is that we're drawing from, because we're drawing these samples out of a pool. And then we have to sort out whether or not the data we've got meets the law of large numbers. So can we draw a strong inference from the data that we have? And what worries me, which is not your fault at all, is there's so few cases that have been taken up by the court, that have been handled by the court, that somebody might simply say, can we make a conclusion at first? You know, the naked statistics goes, wow, I'm not sure we've met the law of large numbers, therefore this analysis may not be meaningful. But that's not the right conclusion, you see. This is a lot like the Sherlock Holmes case where the dog didn't bark. The most important clue in the case was the dog didn't bark. And so what's really interesting in this is, where were those cases? Your rigorous analysis highlights there's missing cases. And you have a very long time period. And even for this Constitutional Court, I know a little bit more than you presented in this presentation. But where were they? Where were those rights? Why weren't those rights litigated? Why weren't they brought forward? Why aren't they constitutional issues? Is perhaps what's really calling from your empirical analysis is that you're discovering something should have been there and it's not there. And so where is it? And I think that might drive some interesting constitutional issues. I might first look for some comparative constitutional analysis and comparative environmental rights from Europe. What are the standard set of environmental rights that you might have to protect forest and communities near forest? Are they here in Indonesia where they engaged in cases in Europe. And in Europe, we have a longer time period. We can go back to the forestry laws of the 1600s. You can see how that played out. And is that similar and different here? There's also De Soto's theory that South America had trouble managing tribal rights versus landed gentry rights because lots of forest communities didn't have access to discrete property rights. And it's that part of the problem of why we don't have the cases. And so, you know, there's two kinds of schools out there that you could add as comparative analysis to make your data pop a lot. You've highlighted so many different statutes, which is a little bit similar to a presentation earlier today where there was a lot of water law issues. And in here, again, the forestry rules are in a lot of places, and that means we have a lot of regulators. And we have a lot of ways that rights might be ignored versus explicitly suppressed. Now, what's interesting is India has already advanced this literature when we have many regulators overseeing a natural area, and overregulation can lead to an anti-commons of regulatory effect. So one of the reasons there may not have been lawsuits is even the people on the ground may not have really known who was really in charge, other than the creation of what India found is that when there was anti-commons in the regulatory sphere, it created a commons on the ground. And then you had the strongman, whoever could kind of outgun the regulators on the ground effectively controlled the environment. And so there were areas in India that were highly regulated, very protected, yet all that regulatory got in the way of each other. And then locally, sometimes gangsters in India were able to run the resources. I have no knowledge of what's going on here, but there is a literature in India that you could compare to see has Indonesia got the similar issues or not. In the United States, we've had studies on fractured issues on holdings as well. The one thing I do want to throw out there as a langyap is the Japanese Supreme Court had very similar issues decades ago. And they came out, oddly, for the customary landholder, not for the Japanese land law and land registries. They said the original holder had primal rights, and you didn't even have to disclose them. You didn't have to put them on the deed. And so even in Japan today, like 20% of the land is owned without proper registry. And so whatever is in those cases, I haven't read them in a long time. You might want to check because it may help you a lot with this one. But it's a fantastically well done article. Thank you.
Thank you, Professor Roy. And next respondent would be Dr. Mary Christiani.
Thank you so much, Ibu Diana Puspitawati. Good afternoon, ladies and gentlemen. Allow me to represent our colleague, Dr. Nalom Kurniawan, that is unfortunately unable to attend these sessions due to his very tight schedule assisting the Chief Justice of the Indonesian Constitutional Court. Well, first of all, we really appreciate the excellent presentations of our speaker, these sessions, Dr. Rianca Arizona, for enlightening us and giving some new perspective on our horizons about the Constitutional Court and conflicts over forest tenure in Indonesia. But before I give or read our response to your paper, actually, from the first time I read the article of Dr. Rianca Arizona, it came to my mind, how could his parents know or name him Arizona? Because most of his papers is related to forest and then, forestry law and then adat law, something like that. So is it related or not? Well, I don't know. Maybe later we can talk about this, yeah. Well, personally, we must state that the speakers in the sessions always write a very good paper, but of course, there are no shortcomings or weaknesses that is found. However, let us give a response to the theme today. According to the theme of this discussion, well, the issue of forest control by the state and corporations that ignores the protections of the rights of indigenous and tribal peoples is a very common problem in many countries, including Indonesia, of course. The emergence of neglect of the rights of indigenous peoples can be caused by several things, namely the issue of the legality of indigenous peoples to the rights of customary lands. And then the second, the issue of the legality of the existence of the customary law community itself. And then the third, the issue of boundaries of customary land rights controlled by customary law communities. And then the fourth, legal settlement authority on land rights of indigenous peoples. And of course, there are more various other issues. Well, if some of the above problems should be faced with the authority or the role of constitutional court, which is providing protections for the constitutional rights of indigenous and tribal peoples, it could be seen that the issue of forestry conflict that ignore the rights of indigenous and tribal peoples places in a concrete legal area. Meanwhile, the role of the Constitutional Court in the context of provisions of protections constitutional rights is in an abstract area or abstract legal area. For example, when it was stated in your presentation, the Constitutional Court's verdict or decision stated that customary forest is not state forest, so that the control of customary forest is in the area of customary rights for indigenous people. So although the Constitutional Court decision seems ideal to provide protections to the rights of indigenous people, on the other hand, the court's decisions cannot determine the boundaries of the territorial area or the total area of the land that is customary rights for customary law communities in a certain area. Well, not to mention, another problem is that on a regulatory basis, the said court's decision still requires further implementing regulations, or judicial institutions are very needed in a concrete jurisdictions, whether it is judicial decisions or verdicts under the Supreme Courts. Yeah. Some of the issues mentioned above will be very interesting to discuss in order to formulate a concrete legal roadmap for resolving forestry conflicts in Indonesia, especially to protect the indigenous people's right. So we can conclude at the end that forestry conflict in certain areas that ignore the customary rights of customary law communities, as well as a broader map, namely regulating the rights of indigenous people to customary forests in various areas of legislations. The gong voice is the time that I have to stop, so that is all that we can convey as a material for the discussions for today's session. I apologize that I should leave the respondent chair.
Yes, thank you. Thank you. But
thank you so much.
Just one more question from the audience, from Professor Cohen. Just make it very quick, please. Thank you.
Certainly. So I just wanted to thank you for this very interesting paper. This is the marvelous thing about this symposium, is that we get to learn so much. The data was incredible, so thank you very much. My very brief question is, your paper was very much related to Indonesia and looking at the Indonesian cases, but it's so interesting to take it and a bit in the line of the respondent, how could it be applied, or do you think it could be applied in other contexts? Because the issue that you deal with in your paper is a very important issue in many other countries, and especially, as the second respondent mentioned, in line with indigenous rights. So I'm just wondering if you think your analysis could be transposed or applied into other contexts. Thank you very much again.
Thank you. Mr. Arzona, make it just quick.
Okay, thank you for very good feedbacks and also some questions. I think I would like to, I'm not to answer, but to respond, to respond to some positive feedbacks. First about experience in Japan. I also did my visiting research in Japan as well to learn about Iriai forest as well. For a very short period, what I found in Japan is that they are not really concerned about status. about the status. So that's why you mentioned that some rights maybe are not registered, but maybe for them it's not really a problem. And also about India, maybe I would like to learn more about India. Maybe it has a similar context in Indonesia. And other, I would like to respond about, as mentioned by Mary before. So yes, we need to see the location of the constitutional court in the forest tenure conflict. So it is not an institution that can really solve the actual problem because they're playing at the abstract level by reviewing legislation. But when the constitutional court review legislation and provide a new narrative for local communities to continue their struggle on the ground, so that create positive effect. I think that can be also, yes, in some countries that also happen, right? For instance, like Mabo decision in Australia, and it also inspired many others Aboriginal communities in Australia to fight for their land. Also, recent cases in Kenya, in Africa, African Court of Human Rights about Ogik cases, and also in Awastingi case in Nicaragua. So in many continents, so the court trying to facilitate and also trying to provide a new narrative for local communities to fighting for their customary land. And yeah, to compare to other contexts, yeah, it can be relevant to compare it with other countries, but I don't think that these Indonesian cases can be, can be fit with the other context. It depends on, especially related to the implementation. Yeah. So I think that many good court decisions, even in Mabo as well, in Australia, but the problem still about how to implement a good decision on the ground. So that is another political process. Yeah. So it's also has to be include the active role of NGOs, local communities, willingness of the state government, also the parliament to collaborate to really solve the problem and to change the paradigm as well in terms of the customary land rights. So yeah, that is my response to feedback. Thank you.
Yeah, okay, thank you so much. And we come to the end of the session 4. We still have one more session, and this is the closing of session 4. Thank you again, and once again, applause for the speaker. I might give it back to the Master of Ceremony, Mary.
Thank you so much. Distinguished chair, speakers, and all respondents, also all participants and speakers that is still awake to join our next session. Yeah. By the way, before we continue to the next sessions, we have some informations to share for all of you, especially who attend this room today. Well, you can access the QR code that is available in your ID card by scanning with your device. Maybe you can try to scan your ID card right now by scanning the QR code. You can get some informations on it. That is the first guiding book about our activities. And then there is also attendance list that you can click. So if you read the attendance list, then you can click the submit to prove that you really attend our sessions. And then you can also access any papers from every conference in the WCCG Congress, such as the first AACG CCJA joint conference and also other conferences. And then you can also get or download some photos from all activities since our first day of conference, the October the 4th until today. And later on, the final, you can also download the certificate of speakers for all speakers, and then participants for all participants, and also respondent. But the certificate could be downloaded at the end of our sessions. After you click all these, submit a menu on the attendance list. That's what I can inform about the functions of the QR code that is available in your ID card. Ladies and gentlemen, allow me to invite our next chair to moderate the last session. Hopefully it will be the hottest and the most fruitful discussions to end our second day of conference. Please welcome Dr. Herlambang from University of Gajah Mada, or I should say Universitas Gajah Mada, Yogyakarta. The time is yours.
Okay, thank you very much. Dear colleagues, we will have the last session, session 5. There will be a discussion on freedom of expressions, unjust democracy, and social conflicts. So the problem is only time, because organizer or committee just told me that only until 5, but perhaps if we can negotiate, we can expand or extend the time for discussion or making more meaningful discussions. First, I would like to invite the first speaker, Professor Bertus de Villiers, and also two respondents, Andi Omara and Alboin Pasaribu from Constitutional Court. Professor Bertus de Villiers from University of Johannesburg Law School, and also State Administrative Tribunal, and also Curtin University Law Schools. Is going to present on freedom of expression and hate speech when values call it in deeply divided societies. 20 minutes is yours.
Chair, thank you very much. It is our duty, those of the last session, to keep you all awake, and hopefully we can do so. Thank you very much for those who organized this conference. It is of an exemplary standard, and it was fantastic to be here, so thank you very, very much. I'm speaking to you about the topic of hate speech, and increasingly we see hate speech across the world in all countries. It's especially with the advent of social media that hate speech is becoming more prevalent, more intense, more widespread. And hate speech is often directed at individuals, at minorities, at religious groups, at people because of their sexuality, at immigrants. And it's often the vulnerable in society that are being exposed to hate speech. The problem, of course, is not all speech we hate is hate speech. We may not like a certain speech, but when does a speech become hate speech? And the challenge is to define hate speech, because internationally there is no agreed definition of what hate speech is. We all agree that freedom of expression is essential for a democracy. A democracy cannot function unless there's freedom of expression. And so the question then is, should freedom of expression ever be limited? And if so, when should it be limited? And this brings me to the paper of today. I'll just see if I can work this. There we are. So the framework that I'm going to speak to, these are the slides that I'm going to speak to. First of all, I'm going to speak about the interaction between freedom of expression and hate speech. Secondly, I'm going to try to answer the following questions. The first question is, when is speech hate speech? Secondly, what is the test for hate speech? Is it an objective test or is it a subjective test? Is it what the person intended in their own mind, Or is it what people perceive? What is the test for hate speech? Thirdly, what evidence is required to establish that hate speech occurred? And fourthly, is a declaration of hate speech looking back, retrospective, or does it look forward, prospective? I will also look at the guidelines in international law about hate speech, and then I will apply this to 2 recent case studies in South Africa, very sensitive case studies. But the case studies I use to show you how difficult it is to apply general principles of hate speech to actual practical circumstances, and then I will reach a conclusion. So the first is interaction between freedom of expression and hate speech. The first point to make is that freedom of expression is essential for a democracy. No democracy can function without freedom of expression. And one must be very slow and conservative before you interfere with freedom of expression, because then it becomes a form of censorship. Secondly, hate speech, it is agreed internationally and in international law that hate speech restricts free speech. So you're not allowed to speak hateful to other people. But the question is, what is hate speech? Hate speech is not defined in international law. And even in countries where there is legislation on hate speech, the application of that legislation is not a simple matter, because often the person hearing the speech is more sensitive than what the objective test for hate speech would be. The one thing that there is agreement is that hate speech is the most extreme form of speech you can get. So it is not dislikable speech, it is not objectional speech, it is not just speech that you don't like. Hate speech is the most extreme form of speech you get, and therefore it must restrict your freedom of expression. So one mustn't confuse type of speech that you don't like with hate speech. For example, I may be offended if somebody criticizes my faith, but does that make it hate speech? Or must I just accept that they can criticize my faith? I may be sensitive because somebody in Australia refers to me as a so-and-so immigrant from South Africa. Is that hate speech, or is it just them saying what they think of South Africans? It's very hard, because the person often experiences hate, but objectively it's not necessarily hate. Sixth point, hate speech can be words, signs, printing, or symbols. So the fact that one talks about hate speech doesn't mean there has to be words. There can also be a sign. The mere fact that one shows something can be hate speech. Recently in Australia, there was a soccer game, and as the one scored, it was between 2 ex-Yugoslavian states, teams, and as the one side scored, all the scorer did, they showed a certain sign on their chest. And the other side went and they burned down the stadium nearly, because that sign to them was just a terrible sign. I don't know what the sign meant, but this was the sign originating from the conflict in Yugoslavia. So generally speaking, hate speech causes harm, fear, violence, discrimination, anxiety. But violence is not a requirement for hate speech. So you don't have to prove violence in order for hate speech to be proven. It's indicative of hate speech, but it's not a requirement. So what are the questions I'm going to try to answer? The first question is, when can speech be regarded as hate speech? The second question is, what is the test for hate speech? Is it a subjective test, what the person intended in their mind, or is it an objective test? Thirdly, what type of evidence do you need for hate speech? And fourthly, if a finding is made that something that was said is hate speech, does it only look back, or does it in effect look into the future as well? We call it retrospective or prospective. So what are the guidelines in international law for hate speech? These are the guidelines. First of all, bad news. There's no definition in international law for hate speech. International law says hate speech must be banned, but it doesn't define what is hate speech, because hate speech in one country is not necessarily hate speech in another country. For example, if you speak about the genocide of the Second World War in Germany, it may be treated quite differently than when you speak about that same topic in Australia, because of Germany's very sensitive background in the genocide of the Jewish people that were there. So there's no international definition of hate speech. Secondly, before you make a finding of hate speech, all circumstances must be taken account. For example, there's a case in Europe where a lecturer spoke about what he called genocide denial. In other words, where he said the names of the number of Jewish people who were killed does not add up. If that is said at a public forum, it's hate speech. But if it is said in an intellectual forum, it's not necessarily hate speech. So one must take into account what is said, where it is said, and by whom it is said, because hate speech in one circumstance is not necessarily hate speech in another circumstance. In fact, in India, there's a case where the court said some things that we intensely dislike must be said because that enables us to talk about it. If it's not said, we don't talk about it. That was a case that was handed down in India. So all circumstances must be taken into account. Thirdly, the point of departure is that freedom of speech must be protected. This is, and here and there I refer to case law, and you can have a look at that case law if you want to. That's a Canadian case. Fourthly, hate speech must not be used to censor free speech, and it must also not be used to give favor to one group. In other words, judges must be careful that they don't use hate speech just to protect the minority or protect the minority. It must be objective, and this was an American case that said hate speech must not be used to favor the one side or the other side. Fifthly, hate speech can be directed at an individual, let's suppose because of their sexuality, or against the community because of their faith or their culture or their language or their immigrant status or whatever. Sixthly, violence or threat of violence may be an element of hate speech, but it's not a requirement. That was recently said in a decision of the South African Constitutional Court. So when one says that you have been exposed to hate speech, you don't have to prove that there was violence against you. You must just prove there was hate speech, that it was severely hurtful in order to prove it. And finally, seventhly, international law encourages states to enact legislation banning hate speech. I'm not sure if you have that in Indonesia, but it's encouraged to have legislation that bans hate speech. But of course, the application of that legislation is not simple. So let's look at some case law internationally about hate speech and when is speech hate speech. First case to look at is the question, can a symbol constitute hate speech? In other words, there's no words. All you do is you show a symbol. You show a flag, you show a hand sign, whatever, and the answer is yes. A symbol can be hate speech, but in America it's been held that the burning of a flag, burning of the American flag, is not hate speech, it is a political statement. So by putting the flag to fire. But on the other hand, it has been held in South Africa that a flag with a racist background constitutes hate speech. So it depends on the circumstance. Secondly, question that I've already answered is, must hate speech involve violence or threat of violence? And the answer is no. There's no need. This was said in Rwanda, and this was also recently said in South Africa. Thirdly, is hate speech impacted by circumstance? In other words, is hate speech something objectively, wherever you say it, it will always be hate speech? Or is it the circumstances that decide hate speech? And the answer is, it's the circumstances that decide it. It depends, are you a lecturer standing in a hall giving a lecture, or are you somebody fighting a political campaign on the streets? That can determine whether what you say is hate speech or not. So what was said in those cases was, yes, hate speech in one circumstance may not be hate speech in another circumstance. Let me give you the example. We all know that the word, and I'm going to use the word because this was a case, we all know that the word nigger is an unacceptable, hateful word. So in Australia there was a case because there's a stadium that is called that word. And there was a question whether that word in that stadium was an unacceptable word. And the court felt, no, it was not. Because the stadium was named after a very important sport player who was black, but his nickname was nigger. And the court found that the use of that word in that context was not improper, but the use of the word in another context may be improper. And so one must look at the circumstances within which a word is used. Fourthly, is the test for hate speech objective or subjective? In other words, is it what a person thinks and says, or is it what people hear? And the answer of the court is that the test is objective. In other words, what would a reasonable person who has all the information at their disposal feel when they hear that speech? But the problem, of course, is who's the reasonable person, especially in a deeply divided society. For example, if I'm in Indonesia and I say something about the Muslim faith, it may be quite different than when I'm in Australia and I say something about the Muslim faith. Who's the reasonable person? So to a certain extent, the reasonable person test is a fiction. It's in the mind of the judge. Because how many people are you going to call to give evidence to work out how sensitive is a reasonable person? Some people may be more sensitive than others. I may accept criticism of the Christian faith, but some people, as soon as you criticize the Christian faith, may immediately say that's hate speech. So how do you work out what the objective person, the reasonable person, would have said about hate speech? And there are some cases about that. So this is just some of the case law regarding hate speech. What is the threshold for hate speech? As I've already said, it must be the most extreme form of speech. So there were 2 cases recently in South Africa. Within 2 years, I'm going to read it. In 2007, there was a public march in South Africa against the high levels of crime. Persons from all races participated. Someone showed the old flag of South Africa that was used between 1927 and 1993. No racial slogans or racist material was displayed. A complainant saw the old flag on television and said this reminded him of apartheid. And he felt so offended by being reminded of apartheid that this constituted hate speech, the flag. The person who displayed the flag said, no, the old flag has a long and complex history. Of course, it was the flag of apartheid, but it also had a cultural symbol. It also was a symbol against colonial domination by England. And most importantly, the flag had not been banned by Parliament. But the court nevertheless found that the display of the flag was hate speech, then and into the future. So without hearing any other evidence, the court said, when you see this flag, it is hate speech. The next case was a case where people sing a song, kill the boer, kill the farmer. The economic freedom fighters sing this song at public events. So they sing, kill the boer, kill the farmer, and when they sing it, they display firearm or a wooden stick resembling a firearm. And the complainant says, this causes fear, hatred, and the risk of violent crimes. This is in the context of, in 2021, there were 59 farmers murdered in South Africa, 1 a week. And there were 395 farm attacks, 1 a day. 1 a day. And so this farmer says, when I hear this song, I am petrified. I am scared. I feel the hatred. I cannot handle it. And the court said, no, this is not hate speech. You must take into account the background of the song. It's a liberation song. And it's not hate speech. So in the one case, the court finds that the waving of a flag that somebody sees on television is hate speech, and on the other hand, the court says the singing of a song, kill the boer, kill the farmer, is not hate speech. So what is the critical analysis of these cases? 1, the court was inconsistent, I think, in the weight that they attached to the background of speech. In the old flag case, they said that the mere display of a flag is hate speech. Whilst in the kill the boer, kill the farmer case, the court took into account the history of the song, which they should have done. One must take into account the history, but they gave more weight to the history in the second case. Secondly, the court was inconsistent in the objective test they applied, because both judgments used the objective test, but the question was, well, what is the reasonable informed person? How do you work that out? How do you know the reasonable informed person would be offended by the flag, but the reasonably informed person would not be offended by a song saying, kill the boer, kill the farmer? Thirdly, the court was inconsistent in the evidence they required to prove the speech. In the old flag case, the court said the mere fact that you saw it on TV is enough. In the kill the boer, kill the farmer case, the court said even if you feel scared when you hear the song, and even though so many farmers are murdered and assaulted, one must take into account the background of the song. Finally, is the declaration of hate speech retrospective or prospective? Now, normally in cases throughout the world, hate speech is determined retrospective. You look at a certain incident and you say, on that day it was hate speech. You don't say into the future it will be hate speech because the circumstances may differ. But in this case, in the old flag case, the court held that the display of the flag on that day was hate speech, and forever into the future it will be hate speech whenever it is shown. Without the Parliament having banned it. Parliament could ban it, but Parliament did it. The court said whenever it is shown into the future is hate speech. Now, I can say both of these judgments, I believe both are wrong, and both are at the moment being appealed to the Constitutional Court, so you may want to follow that. In conclusion, I answer the questions that I put. When can speech be regarded as hate speech? And I answer that it's only for the most extreme form of speech. When the restriction on freedom of speech must be proportional and it must be limited. One only goes as far as you need to go because freedom of speech remains the most important principle. Secondly, what test is applied? Is it objective or subjective? The answer is it's an objective test, but there's an issue. How does one determine objectivity? Whose views do you take into account? Who's the community? Can you really find in a diverse society a neutral person or a group of persons on whom you can rely to work out what is hate speech? Thirdly, what evidence is required for a finding of hate speech? And the answer is all evidence must be taken into account. So what happened on a day, what was said, who said it, what was the purpose of the event, etc. And then finally, is a finding of hate speech prospective or retrospective? And the answer is that the decisions are always retrospective. It refers only to a specific event on a specific date, and it does not try to regulate issues in general. Thank you, Chair.
Perfect. Thank you. Now, turn to respondents. I would like to invite the first respondent, Mr. Andi Omara from Universitas Gadjah Mada. Please, 5 minutes.
Thank you very much, Mas Herlambang. I learned so much about this paper, Professor. And your paper is actually said that it is difficult to draw a fine line between the freedom of expressions and hate speech, where the freedom of expressions and hate speech begins, and so on and so forth. And you also mentioned that there is no universal definitions of these two collide values. And my impressions when you provide an example about the old flags and kill the brewer, that's become a very interesting part for me. And in treating these two different cases, the court seems that they provide different legal reasonings on how the first or the second case would be very elaborative and the other one is really not. They consider many different things and the other one is really not. So my curiosity about your paper, is it possible if you broaden your paper concerning what actually the contributing factor why the court provide different quote-unquote treatment in these two different cases? Would it be because of the compositions of the judges, their experience, the petitioner's identity, the nature of the case, the political situations, or the justice background? And these are actually the possible factor that maybe more can be added more, but I think when we look at a very specific case in very specific context, then many possibilities may come up, not only from the petitioner side, but also from the judge's perspective. And I think that would be my first response to your paper. And then my second response and my final response is that, do you think if it is difficult to find the universal norm for defining the freedom of expressions and hate speech, is it necessary to have a universal standard to determine these two terminology? Thank you.
Thank you, Mr. Andi Omara. And next, second respondent from Constitutional Court, Mr. Alboin Pasaribu, please.
Thank you, Chair, Mr. Herlambang. Good afternoon, Dr. Palguna, distinguished speakers, and all participants. Professor De Villiers, this is a very fascinating and comprehensive paper. I enjoyed and got a lot of insight from your paper. I agree and emphasize how difficult it is to define hate speech globally, as well as the reasonable and proportional limitations between freedom of expression and hate speech. And I concur with the position that must be questioned, as well as the challenge in the interactions between freedom of expression and hate speech, namely when speech qualifies as hate speech, on what tests and evidence are required, and scope of the judge's decision validity, which is retrospective and or prospective. In a democratic republic state, criticism and protest against government policies are common. In Indonesia context, the Constitutional Court has dismissed several articles of the Criminal Code that criminalize hate speech and defamation against government or state official. In Dutch, we call it Hadzai Artikelen. The Indonesian Constitutional Court promotes equality before the law, hence emphasizing the necessity for a separation between state interest and president interest. Regarding this, what if the restriction on freedom of expression is designed to prevent criticism and dissent against government policies? And then, in a few cases in Indonesia, the possibility for violations of freedom of expression arises from a lack of comprehension on the part of law enforcement officers, particularly the police, regarding the aspect of hate speech, especially when it occurs in cyberspace. Based on your research, is this also faced by other countries? What steps should be taken to address this? And regarding the two cases in South Africa present in your paper, did the composition, knowledge, and experience of the judges influence their decisions? The conclusion of my earlier comment, when delivering interpretation linked to hate speech, judges need to explore further through historical, anthropological, cultural, and sociological perspective. Because the idea of hate speech is intimately tied to the history and culture of a community or a society group. This requires the judge to take a multidisciplinary approach. The role of the judge is made more complex when dealing with cases of hate speech, since the analysis is not exclusively legal or positive and overlaps with empirical and historical study of a group. Thank you.
Thank you, and good point. That is, Hadzai Artikelen means heart rate showing in English. I would like to invite 1-2 questions. Oh, a lot. Okay, Pak Palguna and I forgot your name. Oh, who? N. Okay. And black and one from there. Okay, Pak Radian Salman. Okay, only 3, yeah. Pak Palguna. Please.
Okay, thank you, Chairman, Mas Herlambang. It is really an interesting presentation, so makes me come up with a question. Am I appropriate to say that it is almost impossible to establish what is a general and all-inclusive formulation of hate speech, so as to make it difficult to categorize whether hate speech is a mala inse or mala prohibita in the context of a theory of crime. Maybe you have another elaboration in this context. Thank you.
Next.
Thank you. Tapped on lots of things. Just a quick question though. Does hate speech have to be published in the sense that it has to go beyond you and me? So if I said something hateful to you, can there be a remedy from it? Or really is the nature of hate speech about educating the community and bringing in some form of self-censorship so that I don't do it in any kind of forum again?
Good point. Pak Radian, please.
Thank you. Just very quick question. For the argument for hate speech is the primary concern, however, is the harmful effect in hate speech. Yeah? I believe that the goal of today's international criminal law on incitement is to prevent real threat emanating from the speech, from the hate speech. So my question is about an indication or criteria of from potential threat to real threats emanating from hate speech. Thank you.
Okay, thank you, Pak Radian. And I think first must be responded first by the speakers. Oh, okay. You, one small. Okay, please, Mr. Sabu. Yeah.
How do you explain the inconsistencies in the court's rulings? For example, was the composition of the court same? Because it seems to me that the old flag case is very similar to the Kill the Farmer case. The only explanation that comes to my mind is the past experience of the country, apartheid, white minority. Do you think these considerations play a role?
Okay, so you have 8 questions right now.
Well, I most certainly can't answer all the questions. I'll be very brief. First of all, why the different treatment? Yes, I think the apartheid background played a role. So I think the second case, the Kill the Boer, the Kill Farmer case, was informed by the apartheid background. Now, let me say, I can understand as a scholar that in the liberation struggle, one could have had a song, Kill the Boer, Kill the Farmer, because there was a war going. I mean, the Ukrainians today may sing Kill a Russian. But the question is, what happens after peace? Do you then keep on singing that song? So in other words, can something which is hate speech today lose its hate speech status? Or how do you deal with past songs? So in this case, yes, I think the answer is to both of you that the judge was a person from the background of the struggle. But there are 2 cases that I want to refer to. In America, the RAV case, it's in my paper, the court emphasized that courts must not value the sensitivity of one community over the sensitivity of another community, because then the court becomes a platform of the majority, and then the court no longer protects the minority. So the answer that I give, that it was the liberation background, doesn't defend the decision. It simply says what the background is. Is there a universal norm? I don't think the problem with hate speech is to get a universal norm. It's in the application of the norm. It's very much like saying, let's have a democracy. How do you apply it? Let's have constitutionalism. How do you apply it? Let's recognize indigenous rights. How do you apply it? So the devil hides in the detail when you start applying hate speech. And you ask yourself, well, is this now inconsistent with what one would expect in a democratic society? For example, if one showed the Nazi swastika in Germany, that would be regarded as hate speech. But if you showed it in Australia, people would just say that's not a good thing to show, but it's not hate speech. So the same symbol that we all detest can be shown in different places with a different consequence. There is indeed a danger that governments can use hate speech to censor people. That's why the American Supreme Court would rarely find speech to be hate speech, because it's such a fundamental principle in America, freedom of expression. Because when you start limiting speech, I mean, if you walk at a public event against crime with a farmer being assaulted every day and a farmer being murdered once a week, and you show a flag and you are then told that is hate speech, then you start censoring the ability of people expressing themselves. I think we've heard about, I've spoken about the experience of the judge. The question of Professor Palgana was, how does this impact with criminal law? And what many countries prefer to do, sir, is through criminal legislation, they would ban the display of certain symbols. So they won't wait for it to be used in the hate speech context, because it's so ambivalent. Can you now show the swastika or can't you? So they rather ban it. They say the swastika might not be shown. But then there's a case by the Bundesverfassungsgericht in Germany where they said that even though the National Socialism system that they had, that we know as the Nazi system, is offensive, one must not ban it to the extent that it can't ever be discussed anymore, because then future generations won't learn about how wrong it was. Because if you close it, it's like saying apartheid is so bad we can't talk about it. Well, if you don't talk about it, you don't learn from it. So how do you manage that? So one can ban it by way of criminal legislation, but even then one must be careful, because people may raise a defense of freedom of speech. So it's not simple. The question by Professor Black about whether hate speech should be published, if speech is said to you in private, then that would rather fall under criminal injury or something like that. So there must be a public element of hate speech. But interesting, there was a case where people on a closed Facebook page had hate speech exchanges, and that was found to be hate speech, even though the Facebook group was closed. So it needn't be to the public. It needn't be to the public at large. But the hate speech does not extend into the privacy of your home. Most certainly not. There was a question whether how hate speech interacts with the threat of violence or real violence. Well, hate speech doesn't require a threat of violence or even real violence. Hate speech is something that affects, I think the Indian court recently said, it affects your dignitas. It affects your inside. And that's why it's so hard to get an objective test for it. It's as if something dies inside you when you are exposed to hate speech. But the question is, how do you determine that objectively? That's the problem.
Thank you very much. I think we still have 40 seconds. Okay, only one. The red shirt, please. Please.
Thank you so much, Mr. Chairman and the speaker. So yeah, regarding the freedom of speech protections, there is an alarming global risk regarding the democratic backsliding, as Thomas Brooke mentioned that. So you know that the government is trying to limit the freedom of speech by targeting people who have different view with the government. So I just want to ask your opinion about the issue that is really happening in many countries nowadays. Thank you very much.
Well, I think that is the point that has been made, and that is one must be very slow to legislate with hate speech in general because it can so easily be abused. Once you have a parliament that legislates against hate speech and that same parliament appoints the court, then you're just this far away from censorship. Just this far away. And so one must be careful. That's all I can say. At the same time, if somebody really offends you, I mean, there are certain forms of speech. I mean, all you need to go back to the 1940s and see how in Germany they spoke about the Jewish people. Now, I mean, nobody can defend that. So, but where does one cross that line? Where does one cross that line where censorship happens under the protection of hate speech? It's a challenge.
Okay. Thank you very much, Professor Villiers. Yeah, Bertus de Villiers. You cover all questions in what is that? In a precise time. I think we still have 4 raised hands, but if you need to discuss more, you can discuss it during dinner if you are okay with that. So please approach him and applause for Professor Bertus. Next. Next sessions or next presentation will be my colleagues from India, but he's going to present about Hungary and Slovakia. It's about value conflicts and constitutional courts, unjust democracy, ? From Max Stur. He is from Jindal Global University and also Comenius University in Bratislava, Department of Political Science. And also, I would like to invite 2 respondents. The first one is from Universitas Jember, who is going, Professor Bayu Dwi Anggono. Then the second respondent is Mrs. Winda Wijayanti. Here? Okay. Please. And you have 20 minutes. Please.
Thank you very much, Chair. Okay, thank you very much. Good afternoon, Selamat sore, if I pronounce it correctly. Thank you so much for giving me the opportunity to discuss one of my ongoing research projects with you today, which addresses the interaction between the 3 institutions I'm particularly interested in, and those are democracy, law, and constitutional courts. I was also requested by Ryan, I think this morning, who presented to address the relationship between constitutional courts and backsliding of democracy. So I will try to do this a little bit, but certainly cannot do justice to the subject here, even if I exploit all my 20 minutes. The central general message of my talk, based on my broader work beyond this particular paper, is as follows. In order to build resilience, constitutional courts committed to democracy need to explicitly engage with the concept of democracy, developing readings of democracy that challenge contemporary illiberal and authoritarian readings of the concept, and relate it to a broader set of values, including justice. So I will try to unpack this central claim, central message as we go along, and hopefully the technology will assist me in that process. The theme of this conference is constitutional courts and conflict resolution, and as emphasized by several speakers before me, indeed, this is a key task of all courts, to be an authoritative third party whose decision is then complied with. The fact that in principle no party can suppress, sorry, there seems to be some issue with the technology, and no party can suppress another thanks to the court deciding, is key to prevent the concentration of power and to fostering pluralism. And this is where, by resolving disputes, courts may also protect democracy, where everyone counts and no one is disregarded. While all courts are important in this regard, centralized constitutional courts matter particularly due to their capacity to authoritatively interpret the Constitution, the founding arrangement which enshrines the values of the society. It is consequently no surprise that courts are subject to assaults, as Bugaric and Ginsburg would put it, or efforts to capture them by those who would like to gain unlimited power. The literature uses many terms for this trend: erosion, deconsolidation, backsliding of democracy, or autocratization, as Dr. Chair is using in one of his recent pieces. Some of others in this room have contributed to this literature. This trend is visible both in the region where I come from, which is Central Europe, the European Union member states in Central Europe, as well as in the country where my institution is based, and that is India. But I should say that I do not claim to represent India in any way, and there are many excellent scholars working on India who could do so. Sometimes it remains underemphasized, however, that illiberal or autocratic actors do not say that they are against democracy. Rather, they argue for a different view or conception of democracy. In particular, they try to convince us that democracy is only the will of the majority, which embodies the people. Many scholars, including legal philosopher Ronald Dworkin, warn us before these readings. Dworkin says, as I hope you can see on the slide, a political system with equal suffrage in which the majority distributes everything to itself with no concern whatever for the fate of the minority will not count as an unjust democracy, but as no democracy at all. In this struggle for the meanings of democracy, the meanings developed by the constitutional courts are particularly important, as constitutional courts offer the authoritative readings of democracy enshrined in constitutions. It is against this backdrop that I ask, how do constitutional courts conceptualize democracy, and what does that tell us about the self-perception of their institutional roles, or we may say mission they fulfill in the constitutional system? And I address this question by examining two Central European, formerly powerful courts as they grappled with the relationship between justice and democracy. I think that this is a kind of question that allows academics, observers, critical friends of the courts, to borrow a phrase from democratic theorist Calypso Nikolaidis, to learn from examining how ideas appear, advance, and vanish in constitutional court case law. There is, of course, enormous scholarship on the constitutional courts, but it is less focused on ideas in general, in my view. Courts are often seen as counter-majoritarian. This comes from American scholar Bickel, which, if you think about it, however, implicitly embraces a conception of democracy as majority, a view amounting to, borrowing from Susan Marks, false necessity. How to remedy this gap? I argue that it is helpful to borrow from institutionalist theory in political science, particularly the interpretivist tradition of this theory, that highlights the relevance of ideas for political change. This approach allows us to uncover the different readings of key concepts that are also represented in many constitutions. We can look into cases, but we can look also into other sources of constitutional court decision-making with the assistance, with the help of this approach. Now, as the title of my paper suggests, I focus on the references to democracy in relation to justice. And there is, of course, no space at all to provide any detailed discussion of theories of justice. We heard in the morning, justice is what the community thinks, believes that justice is. There are extremely wide ranges of other readings as well. So I just tell you that I conceptualize justice here in this paper through procedural and social rights, which I believe provide a window into constitutional courts' conceptions of political and social justice traditionally discussed in the Western literature from Aristotle to Rawls. But of course, this point can be challenged, and I look forward to discussing it as well. Now, the concept of democracy itself is kept open in my work to enable to analyze both its minimalist, middle-ranged, and maximalist readings. It is the latter that rarely appear in the existing literature on constitutional courts due to, as I mentioned, this prevailing emphasis on their counter-majoritarian character. And an article in which I made this point for the first time was kindly referred to earlier this afternoon by one of the respondents. In terms of the jurisdictions that I cover, I focus on 2 jurisdictions. Slovakia is a small European Union member state that has faced a major challenge of justice pertaining to early efforts of autocratizing the emerging democracy in the 1990s by Prime Minister Vladimir Mečiar, on the left in the photo, which resulted, among others, in the kidnapping of the son of the president, Mečiar's opponent, and the murder of one of the key witnesses, with evidence pointing to the state secret service committing the crimes. By issuing amnesty decisions, Mečiar prevented effective investigation, and the Constitutional Court had to deal with challenges to the constitutionality of these decisions. Now, it may seem that this is a period of the past in Slovakia, but in fact, just in 2018, a journalist and his fiancée were killed due to the journalist investigating high-profile corruption cases, which alone indicates that Slovakia's democracy is far from being a robust, consolidated one. Now, my other jurisdiction I focus on is Hungary, but I want to underscore that I think it is important to focus on other countries as well. And sometimes this language of focusing on Hungary and Poland in Central Europe as the only regimes that are autocratizing may restrict our attention. So Slovakia is important in this regard as well. But of course, Hungary, while Slovakia was undergoing this autocratization process, was seen as a poster child of democratization, but today it is seen as deviating most from the common values of the European Union community. Hungarian leader Viktor Orbán claims to build an illiberal democracy, establishes alliances with the extreme right, and advances opposition towards European Union institutions. Now, the Hungarian Constitutional Court then operates in this increasingly illiberalizing, if not autocratizing, regime. Now, more specifically, however, there is a combination of reasons in support of focusing on these 2 constitutional courts within the broader set of jurisdictions that face erosion of democracy in Central Europe. As I said, I think it's more than Hungary and Poland in this regard. I just highlight 2 of these here. Firstly, both of these courts remain formally independent in that they have been constituted in accordance with the constitutions of their respective countries. This is not the case, for example, with the Polish court, we may discuss in the Q&A. Relatedly, the courts are formally among the most powerful in the region, with the Slovak court having some 20 competencies at the moment. I understand that typically it's to have 4 or 5 competencies, so the Slovak court has about 20. And the Hungarian court is known in the early 1990s and 2000s at least to possess the actio popularis competence, where every individual could petition the court for abstract constitutional review of legislation. And Professor Warren in the morning provided us with an excellent overview of a range of competencies and the degree of openness of constitutional review. And it is not by accident that she put the Hungarian court on top, at least before the transformation of 2010, as one of the most open courts in this regard. Now, before taking you through the key results of my analysis, just what researchers often do, a short methodological note. How did I collect my data? How did I analyze them? I focus on the case law in this paper of the court as an institutionalized form of expression, conducted a keyword search for references to democracy that allows to bring in not only landmark cases, but also the less frequently referred stories from the court's vast case law database. It does mean that some canonical cases might be left out from the analysis, but I would say this is itself a finding because it tells us that the court did not establish a connection between the issue in the given case that it analyzed and democracy. This data collection method has generated 77 majority opinions. I covered the period between the 1990s, the establishment of the courts, and 2017, so maybe some updating would be needed. And I do not focus on separate opinions in this paper. I apologize to the respondents because there was an appendix on separate opinions, but in the presentation I will only discuss the majority opinions. So how do the 2 courts understand democracy in relation to justice? Again, no time to delve into the case law in depth, so let me just highlight some general trends, and let me use a periodization of the 1990s, 2000s, and 2010s, because these are standard ways how we can analyze the jurisprudence of the Slovak and the Hungarian court, broadly speaking. In the first period, we need to remember that the Slovak court fought with the semi-authoritarian regime that issued the amnesties also, as I mentioned to you. Hence, it had a good excuse to focus only on minimum interpretive essentials in relation to democracy, such as ensuring free and fair elections. And this is an association to democracy that has been raised by several judges at this conference, actually, already yesterday. But its 1999 amnesty's decision of the Slovak court comes from after the defeat of the semi-authoritarian majority in elections of 1998. Yet the court adopts a very limited formalist reading, allowing the amnesties against crimes of the semi-authoritarian regime to remain valid. And this has only changed with a constitutional amendment following another constitutional court case in 2017. We can discuss this case later on, those who are interested. Now, the Hungarian court in this period did not have a similar excuse, fighting with a semi-authoritarian regime, yet its jurisprudence features virtually no connections between democracy and justice, put in explicit terms, not only in this period actually, but also in the early 2000s, and this is not something I would say one would expect from a court that was celebrated by many in this period in particular as the most powerful and among the most successful in democratic consolidation in the 1990s. Now, in the 2000s, both courts gradually started to connect democracy at least to the context of the criminal procedure, procedural rights, that is to say. And in the Slovak case, some anti-corruption claims appeared in relation to the growing formulation of democracy in the case law. However, for the Hungarian court, it appears this was too little and too late, and when in 2010 the court started to face the illiberal constitutional majority of Viktor Orbán elected in this year, we can say it already threw off the branch it was sitting on. In other words, it incapacitated itself by a restrictive reading of democracy. The Slovak court, while not facing a clearly illiberal majority, in this period demonstrates slow and gradual awakening, I would say, by including more values in relation to democracy, and particularly prominent in this regard is its 2017 amnesty decision that also boosted the connection with the public, because the public very much supported the abolishment of the amnesties of the Mečiar executive in the 1990s. Now, my approach, as perhaps all approaches to research, has some limitations. Very briefly, the number of cases, first of all, that is discussed prevents to analyze every single one of them in depth. Thus, I rely largely on existing case-specific analysis by others. Secondly, the case selection based on keyword search might omit important path-breaking cases that did not refer to democracy. I also mentioned this before. And for this purpose, I'm adding in other works also commentaries to constitutional court decision-making, as well as inter-EU data. Thirdly, even the maximalist conceptualization of democracy stems from particular research traditions and may overlook the richness of the meanings of democracy, particularly in the non-Western world. In fact, one scholar identified over 2,000 readings of democracy, so I would not claim that even the maximalist conceptualization would be able to encompass all of them. Further research, not only of the Hungarian and Slovak courts, needs to go beyond political and social rights, and I do this in some of my other works to encompass other dimensions of democracy. There is also space in more exploration of the underlying judicial ideas and philosophies, including traditions of the philosophies of law, of individual judges, as we have also heard by Professor Cohen and Dr. Wright this afternoon. To conclude, I think that the interpretive institutionalist approach I'm pursuing in this paper helps us improve understanding how constitutional courts and their judges perceive themselves. It also raises the question on how the implications of the constitutional court's mission of democracy protection that several constitutional court judges themselves highlight, how this mission allows them to understand better the context of the regime in which they operate. Ultimately, it seems to me that the courts have two options, following the well-known social thinker Alberto Hirschman and his distinction between three major types of decisions that are available for actors in many situations: exit, voice, and loyalty. I say, however, only two, because courts can either exit the debate on the meanings of democracy, thus allowing other often partisan actors to take control of it to the detriment of the quality of the regime, or the courts may develop their own voice in this debate on democracy that is also authoritative because of their role as interpreters of the Constitution. Hirschman's third option, loyalty, provided we understand it as loyalty to the Constitution, necessitates opting for voice. Ultimately, it may enable the constitutional courts to remain in public minds and become more resilient against their challengers as well. So voice over exit, that is the message I would leave you with. Thank you very much to everyone, and especially to the online participants. If there is someone who remains connected from 8 a.m., then you have my full admiration. I look forward to the comments and to the interaction with you. Thank you.
Thank you, Max. I think we are happy to get closer with the Hungary experience today after Sabu's presentations, and then continue with Max. And also, thank you for referring my works on judicialization of authoritarian politics. Good to know. Now, I would like to invite Professor Bayu Dwi Anggono to give a comment, please.
Good afternoon. At first, I would like to thank Chairperson Mas Herlambang of Decision, and congratulate to Max Teur for a very interesting topic in both of presentation and paper. As stated by Max, he has successfully portrayed the role of constitutional court in a fragile democratic country, Slovakia, and regressing a liberal regime at Hungary. Max started his paper with a classical debate between Kelsen and Smith, while the first one argued that it is the task of the Constitutional Court to interpreting the Constitution. The other said that the court never had such political legitimation. According to Smith, it was the task of the nationally elected Reich President who has sovereignty to interpretation the Constitution. From Kelsen, judicial point of view, and Smith political constitution-making power, signify to unfixable point of view. At this point, Max offered his own interpretation through constitutionalist perspective. According to Max, as shown in the experience of Slovakia and Hungary, the less democratic country will affect the legitimation of constitutional court. In other words, the eroded environment will also eroding the supremacy of court decision. As way out, the court tend seeking legitimation through adopting majoritarian view of justice, while also try to giving minimum protection for the less advantaged party. This topic then remind me of the work from Sebastian Pompe and Lisa Helbing, both as showing the primacy of democratic environment which affecting the court stand of human rights protection as shown in Indonesia and Chile experience within their respective studies. And it also remind me of the word of Justice Marwar Sihaan, who once said that it was due to support of public awareness of human rights, the court could have confidence in deciding sensitive case. Albeit his methodological preference, as I said, this is quite challenging topic, and Max research has unveiling how far the constitutional court in hostile democratic country could play as role as the protector of human rights. How much price to be paid in search for court legitimacy? That is the main question. How far the court surrender the anthropological facts and sacrificing some of individual rights, that's one thing. Another fundamental aspect in the keyword method employed by Max, in my point of view, does the keyword should really determine the democratic element contained in the decision. Let's say, how to determine the parameter of democracy within the court view. Furthermore, in the any change of paradigm shift in SSG and HCG, how do they define the very word of democracy itself? That's my response. At the same time, my question to Max. Thank you.
Thank you very much, Professor Bayu. And then I would like to invite the second respondent, Mrs. Winda Wijayanti. Please.
Thank you, Dr. Herlambang, the chairman. Good afternoon, ladies and gentlemen. It's my honor to be respondent in this paper. Mr. Max Stewart, your paper is very impressive because you have comparing two constitutional courts. There are Hungary and Slovak. Analyzing them with period from 1990 to 2017. And discussing about zooming procedural and social rights to solve societal conflicts. The title of your paper is Unjust Democracy, Value Conflict and Constitutional Courts in Hungary and Slovakia. I think democracy is always fair. For example, in Indonesia, democracy is indeed the Pancasila. There are 5 values that becomes the basic or fundamental of Indonesia state and the communities. Democracy is on the 4th values or principles of Pancasila, that democracy led by the wisdom of the representative of people. So what is the value in judge decision of constitutional courts in Hungary and Slovakia to solve the conflict of the petitioner or in society and to make democracy become just or fair? Secondly, in your article said that constitutional court might well support majoritarian preference at the expense of minority protection. I think it's very unfair to the minority. How about minorities like the poor, hunger, children, disabled, women, migrant workers, culture or indigenous society, etc.? They are marginal or vulnerable groups in the view of Constitutional Court of Hungary and Slovak. As we know, they need special treatment and protection from the state. Have the decision of Constitutional Court of Hungary and Slovak accommodated the marginal or vulnerable groups' needs? Thank you very much, Mr. Max Stewart, for inspiring and sharing us through your paper, giving reminder in your recommendation about the role of the Constitutional Court as conflict mediators and treating human with respect to get a good life. Thank you.
Thank you very much, Mrs. Winda. Good point also. I would like to invite the floors now. Any questions? Mr. Sabu, Mr. Yance. Okay, start from Mr. Sabu.
Given that we are speaking about Hungary, I cannot be silent. I have some comments and take it as a question if you want. Maybe at the end I can develop it into a question also. I didn't read your paper in detail, so I tried to reflect on your presentation mostly. But of course, I would like to address the general context around Hungary now. You know, I'm not a government agent, so I'm also a scholar, and I also see the shortcomings in Hungary. I would rather consider the government populist instead of authoritarian. Of course, these go hand in hand. One goes with the other. But very often what I experience is that cases are selected and put in this illiberal context worldwide, and sometimes we just miss the point. Illiberal is, of course, not a good, but how to say, a proper definition, because the Prime Minister himself declared his system illiberal. But the question is why he was elected 4 times with a big majority. You cannot only blame the electoral system of Hungary. And the question is, I think, the most important question, why is it happening? You cannot claim the leaders something is happening in the society and the outcome that illiberal leaders, populist leaders receive votes is not the result of the crisis of liberal democracy, but the symptom. I mean, liberal democracy has achieved a lot, but for millions of people, it is just not what they want. And they are happy living in also in authoritarian, but definitely in illiberal regimes. And of course, it's our responsibility to tell them about other possibilities, to educate them. But on the other hand, we have also to understand this as a fact that these governments are sometimes extremely popular, and this is the people who chose them, as I said, 4 times consecutively in case of Hungary. So the coin has 2 sides. That's what I wanted to add as a comment to this conversation. Maybe you can follow up on this. Thank you.
Okay. Mr. Rianche, please.
Thank you. I would like to provide suggestion instead of question. Yeah. Maybe you can also include Indonesia as a case study. Because we also experience some tendency about so-called like authoritarianisms. And last week, Pak Palguna wrote an article about the Indonesian constitutional court under attack as well, because last week one of the constitutional justices was just dismissed by the parliament. So this is maybe it's also interesting to see what will be happen with Indonesia. Maybe they will also follow what already happened in other countries as well. And the other thing is about authoritarianism. I wonder about this, because usually authoritarianism is domination by a single political leaders. You see like that, whether it is civil or military authoritarianisms. But in different countries, sometimes they are not controlled by single dominant political leaders, but there can be with some people, some collection of political leaders, including business actors as well. So in Indonesia, it is quite difficult to show the current or maybe becoming political will become authoritarian. But if we trying to consider this as an oligarchy, maybe it's more clear in Indonesian context, because in oligarchy we can see that the combination of the political leaders and also businessmen, and then they try to control not only the executive but also the parliament as well. So I don't know, whether you think that oligarchy can be also a factor in it.
For the first time to have Kong. I would like to suggest you to have same table during dinner with Max. You got many feedbacks now instead of questions, please.
Thank you very much. These are very rich and encouraging questions and remarks, and I really appreciate all of you for raising them. I will not be able to do justice in my response to them, but I will try to at least make a few remarks. So first of all, Professor Bayu, thank you so much for highlighting the challenges in this method of using the keyword search, because of course you're right that democracy is not only appearing as relevant in constitutional court decision making when they explicitly refer to democracy. So I think there is great value in doing the perhaps more established traditional work where the legal expertise is used to identify the key landmark cases and analyze those in relation to political concepts. Now, that is to say, in Central European context, even that work more rarely engages with democracy as compared to, for example, human rights or the rule of law. my claim is more minor. I'm trying to highlight that if there is no explicit engagement with the concept of democracy, explicit references to democracy, then in a sense that particular concept is allowed to be used by other political or even partisan actors, we could say, and the Constitutional Court doesn't really have a clear voice in it. Perhaps, however, legal elites, legal specialists can bring into the public discourse that connection that is not explicitly present in the Constitutional Court case law. And certainly, I think that the second comment that you make in relation to human rights and the broader need for constitutional courts to address and protect human rights actually relates also to my second respondent, Ms. Vinda Vinayanti, who also highlighted this importance to focus on human rights protection more broadly in constitutional court case law. And I completely agree. And I have another work where I look at political and civil rights, so to speak, first generation rights. And there the picture is perhaps a little bit more favorable towards the constitutional courts in Hungary and Slovakia in terms of the degree of their engagement with these rights. However, when it comes to, and I think that's an extremely important question, to the protection of the vulnerable, there are quite a few decisions where we could say that the constitutional courts have not done as much as they could. I mean, of course, in the Hungarian context, there is the decision on the referendum on refugee exclusion, which was really, in a sense, against the protection of the vulnerable, we could say in very crude terms. In Slovakia also, there are social rights decisions which have been adopting very restrictive readings of social rights. So absolutely there is perhaps more that these courts could do. Now, you know, my claim that the courts can support majoritarian readings of democracy is an empirical one. It's a descriptive one, that we may see that in constitutional court decision making. It's not something I would personally support, but it's something that we may observe, and that challenges this notion that constitutional courts by nature are counter-majoritarian. And I'm not the first one to make this claim, of course. There have been more prominent scholars before me who have done that. Now, to Professor Zsolt-Szabó, thank you very much for joining the discussion, and I completely agree with you that a lot depends here on how do we define, conceptualize, of course, these terms, and we may use the concept of populism. Now, there we again run into a range of different readings, and the scholarship is extremely vast in that sense. I actually don't use the term autocracy for Hungary. I use the term autocratization as the process which, following the varieties of democracy, one of these democracy indices that conceptualize the quality of democracy is looking at the kind of axis between democracy and autocracy. And the process of deterioration of democracy amounts to autocratization, which does not necessarily mean that the regime already is an autocratic regime, but certainly if we use even the term of illiberal regime, we have some problems with associating it with democracy, because illiberal democracy, I would say, is an oxymoron, is a contradiction in terms, and that is something that, as you highlighted, the Hungarian Prime Minister himself claims to be building. Now, we don't have time, of course, to discuss the kind of social background of Hungarian society. I'm also not the most qualified to do that. There are great Hungarian sociologists who are engaging in that process. I think one argument that could be perhaps quickly made is with respect to the role of the media. So also the freedom of the media is very much encroached upon in Hungary. We have other indexes for that, and in that sense it's very difficult for people to get information. So I would also see perhaps here the kind of potential explanation for support, for continued support of the liberal government. And to Dr. Jans, thank you very much. Yes, of course, looking at other countries is always very valuable. Also, this forum is very inspiring in that context. Perhaps in collaborative work, this can be done also with non-European jurisdictions. When it comes to role of other actors than single political leaders, absolutely there are works, for example, by Bálint Magyar, who is a Hungarian prominent sociologist scholar as well, who is writing about the mafia state, or sometimes also you have the notions of the captured state. So there is literature in hybrid regimes that definitely really highlights this point. But still, I think it underscores that the development is towards autocratization. Doesn't necessarily mean that it is already an autocracy. Some already use this term, some scholars, but there is a clear direction of an illiberal regime, which then raises the question of how the Constitutional Court exists, engages in the illiberal regime. And there, I think we also need to hear more from the judges themselves through interviews, through trying to explore what happens inside of these courts. I think that is very important for advancing our knowledge. Thank you very much.
Thank you, Max. I think we have to stop for these sessions, and thank you very much for Max, Tur, and also to respondents, Professor Bayu, and also Ibu Winda. Applause for presenters and the. Yeah. Yeah. Thank you. Okay, so although nearly at 5 or already 5, yeah, but we still have one sessions. The last will be presented by two scholars from Erlangga University, Dr. Radian Salman and Dr. Rosa Ristawati, please, and also two respondents. It's my colleagues, Pak Muhammad Mova from Ibnu Khaldun, Bogor, and also Miss Andriani Wenuvitasari. Okay. Yeah, I think it's better to start 20 minutes for, please. Yeah.
Thank you, Mr. Chair, my colleague, Dr. Helambang. Distinguished speaker and all participants, I think this is the end of the session, and this is the hope of people of Indonesia, that now is all Indonesian final. Yeah, here speakers and also respondent and also chairman is an Indonesian. Yeah, please help me to show my slide, please. Yes, thank you. I'm co-author with author Dr. Rosa Ristawati. Will deliver our paper about the Republic Indonesia Constitutional Court on the effort to prevent social conflict in the diverse society in Indonesia. Okay, this is the fact we all know about Indonesia, that Indonesia is a diverse state of society with plural in ethnicity, cultures, and religions, with the motto of unity in diversity and the signature of the culture and ethnicities. In our view, in my view, that all its people live together largely in peace. At least you may compare to other countries where they are facing social conflict until now. And Indonesia's diverse society indeed potentially has the risk of conflict. So in our paper, we say this is an inherent risk for a diverse society like Indonesia. And therefore, many feel that diversity is an obstacle to the unity, and it has long been associated with adverse social outcomes. So in this part, not necessary for us to provide data concerning this kind of plural in ethnicity, culture, and religion. From this background, we concern on two issues. First is the role of the Republic Indonesian Constitutional Court to reduce the risks of diverse society, namely conflict, social conflict, and then how the court has made a significant contribution to uphold the constitutional values of maintaining the community in Indonesia through its decision. Before further provide and explain some decision of the Constitutional Court concerning effect to the social community, I would like to provide a constitutional clauses on diversity. Maybe this kind of clauses you will not find in each country, but a country where the pluralism, where many different aspects in the state, in the country, you will find about it. Article 18b, paragraph 2 is article concerning recognition of the state and respect to customary law community unit and their traditional rights as long as they are still alive and in accordance with the development of society and the principle of the unitary state of the Republic of Indonesia, which are regulated by law. So in this article, from this article, even that state recognize customary law community, for example, that there are limitations that already set out in the Constitution. The limitation is, one of the limitation is the principle of unitary state of the Republic of Indonesia. A second article is an individual approach concerning protection of the right. In Article 18b2, this is what I say is in the context of public, but our Article 28 G, paragraph 1 is protection for individual right. It says that everyone has the right to personal protection, family, honor, dignity, and property under their control, and has the right to a sense of security and protection from threat of fear to do or not to do something which is a human right. Those two clauses from Indonesian Constitution will be analyzed through some decision of the court. But before discussing about the decision of the Constitutional Court, here I would like to show you about the definition of the social conflict. So we have law number 7/2012 concerning handling on social conflict. According to this law, social conflict define a conflict when there is an enmity and or cycle clashes with violence between two or more community groups that last for a certain time and have a broad impact, resulting in insecurity and social disintegration, of which disrupt national stability and hinder national development. So there are two issues concerning this definition. First is that to the social integration that which disrupt national stability. So the term national stability is a keyword to see this is a social conflict or not, and also hinder national development. From that law number 7/2012, there are 5 aspects that may contribute to the social conflict. This is in the area of political issue, economy and social cultural, interreligious or interreligious enmity, racial and interethnic, dispute over villages, regency or municipal boundaries, and or the province, natural resource dispute between community and or between the community and business actor, and then unequal distribution of natural resources in society. Our research on this issue actually on the role of the Constitutional Court to prevent or reduce, of course not to handling social conflict. So therefore we use conceptual definition from Garavito concerning the role of the Constitutional Court. The role of the Constitutional Court can be defined into two aspects, direct and indirect role. Garavito, Cesar Rodriguez Garavito, define indirect effect of the court decision may include all kind of consequence. This is alarm to end this meeting, I think, yeah? Okay, oh, still time, okay? Oh. The indirect effect of the court decision may include all kind of consequences affecting not only the parties to the case, but also other social actors. But various direct material effect may be through formulation of a policy ordered by the court. From this conceptual approach from Garavito, we would like to show you some cases concerning the issue on social conflict. First is issue on the political issue, which is mostly we find it from two jurisdiction of Mahkamah Konstitusi or Constitutional Court of Indonesia. First is jurisdiction on judicial review, and the second is jurisdiction on election dispute resolution. In the political issue, here I would like to show you in our view as an authors and co-authors is a landmark decision. This is the decision concerning the use of citizen ID, family card, also passport as evidence for having right to vote, even citizen not listed or registered in the list of voter made by Election Commission. This decision is not only upholding political rights, but also prevent conflict between public and Election Commission, as well as preserving dignity of general election. Then in the issue of economic and social culture, we put two decisions of the Constitutional Court, but I would like to explain only one, but those two concerning marriage law. In the decision number 46, the court decided that Article 43, paragraph 1, on marriage law was unconstitutional. Judicial review filed to overturn the 1974 marriage law that stipulated that only mothers and their immediate family have responsibility for children born out of wedlock. The court set a new standard in its decision for the civil right of children's status if born to an unmarried couple. The court decided that the child has a legal relation with the biological father as long as there is scientific and technological evidence. One may think that this decision is about individual rights, child rights, but this decision contributes to reduce family conflict, which may have external impact on the society and provoke social conflict within community. Another decision, maybe this is one of very interesting decision, I think, and I categorize it as a landmark decision, is the court decision numbers 97, concerning judicial review on law on population administration. The law had required that followers of religion other than the major faith leave the line for religion blank on their national ID card. So everyone, for foreigners here, I bring my ID card. The data in ID card is not only name, date and birth, but also religion. If you are not the follower of the main religion, then you have to put it blank. Finally, that the court decide that now, after this decision, the word belief should be included in the religion column, in the identity card and the family card. This is new standard set by the court with the decision that the court has the tendency to reduce the possibility of discrimination. At this context, the court would like to hinder the social conflict that may arise from discrimination, the belief followers. Next issue, in the context of unity and integration, is concerning Papua. The case is about exception, or one may say peculiarity of mechanism to sit representative body for province in Papua. In general, that everyone who sits in representative body must be elected in general election. But except for representative body in Papua, this is not by election, but appointed for a local representative body. That the cause, the court decision that I may explain, but not all. Then, what is then the challenge the court in conflict resolution role? First is, of course, then judicial activism and judicial populism. In the context of social conflict, I think judicial populism is one interesting issue, because in my view that it is dangerous for the court if judges fall into the trap of the perception or perception of the masses or certain group in making a decision. And the court decision which decided on both conditionally constitutional and conditional unconstitutional reflect that there is still hesitancy in the decision. So everyone here that in Indonesia, we have kind of decision that not fully annulled, but conditionally constitutional and unconditionally constitutional. In our view, that this kind of decision reflect that there is still hesitancy in the decision. Other than that, the tendency of cases which were filed over and over again also imply that there is still skepticism against the court decision. So as I mentioned before, when Dr. Rosa gave comment to the bold paper, the law of parliamentary is already reviewed 10 times by the court. So many other law frequently also reviewed by the court. From this challenge to the court in conflict resolution, then the key answer is, let's say, only one, that judiciary should maintain judicial independence in diverse society. Because that maintaining judicial independence is also part of what the court is promoting as social diversity in multiculturalism. Here we only provide one of consideration that it need further research. The composition of the judges in constitutional court reflect the diversity of the judge origin, race, ethnicity, religion. Of course, this is still debatable concerning the way of selection of constitutional justice. Yeah? But at least you may find some study by some scholar that researching on the background of the judges and the influence to the decision of the judges. So this is maybe one of the efforts to reduce potential risks of social conflict caused by the court decision. As a conclusion, indirect role of constitutional court is contribute in minimizing, eliminate the potential aspect of social conflict, also reducing tension caused by the social conflict in the diverse society of Indonesia. By the court decision, the court may come forth as the institution providing conflict resolution and bring justice for society. Second, that the court role in conflict resolution may face challenges. The court in deciding the cases may even make social conflict worse. While on the one hand, the court decides according to what should be decided, the decision of the court may be trigger for social conflict in the diverse society. In this context, once again, the court has to avoid any self-interest and maintain independency. And now independency under attack, I think. In deciding case, judges must reflect the belief of society. Even these are not his or her own belief, because the values of the Constitution may express in the judge's decision as they are understood by the culture and tradition of the populace in its progress through history. So what judges say is actually expression of the Constitution. That's all my presentation. Thank you.
Thank you, Pak Adrian. Pak Radian. Now I would like to invite Ibu Andriani first. Yeah, now is Constitutional Court first. Please.
Thank you, Chair, for the opportunity. This is an enlightening paper, and I'm particularly honored to have been given the opportunity to enjoy the presentation and right to respond to Dr. Rosa Ristawati and Dr. Radian Salman papers with the title of the role of the Indonesian Constitutional Court to prevent social conflict in the diverse society. First, I do appreciate Dr. Rosa and Dr. Radian enlightening describe that the Constitutional Court has a crucial role in suppressing very complex social and political conflict. So it is hoped that it can prevent the disintegration of society. In this regard, this paper also comprehensively at least describe 11 decisions of the Constitutional Court in Republic Indonesia in reviewing laws that interpreted that constitutionally the norms in the various law and show the Constitutional Court Republic of Indonesia may have an indirect role to contribute in minimizing, eliminate the potential aspect of social conflict, also reducing tension caused by the social conflict in the diverse society of Indonesia. By the court's decisions, the courts may come forth as institution providing conflict resolution and bring about justice for society. Second, furthermore, according to this paper states that safeguarding of democratic principle by the Constitutional Court to contribute to a peaceful relation between majority and opposition and a peaceful transition of government following elections by ensuring the regularity of the electoral process and the state actual respect the Constitution and the Constitutional Court can also contribute to the reinforcement of the legitimacy of the representative of the citizens and of their acts and make them acceptable even those who oppose the act. And the third, with the contradiction in this paper also state that, however, the role of court may face challenging. The court in deciding the case may even make social conflict worse. While on the one hand, the court decide according to the should be decide in the decisions of the courts may be trigger of for social and political conflict in the diverse society, and in the context, and the court has to avoid any self-interest and maintain its independency. If allowed, I would like to know how do attacks by politicians and the media as society, especially states controlled by media, create an atmosphere in which judges feel threatened in their ability to act independently or in a way that may bring about political threats and attacks. I think that's all, and thank you very much.
Thank you very much, Bu Andriani. I would like to invite Dr. Mova, please.
Thank you, Mr. Chairman. I think the authors have done a great job at categorizing the court's role in conflict prevention and resolution, as well as in mapping landmark cases relating to that. Indonesia has around 1,340 ethnic groups and 700 languages, according to some sources. Hence, the management of diversity is inevitable. While diversity is an asset, it can also contribute to conflict as people have different values, beliefs, customs, and way of lives. The paper has addressed the court decision regarding religion column in the ID cards, and it is indeed a landmark case. However, I believe that the court's decisions regarding blasphemy is also an important conflict management tool. Religious conflict or conflict over religious interpretation frequently erupts in Indonesia, as evidenced by one of the regional elections in one of the cities in Indonesia. And the blasphemy law is often used by state apparatus to mitigate this conflict. I think it would be good for the paper to address if whether the blasphemy law is indeed a proper way to manage such religious conflict. Finally, I have some questions or perhaps requests for clarifications. The first is regarding your stance on judicial activism, if it is for the benefit of conflict prevention or resolution. So what is your stance? Do you support that or not? Secondly, you also mentioned about the court decision on presidential threshold. So perhaps you could clarify your stance whether this would trigger conflict or on the other hand, avoid conflict, prevent conflict. And then you also state, and I quote, "In this context, the Constitution may provide an anticipation of ethnicity, race, and religious issue in the process of the appointment of judges." I think someone from Canada, if I'm not mistaken, also raised this issue in the morning. So my question is, do you actually advocate some kind of affirmative action on the selection of judges? If indeed that is the case, there are some criticism regarding to affirmative action, because the criticism is when we dissect identity, there seems to be no limit in which a particular identity can be defined. I mean, we can dissect it based on religion, but then what religious sect, and then within the sect there is different kinds of interpretation or different kinds of mazhab or whatever. Or is it based on race and ethnicity or gender? There are different kinds of gender if you look at that based on gender. So belief and social stratum, geography and ideology or what. So the question is, if that is the case, who should represent what and how? Thank you.
Thank you, Dr. Mova. Now I would like to invite the floors. Yes, you first, Pak Andi Omara. Okay, if not, then we keep two participants, please.
Okay, thank you to Chairman Mas Lambang and Bapak Radian. Pak Radian Salaman, thank you for interest for presentation. I have a question for your paper. How the court play a role in diverse society? That is the main question of this session. However, I want more elaboration in this conference. We heard ideas on the debate on how the court maintaining its supremacy. Problem arise when the court facing unpopulist case that hated by politician and majority of population. I agree with the second respondent, Bapak Muhammad Mova. The blasphemy law case is the landmark of this case. The ruling of the Mahkamah Konstitusi in that case for me is ambiguous. By testing the court at the margin, what do you have in mind about it? Because sometimes, as shown in blasphemy case, social order does not always in line with human rights values, with which one should be sacrificed and how far. Thank you.
Okay, Pak Andi Umara, please.
Yeah. Thank you very much, Mr. Chairman. Mas Radian, I have questions regarding the recruitment that you propose. Regarding that, in my opinion, you try to accommodate the diversity, right? So the recruitment process should consider many different background, etc. My question is, would you think that it's going to be like bringing the conflict not to the social level, but to the court itself within? Or the second one, how then the individual judge will maintain their independence if they just like the representative of one or other group? That's my two questions. Thank you.
Yeah, thank you. I think the word independency spoke in several times in the last sessions. Please, Pak Radian Salman.
Okay, thank you. My appreciation to Ms. Andri and also Pak Mofa PSC for addressing some issue that very insightful and valuable for us to further develop our paper. First, about our standing on judicial review. I just want to answer this through the case on, as I mentioned before, wait, I will open the case. Case concerning column of religion and belief in the ID card. Yeah, I believe this one is a judicial activism decision. Why? Because this issue is a very long issue and sensitive issue in Indonesia. So if you see the composition of the judges, in this case, of course, they are Muslim. And we are in Indonesia, or law in Indonesia actually recognize only 6 main religion. There is no recognition formally by law about the beliefs of let's say, a traditional belief. Here is our standing on judicial activism is that it is needed, judicial review is needed on the basis that this is obstructing or violence the really are actual violence to the human rights. So that's case. So if you see once again from the composition of the judges, and this is a sensitive issue in Indonesia, finally then a court decide that you have to put and recognize the column of belief in ID card. Even if you may heard about this case that Majelis Ulama Indonesia also protest to this decision of the court. So they offer proposal to make a different ID for people who has belief and people who has a religion. Yeah. The proposal for composition of the judges actually my point to come into the reformation of selection of the judges in this context today. As already mentioned by Dr. Rosa before in comment to Zbold, that we have 3 judges from government, 3 judges from Supreme Court, and 3 judges of a House of Representatives. Those three holder or sender of the judges for Constitutional Court, no standard for them. So in DPR, for example, or in the Parliament, for example, then Parliament maybe just nominate someone and then do something what we call as fit and proper test, then finish. But this is different with the process in the president. Yeah? However, I don't want to propose a very detailed criteria for that kind of composition, but at least that in the process or requirement of the selection of justice of Constitutional Court, there will be a normative clause concerning considering, once again, considering gender, maybe considering the plurality of the ethnic and etc. Then thank you for comment from my colleagues from Jember and also Pak Mofa concerning blasphemy law. Yeah? This is, we know about this, but we decided not to put it into this paper, but your suggestion we will consider that. And I think we will consult and discuss with Professor Ali Safaat as an expert on religion and state relation, I think. Yeah, your last paper on ISIS-4, I think I read about that. Yeah, Pak Andi, yeah, I'm not going to put the problem in the court, but the key point is not the composition actually, but then how impartial judges when they are ruling the case. This is the key, I think, for me, and impartiality is, yes, of course, I believe that impartiality influenced by the background of the judges, gender also, the experience or activity of the judges. I believe that it enrich the decision of the judges. However, maybe my colleague, Dr. Rosa, want to add something, please.
Yes, please.
Yeah, thank you. No, I just want to add something as a response to Pak Andi. So our idea for the composition of the judges actually coming from the fact that actually the composition of judges is kind of like a political dealing. So at this point, I think this is one of the how do you say, one of the alternatives that we can propose. But other than that, there might be something related to that. The minority also has to be represented in composition of the judges. So I think we will elaborate this kind of recommendation. But for now, maybe this is that we think that it fit to anticipate the social conflict for the decision of the court. Thank you.
That's all? Okay, so I think it's the end of this session, and of course it is uneasy actually to connect directly to previous presentations, so I'm not going to make conclusions. However, given the context of criticism on Constitutional Court and its decisions, our last presentation, it seems like reflecting a hope, yeah, or sunshine in looking at the role of Constitutional Court in Indonesia, at least dealing with the social conflicts. So thank you very much, Pak Radian Salman, and also respondents, Ibu Adriani, and also Dr. Mova. Now, yeah, applause for them, and back to the Master of Ceremony. Thank you.
Thank you so much, distinguished chair, speakers, and respondents. Also, all participants who have raised questions to the speakers. Ladies and gentlemen, that's the end of today's sessions of the 5th Indonesian Constitutional Court International Symposium, the 5th ICCIS. Now we have come to the very end of this event, which is the official closing. Then we will hear a closing remarks that will be delivered by the Honorable Justice of the Constitutional Court of the Republic of Indonesia. Kindly, we invite His Excellency Dr. Daniel Yusmik Foe to deliver the closing remark.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, may peace be upon us. Om Swastiastu, Namo Buddhaya, salam kebajikan. The Honorable Chief Justice of the Constitutional Court of the Republic of Indonesia, the Honorable Justices of the Constitutional Court of the Republic of Indonesia, distinguished speakers and participants of the International Symposium, ladies and gentlemen, let us offer praise the gratitude to the Almighty God who has bestowed upon us His blessing so that we can attend the closing session of the 5th Indonesia Constitutional Court International Symposium this afternoon. Distinguished speakers and participants, during these 2 days, we have discussed the very interesting themes of constitutional court and conflict resolution. We have heard from many academics and practitioners. Acting speakers have presented various ideas and concepts which have been discussed by the respondents and participants by providing comments, feedbacks, and critical questions. These discussions were very useful. They examined the role of the judiciary, both Constitutional Court and Supreme Court, in resolving social and political conflict and human rights violations. In various countries, such as I'm sorry. These discussions were very useful. They examined the role of the judiciary, both the Constitutional Court and Supreme Court, in resolving social and political conflict and human rights violations in various countries, such as Turkey, Australia, Canada, United States, Hungary, Slovakia, Scotland, South Korea, the Netherlands, India, Brunei Darussalam, and of course, Indonesia. The speakers have presented many views. Professor Engin Yildirim from Turkey conveyed the attitude of the Turkish Constitutional Court during the constitutional state of emergencies, while Professor Miriam Cohen and Dr. Sarah Michelle Vincent Wright spoke of conflict resolution issues in human rights cases handled by the Canadian Supreme Court. Even one of our neighbor country, Brunei Darussalam, was discussed. Professor Ann Black looked at the possibility of having a constitutional court in Brunei. We also learned from the experiences of the Constitutional Court of South Korea. Professor Hu Yang Ri explained how this institution helped to protect citizens' rights through constitutional complaint. Likewise, the handling of conflict of interest in the Hungarian and Slovak Constitutional Court conveyed by Dr. Max Theor opened us our eyes. We also learned from the many other speakers, too numerous for me to list now. This symposium is not intended to provide solutions to all challenges related to constitutional court and conflict resolution. More time is needed to discuss specific issues in greater detail. Nevertheless, this symposium has opened a discourse in issues that perhaps receive less attention in comparative studies of constitutional law. But what is certain through this symposium, I, or maybe all of us, agree with what was conveyed by Professor Roy Andrew Partin, that a constitutional court has more power to resolve conflict that arise from various legal rules and cultures. Constitutional judges have a big role to play in ensuring that conflict over fragmented rights can be mended and basic human rights can be protected. Distinguished speakers and participants, the Indonesia Constitutional Court collaborates with universities throughout Indonesia to raise awareness of the Constitution and the constitutional discord decision. It also collaborates with universities abroad. For example, with Den Haag University and Maastricht University in the Netherlands, the University of Leipzig and the University of Erfurt in Germany, Curtin University and Newcastle University in Australia, Malaysia International Islamic University, as well as several research institutions such as the Max Planck Foundation for International Peace and the Rule of Law. The question is, why does the Indonesia Constitutional Court establish this international collaboration? Because we believe that investing in human resources will make the Indonesia Constitutional Court better, both in case management and decision-making processes. We also encourage our employees to uphold academic values, which can provide substantive support to constitutional justices. To improve academic cooperation, the Constitutional Court is very open to cooperation with universities and research institutions to which the speaker and participant of this symposium are affiliated. In maintaining the academic atmosphere at the Constitutional Court, we also manage an international constitutional scientific journal. The journal is called Constitutional Review. It was recently indexed by Scopus. Thus, the Constitutional Court is the only judicial and state institution in Indonesia with a legal journal indexed by Scopus. On this occasion, allow me to invite all of you to submit your manuscript to the Constitutional Review so that your opinion and ideas can be read by constitutional justices and international scholars. I would also like to invite you to continue to support the role of the Constitutional Court and similar institutions in resolving social and political conflict and human rights violation. In closing, I would like to thank everyone to make this symposium a success. Hopefully, this global academic forum can inspire more discussions. Likewise, I hope you all can enjoy the beauty and hospitality in Bali. Once again, thank you all for your attention. Wassalamualaikum warahmatullahi wabarakatuh. May peace be upon us. Om Santi, 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 Om. Thank you.
Thank you so much, His Excellency Dr. Daniel Yusmik for the closing remarks. Distinguished speakers, chairs, respondents, the Honorable Head of Center for Research and Case Analysis and Library Management, Mrs. Kurniasih Pantirahayu, the Head of Constitutional Review, Editor-in-Chief of Constitutional Review, Pan Muhammad Faiz, PhD, by the closing remark that has been just delivered, then that's the end of the 5th Indonesian Constitutional Court International Symposium. Well, every ending is a new beginning. Therefore, may the end of the 5th ICCIS is a new journey of academic friendship that will bring bright perspective and new knowledge for all of us who attend here. After the closing and the end of these sessions, we will have the last time of photo sessions. That's why we will respectfully invite His Excellency Dr. Daniel Yusmik Foe to go to visit a front stage to have photo sessions with all speakers and also respondents and chairs and all committee. But there will be 3 sessions to take the photo sessions. May I have assistance from all committee to please His Excellency Dr. Daniel Yusmik to go to the photo stage. The first sessions of photo sessions will be followed by His Excellency Dr. Daniel Yusmik and all speakers that attend this conference room. Would you please? And then Mrs. Kurniasih Pantirahayu and Mr. Pan Muhammad Faiz, PhD. For the respondents, please remain seated. We will have the photo sessions in the next sessions, or session 2. And I would also kindly invite all chairs that are still in this room, Ibu Diana Puspitawati, PhD, Bapak Herlambang, and then all chairs, speakers with His Excellency Dr. Daniel Yusmik and Bapak Igede Palguna, thank you for being present. Okay, Ibu Diana Puspitawati, hold on. Respondents, be prepared for the next photo session. Okay, let's just count from 3, 2, 1. Would everybody please open the mask for 2 minutes? The speakers on the 3rd lines, would you please just come here in the front because your face is covered. Pak Andi Omara, and then Mrs. Sarah, and then Dr. Rosa, would you please come here on the 1st line, 2nd line? Hang on, let's check that everybody is captured well. Okay, we're gonna take a footage. Could you please wave your hand because it's the 5th ICCIS. Wave your hand, smile. Okay. Thank you so much. Please remain there. Kindly invite the respondent to join the photo session. Okay, so let's wait for the instruction for us from the photographers and videographer. Okay, could you please take off your mask for 1 or 2 minutes, please? It's okay, no worries. Everybody has been vaccinated. Can you please just, oh, okay. Me? Kemana? Ke tengah ya? Saya ke tengah. Tengah kemana? Kayak anaknya Mas Jason. Okay, how is it? Well, I'm so sorry for the longer time to take photograph, as we know that a photograph keeps a moment from running away. So it's gonna be, and it's gonna keep the memory of this event. How is it? Okay. Okay, can you count from 3? Okay. Charlie, maybe you can come to the front line. It's okay. Be with us. Okay. How is it? Everybody is captured? Okay, let me move. Sorry. Let's count. 1, 2. Okay, and then let's just wave our hands. 5th ICCIS. Wave our hands. We're gonna take a footage. Thank you so much. The last photo session with all committees of 5th ICCIS. Let's join us. Without them, we wouldn't have this great event. Count. Okay, everybody please put your mask off only for 5 minutes. I'm sorry, I said 1 minute. Actually, it's 5 minutes. Count from 3, 2. Wave our hands. Okay, wave our hands. Okay. Hold on a second. I apologize. There will be one more photo session outdoor or outside this meeting room. Just keep your belongings here in this room. We're gonna have a photo session in front of this meeting room, in front of the Hall of Fame. Yeah. Just follow the committee. Let's have the last photo sessions of today's event. Okay, just leave your belonging. I need you. I need all of you for 3 minutes. Let's have the last photo session. Would you please, His Excellency Dr. Daniel Yusmik, the Honorable Bapak Igede Dewa Palguna, all chairs and all speakers and also respondents, can I have your 3 more minutes to have the last photo session? It's okay. After these last photo sessions, I believe you can leave this room as soon as possible. Okay. Can we have 2 minutes of photo session, yeah? There will be one more announcement after that, before leaving. Thank you.